All right, good morning, everyone. Good morning. I'd like to call to order the Judiciary public hearing for Wednesday, January 22nd, 2005. This is our first public hearing and first committee meeting of the year. So I'd like to start by introducing the new House Vice Chairman of the committee, Representative Fazzino, to read the emergency instructions. Representative Fazzino.
Thank you, Mr. Chair. Good morning, everybody. See a lot of people out in the audience, so in the interest of safety, I would ask that you note the location of and access to the two exits in this hearing room right behind you. The two doors through which you enter the room are the emergency exits and marked with exit signs. In the event of an emergency, please walk quickly to the nearest exit. After exiting the room, go to your right and proceed down the main stairs or follow the exit signs to one of the fire stairs. Please quickly exit the building and follow any instructions from Capitol Police. Do not delay and do not return unless and until you are advised that it is safe to do so. In the event of a lockdown announcement, please remain in the hearing room and stay away from the exit doors until an all clear announcement is heard. Thank you.
I always thought it should say in the unlikely event of a lockdown like when you're on the airplane and I say water landing is unlikely, you're like, I certainly hope so. Anyway, all right. As I said, this is our first public hearing of the year. I'd like to welcome the new faces to the room. We have several. The way this is going to proceed today is we have a list of nominees. The nominees will be invited up one at a time. We will swear you in individually. You'll have an opportunity to offer a brief opening statement. Followed by the opening statement, members of the committee will be offered the opportunity to ask questions. We do have 40 members on this committee, so I would ask the committee members, in the interest of consideration of their fellow members, try to keep your questions brief, try to get to the point. Please do not re-ask questions that have already been asked. I understand people are in and out of the room, but we don't need repetitious questions. Also, we are not prohibiting folks from participating virtually, but certainly it is our hope that members of this committee, as the session progresses, will take the time to join us in person, particularly if you plan on asking extended questioning of witnesses, etc. We hope that you will join us in person as much as you can. Any remarks from my co-chair?
No, good morning. I'm going to save those for later.
Any remarks from the ranking members? All right, well, welcome back, everybody. And we will start with the Honorable Raheem Mullins to be Chief Justice of the Connecticut Supreme Court. Justice Mullins, Chief Justice Mullins, great to see you. If you could raise your right hand for me. Do solemnly swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury. Great. Have a seat. Turn the microphone on for me, please. And whenever you're ready.
Okay, thank you. Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. It is a privilege to appear before you today. Thank you for approving my nomination to serve as Chief Justice on an interim basis back in September. I would also like to thank Governor Ned Lamont for his continued confidence in me. Should you choose to approve my nomination to serve for a full 8-year term, I will do my best each day to meet the expectations of the residents of this state for a fair, efficient, and effective court system. Since I last appeared before you in September, among other things, I've been working hard to upgrade the judicial branch's technology to better serve all of its stakeholders. Improving our technology remains a top priority of mine, and I would like to take a moment to update you on some of the new developments currently underway. First, I'm happy to report that we're moving forward with getting Wi-Fi in the public areas of our courthouses. We're beginning with 3 pilot locations at 400 Grand Street in Waterbury, 101 Lafayette Street in Hartford, and 235 Church Street in New Haven. In Waterbury, all the necessary wiring and access points for the public areas has been installed and the technical infrastructure has been completed. We're currently working on the policies for public access, the process for guest portal registration by the public, and disclaimers. Once those items are completed, Wi-Fi in the Waterbury Courthouse will be activated for the public. This is a very good start, but I recognize that we have a lot more work to do. Second, you might also recall me noting last September that my long-term goal is to have at least one courtroom in every judicial district outfitted with state-of-the-art digital equipment. I'm very pleased to report that we're moving forward with this initiative with 2 pilot locations, one in the Hartford Judicial District at 95 Washington Street and the other at 101 Lafayette Street. At the Washington Street Courthouse, the cabling installation is scheduled for this month. It is almost all completed, and the judicial branch has purchased and received almost all of the other necessary equipment. I just got an update this morning that we have the monitors in the jury box and at counsel table, and we're just waiting for the center console to be able to control all the digital evidence. The goal is for that courtroom to be up and running by the end of this month. As for the Lafayette Street Courthouse, we're in the preliminary discussions with the Office of the Hartford State's Attorney to collaborate with them and possibly use some of their funds that they've gotten granted to create a digital courtroom for criminal trials in Hartford. Clearly, this is a long-term initiative and it will take time and frankly more money. But I can assure you, we are committed to doing everything we can to make digital courtrooms a reality in Connecticut state courts. Before I close, I want to mention something else I've observed as Chief Justice over the last 3 months. In this new position, I've had the opportunity to be involved in administrative decisions and to see how things come together behind the scenes. I have been amazed at the immense talent and dedication of our judicial branch employees. I'll give you just one example. Last month, several of our buildings here in Hartford lost power due to an underground electrical issue that impacted the Supreme Court, the Appellate Court, and several Superior Court buildings. We became aware of this power outage at 4 a.m. The Supreme Court had 2 arguments scheduled that day, and of course, there were many hearings scheduled in the Superior Courts on Washington Street and Lafayette. Because of the ingenuity and dedication of the judges and especially the staff, we were able to move the Supreme Court hearings to the Appellate Court for the day, and we were also able to have Superior Court cases moved to different locations, which required us to only have to reschedule a few matters. I witnessed firsthand how our employees mobilized to make this solution a reality, and all of this was done before 9 a.m. so that a plan could be in place before people showed up for their court hearings. It truly was amazing, and I realized that if given the resources, there's almost nothing the judicial branch employees can't accomplish. Thank you again for the opportunity to address you, and I'm happy to answer any questions you may have.
Thank you, Senator Kissel.
Thank you very much, Chairman Staffstrom. Chief Justice, it's great to see you again. And again, congratulations on your appointment as our Chief Justice of the State Judicial Branch. Just a couple quick questions, because I know a lot of folks probably have questions as well. First of all, I saw you speaking on CTN. I think it was I probably have the name wrong, but the Compensation Commission or something like that. You were opining on what judges get paid. And you pointed out the fact that many judges have to bring work home, that with I believe they have to produce decisions within 120 days, that they have busy courts that they have to work in during the day. And so when you add it all together, it's almost an impossible workload to handle in the regular 9 to 5 hours. And so with that, you stated to the panel that you thought that a raise would be appropriate. I disagree. I'm just going to say that on the record right now. So probably every judge in the state of Connecticut is not happy with that response that I have. But my concern is this. I think that if you have a job, you should be able to do everything that's required in that job in the hours that have been allotted to you. That personal time should be personal time. People have families, people have outside endeavors, In fact, one of the things that we really encourage is for the judges who have typically been exemplary in community service and outside activities prior to getting nominated to the bench, continue along those lines. And there's only so much time in a day. So I think that this solution, rather than just increasing salaries and keeping the workload still overburdening, is to increase the number of judges. And I'm just wondering, when I put it that way, do you have any firm positions one way or the other?
I definitely have a firm position that judges should get raises. But I don't think that was the only reason that I put forth for judges getting raises. I think there's cost of living increase that all employees, or typically all employees, get. So it wasn't just tied to judges' workload. I don't disagree with you in the main that finding a work-life balance is important. I think my response or my reaction to some of what you're saying is just being a judge is difficult. And what I was trying to convey to the Compensation Commission is not give us a raise because being a judge is difficult. It's part of the mix. But the cases that judges deal with are very difficult to just look at as being able to take care of in the 9 to 5 hours. They weigh on you. They're people's lives. They're things that sometimes make it difficult to put your feet up on a Saturday when you got people waiting for a decision to their case. So it's a tension, it's a difficulty. We know what it is when we take the job. My position was just expressing that to the Compensation Commission to give them some context on what it's like to be a judge. It's very difficult to think about it in terms of 9 to 5. We got to do better. We offer wellness trainings for judges, but that was the context of which I was saying this is what it's like to be a judge. And there are a host of other reasons why I thought raises would be appropriate. That was a small piece of it.
Well, I'm sympathetic to the fact that Connecticut seems to be bifurcated between the South and the North, and that things are much more expensive as you get closer to New York City and down in Fairfield County. But you know, this economy has really hurt a lot of people up in my neck of the woods. The middle class are really struggling. And when folks have a state job with all the state benefits at around $200,000 a year, it seems pretty good, especially since there's still a long list of people that wish they could have that job. But we'll leave that for another day. My other quick question is this. When you assume the role of Chief Justice, you got the 30,000-foot observation of the entire judicial branch. And I'm just wondering, and I want you to sort of break it into two categories. What do you think is like the most heavy lift that's before you and the branch that may take a number of years? And we had spoken before about renovating the buildings. And by the way, you have some buildings, if they're not on the historic register, they should be. They're works of art. We'll never make them again in this world. And so they should be protected. But I know that trying to turn them into technologically accessible buildings is very difficult, asbestos and things like that. So what is something that might be long-term, that might be expensive? And the other part of that question is, what is the number one exigency right now? What is the thing that is on your stove, that is a pot bubbling over, that, hey, legislature, this is my number one concern. I need X, Y, Z, and you can help me with this.
So if you want me to break them out into two categories, I think in the first category, it would be thinking long-term about our buildings and consolidating where we can. And when we do that, when we build the new buildings, have state-of-the-art facilities. And that would require consolidating some buildings and not using as many buildings as we use now. That's a heavy lift in a long-term project in the first category. In the second category, safety is a concern. And so marshals, making sure our courthouses are secure, that's probably way up at the top of the list of things that I would want to make sure we pay attention to and the legislature could help with.
Thank you very much, Mr. Chief Justice. I appreciate those answers. I know that in the court operations bill, we're going to have a proposal to shift where people go to court in the Avon, Farmington Valley area, moving them from appearing in Hartford to Torrington to utilize facilities there. I know, unfortunately, I worked with Judge Carroll for a number of years, but my courthouse in Enfield, GA 13, unfortunately closed. And so I have seen efforts at efficiency and consolidation have a negative impact, especially on law enforcement when they would transfer arrestees to court. But you can only fight City Hall so long. As far as what you had stated in your opening statement, I remember one time when I was starting, there was a courthouse in the Windsor Town Hall, and we had a power outage. And actually, the judge decided to carry on that afternoon with the emergency power lights, and it was rather surreal because people could barely see one another. But the business of the branch continued to march on, and everybody had their cases heard. So it is possible, and I applaud everybody who rose to the occasion when you lost power here in Hartford. Thank you for your candor. And again, I wish you congratulations. And I applaud Governor Lamont for nominating you to be our Chief Justice. Thank you, Mr. Chair.
Thank you.
Representative Fishman.
Thank you, Mr. Chairman. Good morning, Chief Justice.
Morning.
I don't know. Well, first of all, I want to thank you on the Wi-Fi situation. As the courts have shifted over, we have this whole uploading exhibits now, right? And I was in court a few weeks ago and was able to upload an exhibit right there in the courtroom. It was very helpful for the court. So expansion is very important there. I don't know if you had an opportunity to review the written testimony that was submitted. You obviously have a fan. There's a very lengthy, you'd almost call it a love note in support of your nomination. I appreciate the communication since you've been Chief Justice. I see good things. The last thing I want to ask you about, something I learned through your questionnaire, is the experiential program that you're advocating. I had never heard of it. Where individual high school students, college students, law students can actually apply to be interns in the judicial branch. And when did that start?
Ooh. That I don't know for sure, like the start date.
Okay, because I think it's funneled through the Department of Labor, and it's certainly an opportunity for people to see what it's like to work in the courts. And I'm sure through the system, it's enhanced the amount of employees that you've had. Certainly don't want to hire somebody that learn what it's like working in the court after they get hired. Yeah. Right. So, well, I thank you because evidently you're out there talking and heralding that program. Really no questions. I just congratulations on your renomination and you continuing on as Chief Justice. Thank you. Thank you, Mr. Chairman.
Thank you.
Rep. O'Day.
Thank you, Mr. Chair. Chief Justice, good to see you.
You too.
Congratulations on your nomination. Just a few. I know we had spoken offline privately about some improvements, and someone who practiced mostly in Stamford, but throughout the state. I'm curious what the timeline is in the Wi-Fi. I will tell you, in order to get service in Stamford, you have to walk to the windows to try and get Wi-Fi service. So just can you give us a timeline on what you're seeing as far as the test cases in, I believe you said Hartford, New Haven, and where was the other?
Waterbury.
When that will be done, and then when you're expanding it, ideally to Stamford at some point.
So Waterbury will be very, very soon. A lot of the cabling is already done. We're just working on the licensing and how it's going to be communicated to the public that Wi-Fi is available. New Haven will be after that. We are probably going to need some more funds to expand beyond those two, but we were trying to do what we could with what we had to get started. So in terms of a time frame for Stamford, please don't hold me to it, but I could see within a year, depending on funding we can get, and some of it will be bonding funds, but others, we're going to need people and that's not bonding.
And we've spoken, I've got a big concern. I don't practice in family law, for multiple reasons, but there's a huge problem, particularly in Stanford, in the family court system. And I'm wondering, I've got some people I know that have been waiting for a long time. It's over a year. They have to wait to get a modification on an order. And in civil court, I can call and get a status conference within 2 weeks at the longest. Why does it take so long in family court to get a hearing date? And what are your plans on improving that going forward?
Well, in Stanford, you're talking about, Stanford is a particularly tricky jurisdiction for family. I don't know that the rest of family courts operate exactly the same way. But I can tell you it's an issue I'm aware of, and we are currently trying to address how to move the business better in Stanford. In terms of that particular case, I might need to know more particulars, but there's often specifics in a given case that could make it go longer than it should. But that's not to say we should have cases that go on 12 months without a hearing if you need a hearing. I'm always interested in hearing about those and looking into them specifically to see what happened. So bring them to my attention, bring them to the chief courts administrator's attention, and we'll take care of it.
Thank you. And I don't see any reason why somebody shouldn't be able to get a hearing within a month, let alone 6 months or a year. So I appreciate that. And, we've had a couple judges, the last couple at least, that didn't get through because of, some family court experiences. Have you addressed that, maybe some training, or how would you address either the training or somehow helping judges dealing with pro se litigants, if at all?
Yeah, we do offer training, and the chief administrative judge for family is great and meets with the judges. Family is a particularly difficult assignment. And I'm not sure exactly who you're referring to, but sometimes when emotions get high, family just kind of is explosive sometimes and takes on a life of its own. I think the judges we have working in family are doing a good job, and I think there is training, and I think we meet with them and tell them, you have to do your best to remain calm under very, very difficult scenarios. And as long as judges do that, I don't see a problem getting through or having a problem when they come here to testify, as long as they stick to the case and stick to the facts, and not let their emotions get away. Don't let your emotions get away with you in those difficult cases. I don't see them having a problem when they come here.
Thank you very much, Chief Justice, and appreciate your responses, and good luck going forward. Got a lot to do.
Yeah.
Thank you. Thank you, Mr. Chair.
Senator Wilcox.
Good morning, Chief Justice Mullins. Sorry, I lost my voice, so
Good
I
morning.
apologize for that. This is really a comment. I just wanted to thank you. I appreciate, as a constitutional scholar, I appreciate your approach in your answers and in your judicial philosophy to balancing, individual rights and the social needs, and thinking about the context of separation of powers and the relationship between the judiciary and the legislature. And I particularly appreciate your testimony today, thinking about process, technology, infrastructure, and as we're coming off of, it makes me think of, we're coming off of Martin Luther King Day and the March on Washington. We're always focused on the speech and how important it is. But, I'm thinking about who organized those buses, who put the speakers in place, and thinking about people like Bayard Rustin and all the women that helped organize that. And I love that you're doing both, and that you're here thinking about how do we better improve the efficiency and the infrastructure and the technology. So I wanted just a note of appreciation and good luck with everything.
Thank you.
Further questions or comments from the committee? Representative Blumenthal.
Thank you, Mr. Chair, and very good to see you, Mr. Justice. And I want to say I also appreciate all your answers before the committee today, as well as all of your work in the various roles you've had in our judicial system and as a lawyer. The right to jury trial is, in my view, a fundamental part of our constitutional system, both our state constitutional system and our federal constitutional system, and an important guarantor of justice for individuals and others. And I was wondering if you could talk briefly about how you conceive of the jury trial and the role of the jury within our system.
I think it's vitally important to our system. I don't know how to say it any plainer than that. The role of the jury is important. It's a jury of your peers. Connected to that, I think service on a jury is vitally important. If you ask anyone who knows me, the first thing people ask me when they meet me is, you're a judge. Can you get me out of jury duty? And the response is usually not what they expect, because I think it's next to voting, one of the most important civic duties you can have. And every jury trial I've had, I've talked to the jury after, and almost no one wants to serve on a jury before they do it. But after they do it, they feel like it's one of the best experiences they've had in their life. And it's important. We need the jury. Our system needs people to serve on juries. So if you ask me, I think it's vitally important, and service on a jury is vitally important.
Thank you for your answer. I appreciate it. I have to say, recently I was summoned for jury service, and I was actually excited at the prospect. And then the night before, I was told that I wasn't needed, I was one of the few people on that list who was probably disappointed, although I think there was a very low likelihood of me being selected anyway. But in any event, I agree with you completely. The jury is so important. It brings people from all walks of life. Obviously, lawyers like us, judges like you, have a way of looking at the law, of conceiving of the law, of interpreting the law. But it's so important to have people from all walks of life coming in to help distribute justice, to bring their experience to bear, their life experience to bear, to look at the facts, how they interact with the law, as of course permitted by the law and the judge in the relevant context. And I hope that you and our system in general will continue to preserve that as an important and vital part of our system. Thank you, Mr. Chair.
Further questions or comments from the committee? Chairman Winfield.
Thank you, Mr. Chair. Good morning, Chief Justice Mullins.
Good morning.
First, I want to thank you for doing what you said you would do. You have been more responsive than necessarily would have expected, and proactive in that communications that you've had with us. So that is a really good thing. I just want to say that listening to Repo Day, there are some issues on that subject matter, and a lot of folks want us to do some things. I think there's a conversation that really needs to be happening, a little more long form conversation. And since you are so responsive, I will take you up on that level of interactiveness and begin that conversation. But it is good to see you, and thank you for taking on this job in the manner that you have.
Thank you.
Thank you, Chief Justice. Congratulations on your nomination. I want to echo the comments of Senator Winfield and appreciate the responsiveness you've shown in your brief time. I guess I would just maybe take the opportunity just to encourage you to continue pushing on the initiatives you're pushing on. I know I agree with you, and certainly you have my support on we need less physical buildings and to reinvest in technology upgrades, invest in our judges, and invest in improving the quality of our judging. I guess on that point, I think maybe it's the first point of disagreement up here for the year. I think judges probably do need and deserve a raise, considering what we're seeing elsewhere. But one of the other things that strikes me is, should we be looking at a system where we pay certain judges more than others based on location, right? I mean, to Senator Kissel's point, the cost of living in Stamford is a lot higher than the cost of living in Rockville. Should we be paying a judge in Stamford the same as we pay a judge in Rockville? Certain dockets are more difficult than others. Should we be, here in the legislature, if you serve in a leadership position, there's a slightly higher compensation that comes with serving in a leadership position. Should we be looking at ways to incentivize judges to take on more difficult dockets? Just your thoughts on that sort of more long-term as we look at this issue.
It's a conversation I would be willing to have with you. My gut reaction is sort of apprehensive. I don't know about paying judges more. I would like to believe that our judges can sit in any jurisdiction, and sometimes you're in a jurisdiction that we call a block assignment. So one day you may come in and do family, you might come in and do juvenile, you might handle the criminal docket one day, all in one courthouse. So it's not immediately something that I think I support, to pay certain judges more. How you draw that line would I feel get complicated. Family cases get a lot of attention, certainly get a lot of attention here. But I've done juvenile cases that are extraordinarily complicated, civil cases, criminal cases. I think in every area that we have judges serving, there are difficult cases. So immediately, it's not something I would be in support of, I don't think, but always happy to have a conversation to see if there's common ground.
No, and trust me, don't get me wrong. I'm not pushing it. It just was a thought I kind of had as we're sitting here and we're talking about it, and in terms of incentivizing it, because I get it. I mean, I think we've seen it's no secret that we have trouble finding judges for down in Lower Fairfield County. I mean, if you don't live down there, it's a pain in the neck to get to that courthouse.
Yeah.
And so I think we have seen, certainly in my 20 years of practice, I think we've seen the effect of that. And I think it's harder to get good judges down in that courthouse than it was at one point. I think it's a real concern for those of us who practice in Fairfield County. So
It's a challenge. Stanford is a challenge. But we are aware of it, and if there are ideas, we're certainly willing to consider.
Okay, great. Thank you. Congratulations. And just, for the public who may be watching and sitting there saying, why is this hearing so short for somebody who's going to be the Chief Justice for the next 8 years? Go back and watch the tape. We had a very lengthy hearing about 3 months ago, so we're not going to re-ask the same questions we asked 3 months ago. I guess the only thing I would just neglected to ask is there anything about your background or the answers you gave to the questions from 3 months ago that needs to be updated or refreshed before the committee votes on you again 3 months later?
Background thing. No, not that I can think of.
Great. Thank you very much.
All right, thank
Congratulations.
you.
All right, we will move on to our list of nominees for Superior Court. I'm going to take a slight matter of prerogative, and since we do have the Chief Court Administrator on, I'm going to allow her to go first among our list. So we will first take Judge Bozzuto. Judge Bozzuto, if you could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Great. Have a seat, Judge, and whenever you're ready.
Thank you. So good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, and Representative Fishbein, and other esteemed members of the Judiciary Committee. It's an honor to appear before you today. I would like to thank Governor Lamont for nominating me for an 8-year term as a judge of the Superior Court. For the past 24 years, I've had the honor and privilege of serving as a judge. Since my last appointment, I finished up my term as a Chief Administrative Judge for the Family Division and was asked to be the Deputy Chief Court Administrator a position I held during the COVID years. Since January of 2023, I've served as the Chief Court Administrator. I miss sitting as a trial court judge, but as I've done throughout my career on the bench, when asked to serve in a different or additional capacity, my answer has always been the same: yes. I continue to come to work every day, eager to fulfill my commitment to the branch, to the state of Connecticut, and to the people whom we serve. It's a humbling honor, and I hope you deem me fit and qualified to continue. I'd be happy to answer any questions you may have.
Thank you. Questions to the committee? Senator Kissel.
Thank you very much, Chairman Staffstrom, Chief Court Administrator Bozzuto. It's great to see you as always. I'm just wondering, so that the public can know, and actually to clarify it for me, what you said that you wish you missed your days as a trial court judge. I've often wondered, what are the exactly sort of daily duties of the Chief Court Administrator? I mean, I know you have a staff, and I know that you reach out to the legislature. I think that you have something to do with the assignment of the judges, but on a day-to-day basis, what kind of stuff do you actually have to grapple with?
You know, it's interesting because it varies from day to day. You know, you wake up early, 7 o'clock in the morning, and they say the fire alarm and sprinklers are flooding the Stamford court. And then you put people into motion. I mean, you know, I'm very fortunate to not only have an excellent executive team that's been with the branch for a long time and knows all the ins and outs, but we have an incredible staff as well across the branch. And if you ask any of our new judges, they always say to me how impressed they are with our branch employees and their dedication to service. So, you know, it's hard for me to articulate because every day is different. You know, of course, I assign the judges, but that's once a year. I hear from judges often. We're right now in the process, which I do every January, get out to every single JD to meet with all the judges, to meet with staff. But, you know, one day we're talking about legislation. The next day we're talking about initiatives, always talking about money and where you're going to find it. So it's you know, as opposed to when I was a trial court judge and my responsibilities and duties and obligations were very exacting. As the Chief Court Administrator, it's very, very broad, the responsibilities. You know, as was mentioned, we have 35 courthouses, 30 administrative buildings, 4,000 employees, 5 different unions. I mean, it's a very, very big institution.
It's a broad brush response, so I'm not really as clarified by that answer as I could be, I think, but maybe someday I'll have to do shadow day and just see what you do all day. Because I just think the details are really interesting. And I think that, like when you said, you're dealing with 5 different unions and all these different aspects, I think that's an awful lot. It seems to me that that would be a job that a judge would aspire to, that it would be a cool job. But that's just my thing. Along the lines of what Repo Day said, and I believe Chairman Winfield, you know, over the years, and I've been lucky enough to be on this committee now for 30 years. This is going to be 31. The thing that percolates up, and you know, when I talk to my constituents, they're always amazed because they said, it must be really hard in the criminal system. And I said, yeah, it's difficult. I know that the judges weigh with those decisions when you have someone's incarceration, you know, hanging in the balance, and guilt or innocence and all of that. But I say the thing that bubbles up in this committee, like almost every year, is family court issues. I mean, I've seen wonderful judicial careers come to a crashing destruction because of one bad case that they had in family court. I hear tales that judges will do whatever they can not to take family court matters. And so this is a really big problem, and I think that we need to get our arms around it. I know that Chairman Staffstrom pointed out the problems in Stamford, but what exactly are you doing right now to come to terms with this family court issue?
So Senator Kissel, you know well how long we've been dealing with re-engineering our family court. And we've done a lot over the past decade. You know, we did a survey probably 10 years ago from people who've been through family court, cases are done, to find out what their experience was like. And it was surprising to see that they really didn't complain about the judges. They didn't complain about our staff or our marshals. They didn't even complain about the GALs. What their biggest complaint was how long it took for the process to last and how much time they spent in court. So ever since that day, anything we've done to re-engineer family has 3 goals: reduce time spent in court, reduce conflict, and now I'm lost in what the third one was, and reduce costs. Those three things. So we started out long ago with non-adversarial divorce and waive 90. Before you had to wait at least 90 days before you could get divorced. And we started with those two implementations. They've probably been in effect for 8 years or so. And we saw with that 32% of people of our cases were resolved within 90 days. Before that, 0 were resolved within 90 days. But we also understood that wasn't enough because it's very hard for people to self-identify that, oh, wait, I might qualify for non-adversarial divorce. Oh, wait, I could do a waive 90 and get into court quicker. We have to remember, only 20% of the cases in family court have 2 lawyers. Most of the population that comes to family court are representing themselves, which adds another level of complexity. So after that, thinking about what more we could do to reach those 3 goals, we consulted with the National Center for State Courts, they were doing things around the country that we've come to call as pathways. But before we even started with pathways, we sat down with CCADV, we sat down with mediators, we sat down with lawyers and asked them about their experience and what they'd like to see improvements with. And of course, CCADV, and they're right, you come into a courtroom with 100 people, mostly representing themselves. You don't know whether there's domestic violence unless that's somehow been brought to your attention. So that was a big concern for them, kind of identifying those cases for a judge because they aren't being self-identified. So during COVID, when we couldn't do short calendar, and I know there's some lawyers on this committee who missed short calendar, and I could tell you, I was a practitioner and a judge who loved short calendar. But for the litigants whose eyes we should keep on, it was disastrous. It went like this. They get a call from their lawyer, if they had one, probably on Sunday, saying, make sure you get to court by no later than 9. It's going to be really hard to find parking. So that person has to make arrangements for short calendar to get there by 9, whether it's daycare or a day off from work, gets there at 9, meets their lawyer in a building full of people, because with short calendar, all you had to do was file a motion and everyone came in. The court had no control over that docket. Just file a motion, you get into court. So they go down family relations, sit in line to see a family relations officer, finally get into family relations. That's maybe 10:30, 11 o'clock, meet with them, still haven't resolved anything, go back out to the meter, put more money in it. I'll see you back at 12. Maybe we get before the judge at 1. You get before the judge at 1. The judge says, we're taking a recess. What do you need to do? Well, I need 3 hours. Well, you can't get 3 hours in a short calendar. No one got a hearing on short calendar. Let's fix that misnomer right now. No one got a hearing on short calendar unless it was 15, 20 minutes. So it comes to 3 o'clock, find out they can't be heard, send that client away and send that client a bill for $1,500. There's zero value in that to that litigant. And you understand where that frustration comes from, because then it repeats itself on short calendar and repeats itself again on short calendar and again and again. And what we were missing was one of the fundamental responsibilities for a judge. We have 2. We have to make decisions. And number 2, we're required to manage the docket. So pathways is a very fancy term for managing a docket. Differential case management. Every case is unique and needs different things from the forum we offer. Most of them require very little from us. Some might require a mediation, a pretrial, help with resolving, a custody dispute. And then there are, of course, some that need a lot of attention. So we have track A for those easy cases, track B for those cases that need a little something, and track C. About 25% of the cases are track A, 65% of the cases are track B, and the rest go in track C.
Okay.
Every case, but I want to share something with you, if I may, because everyone's been working on this for a long time. Every case with pathways gets into court within 30 to 60 days. And it's structured so every case should be seen not only by family relations on that day, but also by a judge. So that judge can make sure that case is aligned with the services that family or that individual needs in order to get an exit out of the court, however long that may take. So now fast forward, 52% of our cases across the state are resolved in less than 90 days. That's unheard of. I'd put it up against any stats with any state across the country. 52% resolved within 90 days. Are there still things we could fix? Absolutely. Do we continue to have conversation with lawyers? Absolutely. Does Stanford stand out as one of the most challenging jurisdictions? Absolutely. But we aren't ignoring it. And we continue to plod on to make sure that the forum that we provide and the process we provide meets the needs of the litigants who come before us.
I appreciate that answer. I got more than I bargained for, and I appreciate that. And actually, my friend and colleague, Representative Fishbein, the ranking House member, has far more expertise on family matters than I ever will. My last quick question, because I know that I was admonished to go quickly, and other than Judge Armada, I'm not going to have a lot of questions this morning. And those are all friendly, Barry. Your Honor, regarding technology, in the response to the concerns raised by Chairman Staffstrom, he sort of pointed out, and I agree, that we have to sort of phase out of looking at structures, although save the assets that we have, but embrace technology. And in my other job in a corporate setting, I know they are upgrading our internet, our protections, our capability of communication all the time. And so many meetings are now done by Zoom, and it's really, really efficient. And there's great strides taking place every few years. And I'm just wondering, for a period of time, and actually in great measure in response to the necessity of the pandemic, the judicial branch took a giant leap forward, and then all of a sudden, things that were in person are now being done by distance. And as someone who has matters all over the state, I don't know what I would do if I had to go to foreclosure hearings in New London and Waterbury and Hartford all at the same time. I'd just be pulling my hair out, and I don't know what I would do. Now it's completely possible. And I'm just wondering, that was sort of round one. And I'm wondering what is afoot, if anything, to even make it more efficient and upgrade the civil side in particular regarding technology, so that more things can be done from a distance, which I think allows everyone to operate more efficiently. In some things, I'm going to tell you, you got to be in person. It really does wonders. But in a lot of things, they don't require having to haul. And the time on the highways is just downtime, no matter if you have, hands-free cell phone and all that jazz. I'm not a great multitasker. So I'm just wondering, is there any group that's sort of like working on this now, or is it still sort of stasis?
No, we continue to do what we can with respect to technology. And Senator Kissel, I don't know we'll ever get consensus amongst the bar as to those who want things in person and those who like the remote. It seems like it's cut down almost the middle, but you're right. There are some things that certainly should always be remote. The trial management conferences, the status conferences, the arguments that don't require any evidence. But, we're continuing to build out that platform with breakout rooms. We also have a big need for interpreters, and we've built that out with virtual remote interpreting that is, wires right into a remote courtroom or into the courtroom. And since we can't compete in the private market with interpreters. So that's been a big push with 120 virtual remote interpreting carts around the state where, interpreter could be in Hartford, but plugs into your hearing in Stanford at 10, to someone else's hearing in Hartford at 10:30, and on and on and on without ever having to get in the car, which is a big convenience, because usually there are always oftentimes we're waiting for an interpreter. We've done things that, judges are actually on duty 24/7 for taking risk protection orders or arrest warrants. And that used to be where a police officer would call looking for a judge and have to drive to a judge who was available to their house. We've now made that a virtual platform where, at any time of the day or night, If a police officer has an arrest warrant or a risk protection order, it's submitted electronically. A judge gets a ping on their phone. The judge does wake up. I was just on duty this past week, so the judge does wake up, reviews that risk protection order, signs off on it, and submits it back to the police department without police officer never having to leave the station to look for a judge. So, across the board, we're doing things to try to, maximize on technology. We're hoping AI provides us maybe with some insights. We have, a very large AI committee that has both branch and external stakeholders. And then we have an internal committee that's going to be kind of a testing ground where if there are suggestions, it'll be vetted through this committee that has lots of IT people on it to see if it's something that we could capitalize on some of where we, fall short.
Well, thank you. And I just want to give some props out to Judge Bellis because I think she was really instrumental in the first iteration of advances in technology, and any other judges that are participating. I appreciate that. And I appreciate the indulgence of Chairman Staffstrom and my questioning. Thank you, sir. And thank you, Judge Bozzuto.
Thank you.
Representative Fishbein?
Thank you, Mr. Chairman. Good morning.
Good morning.
You always give a great face for the judicial branch. Always very professional. I very much like seeing you up there. A couple areas I just want to ask about. The Chief Justice Mullins talked about the Wi-Fi in Waterbury. As far as where the Wi-Fi goes, I would think that's a function of your office. You make that determination, right?
Well, when the Chief Justice initially talked about that initiative, he wanted to get the biggest bang for the buck. So he went to the 4 largest JDs. But you're right, within those JDs, it was really more IT that helped us identify what's the quickest way to go. So for example, in Waterbury, it's going to be at 400 Grand Street because that's a new structure. 300 Grand Street is a very old structure. And of course, there's a concern, once we start doing the cabling, you have to rip down the walls, that there likely could be asbestos behind that. So we want to do some testing on that before we reach out to 300 Grand Street in Waterbury. So there was, the original decision was let's get our biggest JDs to have Wi-Fi in public corridors, see how that works, and then continue to spread it out throughout the branch. And
Did he-
again, as money, as funding allows.
You sort of answered the question because for those of you who haven't been to Waterbury courts, the 2 courthouses are right next to each other, right?
They are.
So it begs the question, why do 400 and not do 300 when they're right next to each other? So,
Right.
no, I appreciate that answer. I do want to push back, as you had probably anticipated,
Of course.
about the whole track system. And I want to give you a scenario. Motion for exclusive use. We got a family, mom, dad, 2 kids. Dad got drug issues. He's drinking a lot. The kids are being affected. Maybe he's living out of the basement. Brings his girlfriend over on Saturday night. They're doing whatever they're doing. The kids can hear it. Wife says, I'm done with this. It's not good for the kids. She brings the action, and along with the action, she files a motion for exclusive use, which, as the title seems to say, she wants exclusive use of the property, and he should be elsewhere for the betterment of the family. So under the old system, she'd file the action, there'd be a return date. Return date can't be any more than 12 days before the papers are served, right? So that's the 15 days about is what you're working with. And then from the return date, you get a short calendar note. It's about 2 weeks after the return date. So now you're in court. And I know the pushback is basically from my experience and my discussions from family relations, because it's a cattle call, right? You got a bunch of people, they're not all happy. And they got to triage these cases. But when those people leave that courthouse, they're either going to have an answer because family relations is going to say, dude, cut it out, or you should be looking for an apartment, or they're going to get a hearing date that day, right? A hearing date maybe a month later, because it's a PL, Pedenti Liti stands for, the case is pending. And at that hearing date, a judge more than likely is gonna, they're gonna do the right thing, right? No matter what that is. So that's the old system. Under the new system, you file the action, you attach the motion. You're not getting into court for maybe 45 days, 60 at the most, on what's known as a RPD, or a resolution plan date. Which I gotta tell you, I don't know what an RPD is. Because sometimes you see a hearing on an RPD date, which was like old short calendar. Ultimately you're meeting with family relations, which you did under the old system. You're gonna go to a judge who's gonna track it, A, B, or C. More than likely, you're not gonna hear that motion for exclusive use on that day, right? So you're 60 days hence, right? So now we're about 75 days because the papers were filed 15 days, 60 days, right? Meanwhile, I got dad drinking and drugging and whatever in the basement, and kids are being affected. So now the result of the RPD date is a case date, which once again, I don't know, because none of this stuff is in the practice book. And I don't know what that is. Is a case date a hearing date? In my experience, it's a status conference, basically. Where are we? Were you able to figure it out yourselves, basically? Meanwhile, dad's in the basement drinking and drugging and whatever else. And case dates, as far as timing, 60 days after the RPD, and that's being generous. I got to tell you. That's the new system. So how is that better?
So Representative Fishbein, we had heard that from the bar, and in every JD have established a motion docket, which is just like almost going back to short calendar, where if that motion for exclusive possession wasn't heard on the RPD date, which it could be, then it would go on a motion docket. So we've tried to address every single scenario that comes up in the life of a dissolution action. And I'm hoping wherever you're practicing, Representative Fishbein, that on that RPD date, not only meeting with family relations to look at the case holistically, as opposed to the Band-Aids of short calendar, but you're also before a judge who'd be asking those questions. What do you need? I need a motion. I need a hearing. How much time do you need? That's what it's supposed to be, active docket management by the court on your RPD date to make sure that you are getting the time and resources you need to get that case resolved. That's the whole thing. It's about coming up with a resolution plan on that date. Whether it's a simple case or one of our really complex cases that needs a rigorous discovery order with, disclosure of experts. So that's the way the resolution plan date's supposed to work. I know Judge Armada is behind me. That's the way it works in New Britain. I think really that's the way it works in most places. And it's really, Representative Fishbein, you're the rarity, a lawyer being in a family case. It's typically self-represented litigants who have no experience whatsoever in a courtroom, let alone dealing with a divorce, which is so stressful and painful to begin with. So it's all hands on deck with the RPDs when it's executed properly with a judge, making sure that judge addresses that case, finds out what the issues are, what the needs are, and aligns that case to get all of those resources.
You point out the other problem. Myself as a practitioner knows to file that motion, right? The wife in the original scenario has no idea what a motion. What's a what's a motion? I just want to get a divorce, right? She doesn't know she even has the ability to file that thing, right? So under the pro se situation with the same thing, the motion doesn't get filed until about 6 months after the action is even brought. Meanwhile, I got kids that are being negatively impacted. So, I would just suggest that on that RPD date, if there's motions that have been filed, you're either withdrawing them, you're marking them off, or you're getting a hearing date, right?
That should happen on the RPD date.
It
You're
should.
absolutely right.
It is.
You're absolutely right. And that pro se litigant who doesn't even know that that person could file a motion will be educated about that. Of course, our family relations officers can't give any of them advice, nor can our clerks. But they get some information as to the divorce process.
Yeah, I'm just gonna tell you, under this new system, I have a case that was filed last June. I think no, actually the restraining order came first. And then the dissolution. Restraining order was only granted for 3 months, and then the day after it was lifted, he threatened to kill her. We had to get the restraining order again. When I brought the dissolution action originally, I filed a motion for financial order. I'm gonna have that hearing February 3rd. I don't like this new process at all. The other benefit to the old process is, I gotta tell you, it's costing litigants more. Because under the old system, I would file motions in my case, as I do. Let's say I have 4 cases now, file all the motions, right? Under this new process, I'm getting different dates. They're like all over the place for the most part. They're not going to be scheduled for the same day. Under the old process, I'd go to court on that short calendar day on those 4 cases. I'd settle. Well, I'm a decent settler. So 3 out of the 4 I'd settle, right? Out in the hallway, I'm working on it, right? Get an agreement, go before the judge, and you got the one that you got to deal with family relations, maybe get a hearing date. Those clients aren't all getting billed for my time being at the courthouse. It's getting shared because I'm working on all of their cases. Now, it's almost like individual, right? So I'm summoned to court to stand out in the hallway New Britain, sure. I've been there for RPD day. We're gonna, I see Barry here. You can be there a good 3 to 4 hours on an RPD date in New Britain. I'm billing 1 client, right? Ordinarily, if I had the 4 clients, they're splitting it up. So that 1 client is having to pay more for that legal representation, which the result is more pro ses in the court system. Who I got to tell you, a lot of times pro ses, when they're putting their agreements together, they screw up. And the judges accept, they're agreed. This is what they agreed to, right? But it's beneficial to have more lawyers. So, I push back on this process all the time. I don't think it's beneficial, but it is what it is. So thank you, Mr. Chairman.
Representative O'Day, followed by Representative Osborne, followed by, with those.
Right.
Representative O'Day first.
Thank you, Mr. Chair. Hello, Your Honor.
Good morning.
Good morning. Just a couple, look, you've forgotten more about family court than I've ever known. So let's just get that straight. I did like the good chair's kind of suggestion, thinking outside the box. Maybe we pay family court judges more. And I heard the Chief Justice's response there, and certainly I commonly say that I've been wrong more than I'm right. Just ask my wife, but on ideas. But I do think we should talk about something like that. The other thing I was thinking of, and I actually put a bill in, that the judges review the legal fees for family court attorneys, like committees. Now that didn't get me too many fans in the family court bar down in Stanford, but I guess you were, I want to make sure I understand correctly. 52% of family court or divorces are resolved within 90 days. Is that what you said?
Within 90 days. 10 years ago, it was zero. It was zero. Then with the first iteration of reengineering, it went up to about 32%. And now it's 52%.
Wow, that's
And what that
fantastic.
does, it's not only getting those cases out, but then more availability for the judges to handle the cases probably need more attention, right? They have more time.
Was the other thing you said, only 20% have two lawyers?
That's right.
So, I'm not really good at math, but that means 80% don't. And out of those, all those, so 48% don't get resolved within 90 days. I'm just wondering, you had mentioned that over the last decade, we've done a lot. And not having practiced a lot in family court or hardly at all, increasing it from 0 to 52% resolved within 90 days is phenomenal. What are some of the other things that over the decade that you've been experienced with family court that has improved? And what are some of the things that haven't yet improved that you'd like to see improved, if you don't mind the long question there?
So any improvement, I mean, I always relate family court to, a highway. And the longer folks stay on the highway, the worse it gets for them. And when they're at the very end of that highway, they're exhausted, they have no money left, and they hate each other way more than they did on the first day. So it's always about getting people kind of off that highway as quickly as we can. And really, we're the envy of the nation because we have family relations officers who are well-trained, have been doing this work for a long time, and settle a lot of our cases. But it's really, and the idea with what they call pathways, which is it's differential docket management. And I wonder all the time, I don't even know if I need a practice book rule to manage the docket that way. You ask a person, what do you need? Oh, well, we haven't finished our financial affidavits. Go to the court service center, finish them now when you get your divorce today. Or they come in and say, well, we have 16 properties and we need evaluations. You get them on a scheduling order. I mean, I would do that, pathways or not, as a judge who's supposed to be managing their docket. So, we've done a lot. There are still remaining issues. When anyone mentions a case, I always like to take a look at it because looking at it on Edison tells sometimes a different story. When they say, oh, I can't get in, well, there's been 3 requests for continuance by the plaintiff, 3 requests for continuance by the defendant, and maybe 1 continuance by the court. So there's a story behind every case that gets postponed. And listen, I think it's intolerable to be in court today on a post-judgment motion and say, well, I'll see you next year. That's unacceptable. That should not be happening. So I want to address those or, obviously address it. We have PJs in every single one of these locations. Stanford has been hit in more, it's always been a challenging jurisdiction. It really is a medium-sized jurisdiction, but takes up a lot of resource. They have some super sophisticated, complex cases, no doubt about it, that take a lot of time and attention. And we've suffered some major losses of our most senior talent. Judge Trulia, may he rest in peace, got there in September, and by December had already made a big impact on that docket. Judge Heller's taken senior status. Judge Shea's retired. Judge Novak died. That was all of our senior talent in Stanford that we've lost. But I'll say for Stanford, when you look at their cases pending over a year, it was 50%. It's now 25%, which to me is still unacceptable, but it's trending in the right direction.
So if I do know of someone who filed a motion for modification, and it's taken almost 18 months to get a hearing. So your suggestion for that, and both, let me see, one side is pro se, the other side has a lawyer. And the person that's pro se is the one that's seeking modification because their status has changed significantly financially. And the other side has no incentive, so they just kick it off as long as they can. And the court has kicked it off for 18. I mean, that just sounds outrageous to me.
To me too.
So what
Really, Representative Day, I'd love to, not here
Right.
publicly, love to know the case.
Okay.
So I could look at it, because I find that completely unacceptable too. Unless, oftentimes in Stanford, there's requests, they have experts, they have appraisals, forensic evaluations, all of that takes time. I'm not sure if that's what's implicated in this particular case, but I would agree with you. 18 months on a post-judgment motion to modify shouldn't be happening.
Understood. So I won't take up any more time. I know we've got a lot here, but I would appreciate the opportunity to buy you coffee and try
You
and
don't even have to buy me coffee.
and get down to how we
I'd
fix
be
it
happy-
down in Stanford,
please.
because it's a mess and I don't know how to fix it. So thank you. Thank you, Mr. Chair.
Representative Osborne?
Thank you, Mr. Chair, and good morning, and thank you for being here, Judge Bozzuto.
Good morning.
Just a couple of asides that don't count to my questions. I noted that you listed the Dijmarescu versus Sherpa case as one of your most, important or interesting cases. And just as an anecdote, I was the GAL on the original matter.
The original one. Yeah, I had a post judgment,
Yeah,
but fascinating family.
fascinating,
Right.
and just very, very small world.
Yeah.
And it brings me back to how long you and I have both been doing family law,
Right.
right? And that brings me up to just two other points. One is, just circling back to the 90-day issue that you were discussing with Representatives O'Day and Fishbein. Obviously, the reason that there's been this exponential increase is that we now have a statutory fix that allows divorces to be resolved within those first 90 days, which we didn't previously have.
But at that point, it was 32% were 90 days or less. When we had those original fixes where we got rid of the 90-day waiting period,
Mhm.
we got up to about 32% that were getting resolved in less than 90 days. But now with pathways, it's gone even higher.
And
At
are you seeing
52%.
most of those being, well, actually, I actually want to go down that rabbit hole on my questions that I really want to talk about. And what I really want to talk to you about is because you do have an extensive history in family court. And I know that I'm probably going to talk to you about this, but the cases that we were seeing when you were sitting in Hartford family, alimony was still a thing back then. Women who had worked in the home, raising their families, who had elected their choice in life to be a homemaking choice, were getting alimony that was long enough and that was, I'm going to say generous enough, but adequate enough to not have to worry about retiring into poverty or not figure out what they're going to do to make a living once they hit age 52 and they've never worked outside the home, or they haven't worked outside the home since, their second year out of college. And that doesn't happen anymore. And it's a real shift in the way that alimony is awarded in the state of Connecticut that has happened over the last decade or so, while this legislature has not done a single thing to shift our policy about the standards for the awards of alimony. So it seems from a practitioner's viewpoint, and from the viewpoint of a woman who at times represents, not always, but represents women who have been in that dependent position in life. It seems that, if you're talking about a 20-year marriage, it's now getting 4 years of alimony recommended, maybe 6. Ooh, if you got a really, really bulldog, maybe you're getting 8 years, and you're still going to be 57 or 54 when your alimony ages out, and you have no way to make a living because you can't get yourself back into the workforce because trust me, women cannot get back into the workforce. Women have to put on this whole other entrepreneurial hat to figure out how to manage in the world. And most people don't have that type of personality, right? So what, in your opinion, has shifted so drastically in the last decade that a woman a decade ago would have gotten enough alimony to not worry after spending her entire adult life focusing on the family, raising the children, making sure the children are okay? What has shifted so drastically in the interpretation of this legislature's laws that require looking at the length of the marriage, looking at the station of the parties, looking at the real earning capacity of people, not just what could theoretically be drummed up if somebody had never stopped working and had worked their education from day one? What has shifted so drastically in the way that it is being applied in the Superior Court? Because let's face it, most people don't get a bite at the appellate law, right? And then it's only an abuse of discretion standard. What has changed so drastically that women are now facing, women who have chosen to raise their children are facing this cliff, this financial destitution that is facing them in these awards of alimony we're seeing at the Superior Court level? Thank you.
So I'm not sure that I don't know the cases you're talking about.
It's
The
pretty standard.
statute has not changed.
Right.
All of those factors are still relevant and need to be taken into consideration by the court. So
It seems to
I-
be
I'm
changing
not
across
famil-
board though, especially in certain jurisdictions.
Representative Osborne, let her finish her answer.
Sorry.
yeah,
I'll take off my litigator hat for a moment.
yeah,
Sorry.
no, it's just hard for me to answer that question, without, I guess, maybe you have, a stream of cases that show some sort of trending change because the statute
Mhm.
has not changed at all. And the application is still required by the court to consider all of those statutory criteria. So, it's hard for me to answer kind of in a vacuum without knowing about the cases that
Well,
you're
then-
talking about.
May I ask that, well, I mean, it's not me. It's, if you talk to the entire family bar, I actually admin, there's a Facebook group just for family law attorneys in the state of Connecticut. I admin that group. So, and of course I'm on, the CBA family law section. I'm a member of the Hartford County Bar Association. It's not just my cases. It is across the bar. There's been a shift in the way that women in these long-term marriages who've raised their children are being treated
Mm.
at the Superior Court level. So I'm just going to ask that maybe you take a look at that because this legislature has not changed its policy, but the interpretation of it seems to have changed drastically. And it's really putting women who are already divorced women are a third more likely to retire into poverty than any other demographic in America.
Mhm.
It's putting them in extremely dangerous positions in terms of their financial security in the future.
I would be happy to review that with you. As you know, Representative Osborne, since you practice this, there are no two divorces alike,
Oh,
right?
absolutely.
So
Absolutely.
there's, factors that obviously could change one decision compared to another case, but I would be happy to look at that with you.
I would be grateful for that. And that's all I'm going to say.
Thank you.
Thank you so very much.
Thank you.
And congratulations on your renomination. Looking forward to it.
Thank you. Senator Flexer?
Thank you, Mr. Chair. Good morning.
Good morning.
It's been interesting listening to the conversation here this morning, particularly given your position as the Chief Court Administrator. Can you talk to me a little bit about, from your vantage point, the fact that 1/3 of the cases in our courts throughout the state have some aspect of domestic violence, and your vantage point on that?
Yeah, I mean, it's, I think it's eye-opening to most people when they hear about how widespread domestic violence is in our family cases. And I think, Senator Flexer, that, those cases are companionized. So a family court judge that's presiding over a dissolution will know if there's either it's a criminal case or a TRO and companionized those cases. So that element is always obvious to any court reviewing that matter. But it's eye-opening when Family Relations does their assessment on the TRO docket, how many of those come out as really high-risk matters. So it's a big issue, and family court deals with it all the time.
And in your role, what are you doing to try to change systems to look at both the interaction between the family court and any criminal case that may be pending that eases a person's interaction with this system?
Yeah, well, there's been a big push towards having lawyers for applicants in TROs. There was a grant that was awarded to the Connecticut Bar Foundation. They're in the 5 biggest JDs now. They'd like to expand. CCADV also has volunteer attorneys, and they're expanding across the state because certainly, despite the fact the judges have had extensive training on dealing with pro se litigants, and I think do a pretty good job with a TRO, even when they aren't represented, the applicant absolutely is better off having a lawyer by their side when they're in court. There's just no two ways about it. So we're hoping that it's funding. We're hoping that program expands. I don't know. I know you were very instrumental in that, Senator Flexer. Might have been the first in the nation under our Civil Gideon efforts to have lawyers representing applicants in TROs. It's really very, very important.
Thank you. It's good to know that that you support the potential expansion of that, because I agree that it is important, and that the process of being a victim trying to navigate the system, no matter which side you're on is incredibly challenging. And so the support that now exists in the 5 jurisdictions should be expanded and has made a world of difference for a lot of people. You mentioned the training that judges have in terms of dealing with pro se litigants. Can you tell me more about the training, that particular training, and also training that the branch offers for judges in how to respond to cases they're dealing with that have domestic or family violence?
So I can start with pre-bench before they even take the bench. Pre-bench is usually anywhere from 4 to 6 weeks. There's 4 days exclusively set aside for domestic violence training. And then every year we have, at the very least, our CJI Institute, Connecticut Judges Institute. It's a 2-day training. And every single year we have a plenary session regarding domestic violence. This year it's going to focus on intimate partner violence. And then we have offerings throughout the year that are available to judges. They have every division has a fall meeting, sometimes a spring meeting. And, you know, domestic violence is really, it's pervasive across all 4 of our divisions. I know it seems most prominent in family, and it is. It's certainly very prominent in criminal. Of course, we have it in juvenile. Well, I mean, it's broad. So all judges are required to undergo the training. And there'll be, obviously, we have our institute in June. I forget the name of the speaker that we're bringing in, but they're going to focus on intimate partner violence this year at this year's training.
So the 4 days and the institute, who runs those trainings?
So the 2-day Connecticut Judges Institute.
Mhm.
So it's a branch function, and we rely heavily on our judge support services. And we have an education committee, and it's currently chaired by Judge Westbrook and Judge Goudreau. And we solicit faculty, both within the branch and without. They come up with a curriculum, which they've already did. It's already been planned for 2025. But you know, that's how we do it, you know, every year with our education. And the education committee has probably 10 to 12 judges on it, representing all the divisions, with suggestions as to what training's really necessary, what they need to brush up on. But regardless of that, there's a standing DV plenary every year. We've been doing that probably for 6 or 7 years now.
Where do the suggestions come from for what needs to be included in the training, from
It's-
just your judges?
It's usually from the judges,
Okay.
right?
And
You know,
that-
in the
that-
field, on the bench, kind of seeing where maybe we need a little more training here, a little more training there. And it often deals with, you know, how to better deal with self-represented litigants, since that's become, you know, it's an ever expanding population. I don't see that trend being any different. As I said, domestic violence is ever present. But there are other more nuanced topics that we also have available to the judges.
And are there ways for other people involved in the system to make suggestions for this training, or this seems very insular to me? And I know that in other states, they have outside experts come in and conduct some of these trainings. And our branch has been very resistant to that for more than a decade. And it sounds to me like you take suggestions from people who sit on the bench, but not the people who are dealing with the reactions of the decisions that come from the bench.
Well, for example, the domestic violence plenary sessions are always with outside speakers. It's not a judge presenting that content. It's an outside recognized expert from the outside. I mean, you know, long ago it was Jackie Campbell. You know, we have a very small budget. Lots of time these people offer to provide content or to come in and teach at no or low cost. So the outside, most of the plenaries are conducted by outside speakers, outside experts.
And is it accessible for folks to see what those trainings and plenaries include?
I mean, if you'd like to see the agenda, I'd be happy to share it with you. We don't invite the public into our 2-day
course.
training, but no, I'd be happy, you know, to share that with you. I think there's times when I've reached out to Liza, the folks at CCADV with suggestions. They're always a great resource for us, and we collaborate with them on a lot of things. So, and I'd be happy to share the curriculum with you, Senator Flex, either from this year or any of our prior years.
Okay, that would be great. Thank you. And from your vantage point as the Chief Court Administrator, are we still having challenges with space for family violence victim advocates to have private spaces to meet with victims that they're working with in our courts. I know that's been a challenge over many years. We've tried to push the branch to change that. I know that there's a variety of capacity issues in our courts, and some of our structures actually have a lot of space that is free and open for use. So can you just tell me where we are with that?
So you must be referring to Litchfield. Because otherwise, you know, I just finished a conversation with the acting chief public defender because they had 60 new lawyers looking for space. And I found space in 4 different JDs. There's victim advocates in every single one of our courthouses. Some have private space, some don't. They're all given some kind of space. I mean, CCADV has a location in all of our JDs, but space is absolutely, when you're talking about Hartford, I mean, Hartford is bursting at the seams for space for even the public defenders. I'm not, you know, if you go to their office, they're crammed in the basement like cattle. So I know why Attorney Day is on my back about finding more space. And we've made a proposal in our court ops bill to move some of those western towns out to Litchfield to kind of, it's small relief, but some relief to Hartford for space. Because it's not only not good for certainly the people who need to be there, such as victim advocates, but when you have people in an adversarial system come into a space that's cramped and crowded, it's really hard for our marshals to manage. I mean, they come in anxious and angry, as you could understand. All of the things we do, you know, someone's been wronged one way or another, and they're nervous and anxious. And if you spend any time in our bigger JDs like Hartford, it's really untenable.
Thank you. You and I served on a task force a number of years ago regarding the expansion of civil restraining orders. And that task force met several times. And in one of those meetings, you had expressed sentiments about the use of restraining orders that I found deeply disturbing at the time, and I've never forgotten it. Unfortunately, those meetings were not transcribed, but there were minutes. And the minutes indicate that at the time you said that 46B-15, the civil restraining order statute, is not being used the way that was intended at the time it was enacted. Do you still feel that way?
From time to time, that still happens. Now, I've been off the bench for a while, but from time to time, there are abuses of the 46B-15. And I think if you asked any family lawyer that, or family judge, they would agree that sometimes people use it in a way to gain an advantage, in a way to manipulate. Now, it's certainly not the majority of TROs that are filed, but it does exist.
Right. But is that a reason to not expand that level of safety and protection to victims of other crimes? Because sometimes there are some people who abuse this particular system for nefarious reasons. Is that a reason to not ensure that victims of crime have access to the protection a civil restraining order can provide?
No, absolutely not. Absolutely not.
Well, thank you for the answers, and I thank you for the time, Mr. Chair. Thank you.
Further questions or comments from the committee? Representative Blumenthal.
Thank you, Mr. Chair, and thanks for being with us today, Judge Bozzuto.
Thank you.
One of the thorniest and most difficult issues that we face here on the committee, and I'm sure that you face as well, is issues related to judicial temperament. Obviously, people have different judicial philosophies. They may approach an issue in the law or on the facts in a different way, and reasonable people can disagree. But so much of how individual litigants' life may be affected by a case before a judge is decided, not in a lengthy decision or even maybe on the record, but in those those gaps in between the kind of official things that we think of as part of the record and what gets reviewed by an appeals court, and how a proceeding is shaped by those decisions. And so to step on the turf of one of my colleagues, Representative O'Day, we constantly ask about the potential of robitis. And so I'm going to ask you a question in your role as Chief Court Administrator for the Superior Court. How do you think about addressing issues related to judicial temperament when they do arise? What transparency do you think is necessary? And also, how do you think about remediating those potential issues when they do arise? And what, if anything, do you think can be improved about that process? Thank you.
Yeah, so I usually find out about it after the fact, whether it's been a grievance filed. So it comes late in the process for me. And we do have ways of addressing that with any particular judge, through our judge support services, having someone anonymously go out and sit in the court and view that particular judge, provide feedback. All the judges are subject to the performance evaluations that we go, when we receive them, we go over them with the judges. And if there is a comportment issue, we talk to them. I mean, I talk to the judges all the time about comportment, all the time. And it's, I'm not saying we have a huge problem with it, but there's certainly, as you well know, have been some judges who have struggled with that. So it's a constant conversation. And I always tell the judges, if they just stick dispassionately to the requirements of the job, find facts, apply the law, and render a timely decision, they'll never have a problem sitting as a judge. So you need a long fuse, especially if you're sitting in some of our more challenging assignments. It requires a long fuse. And that's up to the individual to make sure they're keeping themselves in check. We're all big boys and girls. We all accept this position and all the responsibility that goes with it. And they have to be mindful that people come to court because they want to be heard, they want to be respected, and they want to be understood. They deserve that. They're owed that. So, these are conversations I have with my colleagues often, and the vast majority of them, certainly all the superstars behind me, every single one of them, know exactly how to execute that responsibility in an appropriate way. All of these behind me, I've asked to do more than what's required of them, and they always say yes.
Well, I appreciate that answer and appreciate how seriously you take this issue. One of the concerns I think a number of us have had on this committee is we sometimes find it difficult to suss out issues like that when it comes to reappointments. And I'm certainly not casting any aspersions on any of the individuals who are up for appointment or reappointment today. But I would like to see us be able to work with the branch to have more transparency on these issues and a process that's more reliable for surfacing them, so that we can do the oversight that we need to do. And I would certainly welcome any cooperation and on that we could have. Thank you, Mr. Chair.
Thank you.
Further questions or comments from the committee? Representative Callahan.
Thank you, Mr. Chair. Just very briefly. Good morning, Judge Bozzuto. Good to see you.
Good morning.
I just wanted to thank you and make the committee aware how open you are to communication if we have issues. I know for one, you've picked up my calls even on the weekends on the water. So I do appreciate you accepting input and giving me input on things that come across your desk. So you've been very open and helpful to me. Thank you.
I'm happy to do it.
Representative, anybody else for the first time? Anybody else? If not, Representative Fishbein briefly for a second time.
Thank you, Mr. Chairman. Judge, we heard something about delays in family, and I think one of the impacts is the person on the modification who, finally gets that hearing date. Like the case that Representative Day was talking about. I did look up the case, and for various reasons, the motion's been pending for a year. Right now, the retroactivity statute is discretionary. And as you as a family court judge, you know, would you have a problem with us changing the statute to make that retroactivity mandatory? To help those people that are waiting to get a modification? It would seem to make sense to me. So what are your thoughts on that?
You know, I don't know that I would have a problem with that. I guess it would have to take into consideration that although someone might be delinquent, they've been making some payments, right?
No, but I'm talking about you know, the guy who just say the gentleman whose income has been cut in half, right? They're required to make alimony child support payments up here. They're doing it,
Oh, I see.
right? While this motion is pending.
Right.
And now all of a sudden we have an order of the court saying, yeah, modify, we're gonna cut it in half.
And it's
Really
been
should be
paying the full-
retroactive
yeah.
back to the same, you know, date of service of the motion, which right now it's discretionary. Judges, in my opinion, don't always want to get into that math. And just say, okay, here we go.
Well, in that scenario, I think it sounds fair to me to do that in the scenario you gave me.
Okay.
I mean, I always balk when it's, especially in family court, taking away some of the court's discretion. Because, you know, cases are so nuanced in family court, but, you know, that would seem fair and appropriate to me. Someone who continues to pay, but then gets a modification, that there be some acknowledgement of the overpayment.
Thank you, Mr. Chairman.
Further questions or comments from the committee? Further questions? If not, Judge, I just want to first thank you. Thank you for taking on some extended questioning from the members today. I did allow this to go on a little bit and a little deeper into the operations of the branch because this is our first hearing of the year, and I think some of this will be informative to us as we do our work going forward this session. But I do want to just remind my colleagues that when we vote, what we are voting on is whether you're qualified to be a judge of the Superior Court, no different than any of the other judges that are going to be before us today. The choice of chief court administrator is, I guess for better or worse, the prerogative of the Chief Justice, not the prerogative of this committee. So I do just want to, while we spent a lot of time talking about sort of the operations of the branch and procedural changes and the like, you know, I think I would take that as an indication from this committee that there really are probably, I shouldn't say no, but there's not significant concerns about your ability to be a judge and your intellect and your temperament and performance. So I do just want to make that clear. With that, while we're on issues before the branch, I will again make my plug. Well, much to my chagrin, short calendar may not be coming back. I would quibble with one thing you said, which is that argument on motions that don't require testimony should remain remote. I wholeheartedly disagree. Dispositive motions should be argued in person in front of a judge. Something that is going to dismiss a case or grant summary judgment in a civil context, I think should be treated with not sitting behind a desk. It should be in court. I think as somebody who is responsible for training young lawyers at my firm, I think it's a disservice to them when they're now 4, 5, 6, 8 years into their career and they've never had an opportunity to walk into a courthouse, walk in with their litigation bag, spread their files on the table and see motion for summary judgment argued. So I would really, I know you're going to tell me it's the discretion of the individual judge and it's the case and We've been through this. Push the judges and anybody else listening, civil judges, dispositive motions in court, in person, please.
You know, it's funny that you mentioned this, and you probably know, in Hartford, everything went from remote to now in person. And we've kind of left it to the judges to make those decisions. I know when Judge Carroll was still chief court administrator, we always had this debate. Do we issue some kind of standing order where, you know, these types of things are remote, these type of things are in person, and everything in between could be the discretion. And we really stayed hands off on it because it appears to be working itself out, maybe lawyer by lawyer or jurisdiction by jurisdiction. And I don't know that you'll get agreement or consensus amongst anyone
I know
as to what's in and what could be virtual. So
I know.
You know, I
get-
guess this is one of the things where we're hands off on that one.
I get it, and I get nobody wants to drive down to Stanford for status conference or for a short discovery dispute or the like. I certainly don't, but major dispositive motions, I'll put that out there.
Understood.
I'll put that out there globally for anybody who may be listening today.
Understood.
So, thank you, Judge. Appreciate you being with us.
Thank you.
All right, Judge Armada. If you might raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Have a seat, and whenever you're ready, we'll take your opening statement.
Okay. Good morning, Chairs. Senator Winfield, Representative Staffstrom, Ranking Member Senator Kissel, Representative Fishbein, and other esteemed members of the Judiciary Committee. It is my pleasure and honor to be before you today for reappointment to a second term as a Superior Court Judge. I'm grateful to Governor Lamont for his confidence in nominating me to this position. Since I was last before this committee, I've been assigned to the judicial districts of Waterbury, Tallinn, and New Britain, where I currently serve as the Assistant Administrative Judge and the Presiding Judge for Family Matters. In these assignments, I've had experience with all 4 divisions of the court. Additionally, I serve on the Judicial Branch's Education Committee, the Rules Committee for the Superior Court, and the Branch's Committee on Artificial Intelligence in the Connecticut legal system. I consider it a privilege and an honor to serve the people of the state of Connecticut as a Superior Court Judge, and I hope to be approved by this committee and continue in that role. To that end, I'm happy to answer any questions you may have.
Senator Kissel.
Thank you very much, Chairman Staffstrom. First of all, Your Honor, I owe you an apology. I should never refer to you by your first name, but we go way back
Go way
to
back.
Harlem Globetrotters, land on Gilligan's Island, and I'll just leave that as a mysterious reference for the fans that are watching in TV land. And I just wanted to let you know, not only am I extraordinarily proud that you come from my district, that was a fast 8 years that flew right by. I think you'll find that this pass through the legislature will be far different than your first one, because everywhere I go, and everyone that I talk to that's had any business before your court, they just sing your praises. You're an extraordinary jurist, and you're really a great representation of lawyers from up in our neck of the woods. And for the longest time, we hardly had a lot of judges from our north central Connecticut area. And we have a handful now, and you were one of the first that I was aware of. And you've done us all proud. And you do handle the family matters, and you brought your expertise from your private practice. So I just want to let you know that just whenever I mention your name, people have nothing but good things to say. And I'm glad that I sat in on that Rules Committee meeting where I saw you in action. And my friend and former our counsel for Senate Republicans, now Judge Maczarowski. And it was really enlightening to sit on that. And I was very proud of both of you. I guess I just have 2 quick questions. One, what have you gleaned over the last 8 years that you can impart to us that we should be aware of? Because you're going to see things, you see things that we don't. And how can we help you out to mete out justice? And my second little portion is, I'm just very intrigued by artificial intelligence and what is the judicial subcommittee or committee on artificial intelligence that you stated you sit on actually attempting to grapple with.
So first off, thank you for your kind opening words. I really appreciate that. In terms of what I've learned is the court system has become a place where we're given a lot of societal problems to try and fix. And we don't necessarily have the resources to do them. We see mental health, we see drug addiction and things like that, and they sort of try and fit into a criminal. And it's hard for judges who come from a legal background to try and grapple with that. So in terms of what we could use from you is probably more resources, and by that I don't mean money, but programs or things like that that can help folks that we're trying to help get on a better path in life. In terms of the committee on AI, I'm a little not sure why I'm on it. I can spell AI, that's about it. But what it is I'm inquisitive of it. And it is a new up and coming tool that can help the court in terms of the processes it's done. I think we have to be very cautious about it in terms of you know, the visions of the Terminator and it taken over. There's confidentiality issues, there's bias issues, there's all sorts of things like that. But I think it's because I'm inquisitive and want to understand that I was put on this committee so we can understand what AI tools are available to us and how we can use them in an ethical way, both the bar, the branch, and the public. We're seeing results in other courts and other states in terms of AI helping folks navigate things, understand the law. But we're very cautious on this right now, and we're just right now sort of trying to get a lay of the land. And it's chaired by Justice Alexander, who's doing a great job.
I appreciate those answers, Your Honor. And yeah, I feel the same way. We grapple with AI on the General Law Committee. Sometimes those bills get referred over here. I'm still not quite sure, other than if there's any kind of criminal penalties sort of wrapped in. And I'm sure everybody in the room witnessed our new president, or sort of old president now, once again, new president, President Trump, at his press conference yesterday, where he met with three investors pledging, I believe it was over $500 billion to have a huge AI investment in the United States of America so that we can compete head to head with China. And it's an exciting field. I think it has the ability to do great good and great harm. And to the extent that we get our arms around it early on, we're going to be better off. And having you have that inquisitive nature, it doesn't surprise me in the least. So again, I just don't want to take up a lot of the committee's time. We have a lot of judges on our list today for renomination. All of them are great in my book, but again, you do us all proud in North Central Connecticut, and I couldn't be happier for you. And I commend Governor Lamont for your renomination, and I wish you the very best going forward, Your Honor. Thank you, Mr. Chair.
Representative Fishbein first, and then followed by Representative Day.
Thank you, Mr. Chairman. Good morning, Judge Armada.
Good
Nice
morning,
to see you again.
Representative Fishbein.
You know, I'm proud to say that I knew you when you were just a lawyer. And I think you are unique. And I think one of the reasons why you're unique is you were also a GAL. You did a lot of cases where you were meeting with people that were many times pro se, deciding what happened with children. And I think you've brought that to the bench. You know, 8 years ago, or just about that, I don't think I was on this committee, but I was certainly in the legislature. And your name came up on the board, and I got up and I argued against your appointment. My argument, as you recall, though, was not about you. It was about the money. Could we afford all of these judges? So, I mean, there is some testimony in the system that talks about the vote. But I just want to point out that the vote was not based upon you, your background, or anything like that. And I just want to let my fellow committee members know that I got up and made that argument. I voted against Judge Armada, and he sent me a thank you note. And he thanked me for, you know, looking out for the finances of the state, and he understood what I was doing. You know, a few weeks ago, I was before you, Your Honor, and I had the opportunity to sit in your courtroom. And there was a case, I'm not going to get into the case before me, and, you know, I had to deal with an infant. And mom wanted to go to Europe with the infant. And dad's like, no. And at the same time, dad's saying, well, it might not be my child. And they're jawing back and forth. And Judge Armada is sitting there listening to both sides, both arguments. And he came in with such a tone that was, I don't know how to describe it, but it certainly wasn't confrontational. He explained to the pro se parties, you're not dealing with a piece of furniture. This is a baby. And we have to look out for that child. And, you know, I'm sitting there and I'm thinking, I wish Governor Lamont was sitting in this courtroom watching what actually happens in family court. And I did tell that to the governor the other day, and how Judge Armada handles these cases. I had another case in your courtroom or your courthouse a few years ago. A gentleman had gotten, he had a child with someone he wasn't married to, and he had a serious drug issue. Heroin was his drug of choice. And he didn't cooperate with the court system because he was so busy with his drug of choice. And in fact, the court scheduled, he went to a couple court appearances. The court scheduled the matter to go to final judgment. And he didn't go to court that day because he was too busy with his drug of choice. So Judge Armada took the proposed orders of the mother, and they called for dad to get some help, give mom some control over when dad could see the child. And he got clean. And that's when I got involved in the case. And I was very proud of my client that he saw the child comes first. And little by little, we got his access expanded. 3 months here, get a couple days, expanded a little bit. And we finally concluded the matter. And I, went before Judge Armada, and I was so proud of my client. And Judge Armada said to him, young man, you got a monkey on your back. And you're going to have that monkey maybe for the rest of your life. And I'm sitting there saying, no, Judge, you're wrong. This guy is clean. He's never going to do it again. And wouldn't you know, about a year ago, the monkey took over. Judge Armada was right. And I think, I see that you're on the opioid committee with the judicial branch, and, that knowledge, obviously, you bring to the system. And that's very important. The Rules Committee, you're currently on the Rules Committee?
Yes, I am.
Then I have a request for you.
Please.
In the practice book, 25, there is no such thing as a cross complaint. It is a counterclaim, okay? It is a procedural defect that has appeared in the practice book from the beginning of time, okay? A cross complaint is when you have a plaintiff suing, or no, so action is brought plaintiff against defendant. There's two defendants, right? And then the defendants fight, right? That's a cross complaint, okay? In the practice book, it talks about cross complaint, but that never happens in a dissolution of marriage. A counterclaim is where somebody brings an action, plaintiff to defendant, and defendant brings an action back against the plaintiff. That is a counterclaim. So all of the forms say cross complaint, they are wrong.
I will raise it.
Please, please. I just had this in Waterbury, and I refused to file the document as a cross complaint because I know it's procedurally improper. So I would appreciate if we can get that fixed in the rules, and appreciate you being on the bench. And certainly, well, I won't be here on January 28th when we vote on judges, but you're a credit to the bench, and very much appreciate you being there. Thank you. Thank you, Mr. Chairman.
Representative O'Day.
Thank you, Mr. Chair. And you are the last of the family judges in current assignment. So that I'm going to ask this question. I promised to my members of the committee that I won't keep going on this family law tirade. But you're coming through. You've now experienced the family court system. What recommended changes would you make going forward, particularly in Stamford, which I know you haven't sat at, but what changes would you make to the family court system to improve it, if any?
I think there could be more dialogue about the process and about the expectations between the bench, the bar, and other partner holders, stakeholders type things, so that we're all working. I have learned from my friend, my colleague, my teacher, Judge Bozzuto, that we need to get families through this process as quickly as we can without rushing it, but so as to avoid damage and create bad things. And I think if we come at it from that point of view, okay, what do we need to do to get these people to resolution? And that's what I do at a case day, talk about where are we going with resolution? What do you need? How can we help you? I think having a dialogue so that the bar understands the way the court works, court understands some of the bar's concerns, I think that might help.
And you know, the questions that I got from, quite frankly, the chair when I first started here 13 years ago was Andrew McDonald, and he had always asked, and we had asked you when you first came here, if how you can assure us that robitis would not be an issue that you would be afflicted with. And so far, there is one letter that I saw who said, it says authorized for public disclosure, the testimony of Maureen Markowska. Have you read that letter?
Yes, I have.
All right. And to give yourself a chance to defend yourself based on this letter, what would you say in response to that letter?
So the Martauskas, I represented their granddaughter shortly after she was born. And then I haven't been involved in the case for 12 years. And I know the outcome is not what they wanted. It's not what I would want for a family. I want every family to be, you know, happy, healthy, good relationships. But for some cases that doesn't work. And so I think that's where that source is from.
And having done some GAL work myself pro bono, is there anything about GAL work that you would suggest we change or modify based on your experience?
I think the branch has done a good job in terms of training. I know we're limited in terms of the number of people we can use, the resources that people have. I don't want to give people big bills that they can't afford as a judge. You know, I didn't like it as a GAL in practice. Let's focus on what's important. I'd rather you save for college education or, you know, camps type thing. But that's become a problem is resources.
One of the things, big problems we see in Stanford is the confrontation between spouses and family. They want to spend each other dry. They want to get rid of the money. So that you have not served in Stanford. So I assume you haven't really seen that.
I've seen
much?
cases like that in my court and in private practice, because before I was a judge, I was a family lawyer for 30 some odd years. So
Is
I
there-
would see those.
Is there anything you would do as a judge if you could to, if you were going to legislate like we do to try and fix that?
When people come in front of me, I will tell them that, you know, we've got a custody battle here, but remember, even though I wear the black robe, I'm not the judge. The judge is the child. And think of how they're going to deliver their decision. Are they going to invite you to their wedding? Are they going to let you know you have a grandchild? Are they going to invite you? They're the real judges in this case. And you get to define their childhood. If we write it, then, you know, we're writing it. We want you to. But those kids, keep your eye on the prize.
Yeah.
Representative, give me a second. If you could move that mic a little closer to you, I just want to make sure you're projected. Thank you.
Thank you. I'm sorry.
And then the question I ask, or no, people in the committee ask, are you willing to serve if you're appointed somewhere differently, anywhere in the state, whether it's Stanford or anywhere else, if so assigned,
Absolutely.
and work at least 9 to 5?
Absolutely.
All right. Thank you very much. Thank you, Mr. Chair.
Thank you, Representative. Representative Osborne.
Thank you, Mr. Chair, and good afternoon, Judge Armada. It is such a pleasure to see you.
It's a pleasure to see you.
I've sat in my conference room with you, and I have appeared before you on the bench, and I don't have any particular questions, but I'm going to use this as an opportunity and hope that judicial selection is listening to me, because what I've heard from my colleagues, what I've heard both in private practice and here in the legislature, is what a difference you are able to make in your courtroom, because you brought 30 years of family law experience to the bench with you. And to be honest, it is a rare family law practitioner who gets through judicial selection. We have to scrape and claw to be taken seriously as attorneys, and to seem to have judicial selection value the necessity and the nuance of people who do this area of the law and do it really well. I have appeared before you, and I have found your decisions to be nuanced, balanced, and you get it. And that is not something, no matter how brilliant or well-intended a judge who has never practiced family law can bring into a courtroom. They may develop some of that over a lifetime of practicing in family court as a judge. But there are things that you learn as a practitioner that you can't learn anywhere else. And that shows in your courtroom. And I would simply urge judicial selection to take a look at you and to take a look at the difference that you've been able to make in people's lives, not just in the decisions you render, but in the advice you give to the litigants before you and the approach that you take with litigants, and realize how valuable that is when they are evaluating family law practitioners who come before them. And I'd love to see more candidates before us being nominated who have the extensive background that you have and the perspective you're able to bring and the benefit that that gives to the litigants before them. So thank you very much for being here today. Congratulations on your renomination. And I look forward to it.
Thank you for your kind words.
Thank you. Good to see you again, sir.
Thank you, Representative. Representative, I don't know, Mark Brown, yeah, sorry.
Thank you, Mr. Chairman. Thank you for being here today and congratulations on your nomination. I'm not an attorney, and so I've never been before you, and I hope to never be before you in family court. But my question, I guess, is given the age that the year we're in, 2025, and the family nucleus doesn't look how it used to some 20, 25 years ago, how have you adapted to the family nucleus, and how do you see your position as a judge of the family courts to understand that families don't look as the way they did some 20 years ago?
So I see that all the time. Various combination. I think it's a beautiful thing in terms of the way family has defined itself, a group of people who care about each other, take care of each other. And I try and hold that with respect and dignity and help them have self-autonomy. Family judges don't want to write children's childhood. We want the parties to do it. We want to empower them to do that. But we also want to recognize that for a child, you know, there's parents, and it's not one parent over the other. It's both or multiple sometimes. We have third-party access as well. So, and the more people who love a child, I think the better.
I would agree with you. And just my second question, if I may, how do you specifically deal with parties who are self-represented, for example? Because I think oftentimes we see in these family proceedings, folks who don't have the means to hire an attorney, they often represent themselves. Where do you see yourself, or how do you see your position for those folks who can't afford to pay for an attorney? And how do you help them, guide them through the process? Or you tell me.
So first off, when they're in front of me, they're nervous, they're scared. I acknowledge that. Second, I explain, okay, why are we here? Let's look at why we're here. What do we want to accomplish? You know, a big phrase of Judge Bozzuto is make court dates count. So you've taken the day off. What do we want to accomplish here type thing? What can we do to assist you? I educate them. If I'm doing a hearing, okay, we're here on a motion for modification or a contempt, and these are the standards the court has to apply. I do it with restraining orders. I do it with ex partes, so that everybody understands this is the laws I've got to follow, the rules set, and this is the way we're going to roll. Does everybody understand it? And once they have an understanding about that, it makes it easier to go back to the decision and say, remember when we said this is the standard, this is what the court finds.
I appreciate that answer. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee, comment or question from other members of the committee. If not, thank you very much for being in front of us today.
Thank you very much.
And we will next hear from the Honorable Matthew J. Budzik of West Simsbury. All right, if you raise your right hand. Do you swear or affirm that that the information that you'll be providing to the committee will be the truth, the whole truth, and nothing but the truth, under penalty of perjury? So help you God, under penalty of perjury?
I do.
You may provide us with your statement. Thank you.
Chairman Winfield, Chairman Staffstrom, ranking members Kissel and Fishbein, and distinguished members of the Judiciary Committee. I appreciate your consideration of my nomination for reappointment to the Superior Court. I want to thank Governor Lamont for renominating me to serve another term as a Superior Court judge. I am extremely grateful for having had the opportunity to serve as a judge for the last 8 years.
The experience has been intellectually challenging and at times stressful, but has nonetheless been very rewarding. I currently serve as the presiding judge of tax and administrative appeals in New Britain. In that role, I handle municipal real property tax appeals in the wide variety of cases involving the appeal of government agency decisions. Prior to administrative appeals, I was the presiding judge of the land use docket and a civil line judge in the Hartford Judicial District from 2018 to 2022. On the land use docket, I handled cases involving appeals from decisions of local planning and zoning and inland wetland commissions. As a civil judge in Hartford, I handled the wide array of civil cases involving personal injury contracts, medical malpractice, and other statutory claims. My first assignment as a judge was on the criminal domestic violence docket in Hartford from 2017 to 2018, and that was frankly my most challenging assignment. Out of the courthouse, I coached middle school and high school mock trial teams. I participated in the Read Across America program, and I coached Little League Baseball. I'm grateful for the opportunity to serve another term as a Superior Court judge, and I am happy to answer any questions the committee may have. I
Thank you.
appreciate your time.
Comment or question from members of the committee? Comment or question? I don't see Rep. O'Day for his traditional question, but I'll ask you to talk about temperament, and more important than just answering that question, everybody can answer that question, is what is your system of accountability?
Well, with respect to temperament, Senator, I keep in mind that my role as a judge is to be there to serve the people who appear in my court, not the other way around. Everyone deserves respect. Everyone deserves to be heard for whatever their concern is, particularly pro se individuals. I find that for the most part, people just want someone to hear what they have to say. And as a judge, it's my job to listen to them and try to discern what their concerns are and either work out a solution between the parties or, if necessary, to adjudicate the issue as best I can. With respect to accountability, I'm candidly, I'm not sure.
Yeah,
I understand the question.
I'll explain. Rep. O'Day has been asking the question about judicial temperament for as long as he's been on the committee. I think it's an important question. I think it's a pretty easy question to answer. The more difficult question usually is what systems of accountability do you have in place to make sure that you actually do the things that you say? And so that's my addendum to his question that I've begun asking in the last 2 or 3 years.
Well, I think I review my own actions on a day-to-day basis to make sure that I'm cognizant of the decisions that I have to make, and then I review the law that applies to them. I always make sure that I read the briefs and that are submitted to me. Most of my practice now is an appellate practice, but I make sure that I am answering the questions and adjudicating the cases that the litigants are putting before me.
Okay, are there questions or comments from other members? Representative Fazzino.
Thank you, Mr. Chair. Judge Budzik, thanks for joining us this afternoon in your nomination hearing. I'm familiar with your work on the land use docket as well as a property valuation docket. And I think what's interesting about those specific areas of practice is that you're dealing with very hyper-technical issues. You're dealing with potentially some very unique facts, and you're also acting as the primary fact finder in those actions. And so I'm just wondering if you could elucidate for the committee some of those very helpful best practices and techniques that you utilize in these particular areas of law to act as the fact finder, to stay engaged on very technical legal issues, and also to get your legs under some of the more complicated facts that go into these valuation cases and these land use cases.
Well, let me take that in two parts. With respect to the statutory issues, land use cases, as you say, those can be very complicated. I mean, I find for me, the easiest way to deal with these issues is to make sure I understand what the rule of decision is, which is the parties will frequently want to explain the case to me. And that is somewhat helpful, but I want to know what the issue that around which the case turns and what the rule of law is that I'm applying. And then look to the facts as to how that, how those facts fit into that rule of law or what the applicable case law will say. So particularly in administrative appeals and the land use appeals, it was not uncommon for the administrative record to be 18,000 pages long. So there's a lot to go through. So for me to help me make a decision is keep an eye on what rule of law am I actually applying and what facts are relevant to making that decision, and sort of push away all the other sort of side issues that either the litigants aren't contesting or aren't relevant to that sort of decision. With respect to the real property tax appeals, I mean, a lot of that comes down to common sense, which is to say, you know, what as, you know, using human experience and common sense and reasonable inference, what a reasonable buyer would consider to be relevant to a personal house. For example, I had one case recently where the homeowner disclosed that they had rattlesnakes on their property. That was not included in the appraisal, but I think my wife would certainly consider that in the price that she was willing to pay for a house. So for those kind of things, for real property tax appeals, when it's a personal property, a lot of it is common sense as to sort of what anyone would consider relevant to a purchase of a house. When it's a business, income and expense statements, what the capitalization rate is, those are always the critical issues. Again, you want to make sure that you're dealing with, I mean, my preference is to deal with the actual numbers, not estimates. It is common that in a real estate or a real property tax appeal that there's as much as 30% difference between two appraisers that have 30 years of experience and have been appraising properties in that location for 30 years. You have to sort of wade through that, and as I said, my preference is to look what the actual facts are that property is experiencing.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us this afternoon. Next, we'll hear from the Honorable John L. Cordani of Walcott. All right, if you'd raise your right hand. Do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
You may provide us with your testimony. Yes.
Thank you. Good afternoon. My name is John Cordani. I'd like to start by thanking co-chairs Senator Winfield and Representative Stafstrom, Vice Chair Senator Flexer, Senator Gacker Wilcox, and Representative Fazzino, and Ranking Members Senator Kissel and Representative Fishbein, as well as all the other members of the committee for taking your time to consider my renomination for my reappointment to a judgeship within the Superior Court. I'd also like to thank Governor Lamont for renominating me. I've been a judge now for one term, and I've found my experience to be a deeply fulfilling experience as a judge. I enjoy meeting our fellow citizens and providing them with assistance in resolving their disputes in a just manner in accordance with our law. I found my work with the staff of the judicial branch to be quite pleasant and fulfilling. Geographically, I've been assigned to courthouses in New Britain, New Haven, Bridgeport, and Waterbury. And over my time as a judge, I've been assigned to practice areas of criminal, juvenile, housing and foreclosures, administrative and tax appeals, and civil litigation. Currently, I'm assigned to Waterbury, the Waterbury Judicial District, as its administrative judge and as the presiding judge for civil litigation. I've served the judicial branch as a member on its executive, education, and jury instruction committees. Prior to becoming a judge in 2017, I spent about 25 years practicing law as a corporate attorney and as a civil litigator, and about 5 years before that practicing as a chemical engineer. Personally, I've been married for 38 years. I have 3 grown children and 6 grandchildren. I grew up in Waterbury and have lived in Wolcott for the last a little more than 30 years. I regularly participate in Read Across America as well as moot court competition. I serve as a mentor for two newer judges. And it's been an honor and a privilege for me to serve the people of Connecticut. And I would be very grateful if you would see fit to approve me for another term as a Superior Court judge. I'm happy to answer any questions you may have.
Thank you. Comment, question from members of the committee? Comment, question from members of the committee? I'll just put forward the same question I asked of the last participant. It is about temperament and also your system of accountability.
Sure. I would say, as a general philosophy, both in my personal life and in my professional life, I strive to treat people in the manner which I would like to be treated. And so I keep that in mind. I genuinely care about the people that come before me, and I try to communicate that to them. When people come into my courtroom, as far as accountability, I make sure that I welcome them into the courtroom. I make sure that I address them by their names. For self-represented parties, I make sure that I take time to explain to them generally what they're here for and what procedurally they can expect at the time. I give them a thorough assurance that when it's their time to speak, that I'll listen to anything that they'd like to tell me and that I will give it very careful consideration. I go through any particular statutory requirements or whatnot to make sure that they're up to speed or at least have some sense as to what they need to, what evidence they need to put forward if that's what's going on. And so I also am very aware that as a judge, I'm a public servant. I'm here to represent the people of the state of Connecticut and to provide service of resolving conflicts in accordance with our law to the litigants and the attorneys that are before me. And so I keep that in mind continuously.
Thank you. Comment or question from members of the committee? Comment or question? If not, thank you very much for joining us today.
Thank you very much.
Next, we'll hear from the Honorable Matthew D. Gordon of West Hartford. You raise your right hand. Do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, nothing but the truth, so help you God, or under penalty of perjury?
Yes, I do.
You may provide your statement.
Thank you. Good morning. Chairs Winfield and Stastrom, ranking members Kissel and Fishbein, vice chairs and other distinguished members of the Judiciary Committee. My name is Matt Gordon, and I want to thank you for the opportunity to appear before you this afternoon. I also want to thank Governor Lamont for nominating me to continue serving as a judge of the Superior Court. I have found the experience rewarding and enriching, and I would be honored and privileged to continue serving. I began my service as a judge 8 years ago, covering the criminal docket in Rockville, and after 18 months and ever since, I've had the privilege of covering the civil dockets in Waterbury, Rockville, and now Hartford. During my time as a judge, I presided over numerous jury trials to verdict. I've written numerous decisions, and I've had the opportunity and the privilege to assist numerous people resolve their disputes by way of negotiated resolution. And I will say, of all the things I do as a judge, I think that's the thing that I enjoy most and appreciate most. In addition to my time on the bench, I've remained active in the greater legal community. I am currently serving as the incoming president of the Oliver Ellsworth Inn of Court. I'm also an active past president of the Hartford County Bar Association, which is the oldest continuously operating bar association in the United States, the fact of which we're very proud. I'm also privileged to serve as a member of the Board of Directors for the Connecticut Hispanic Bar Association and the Connecticut Judges Association. I'm also privileged to serve on the Connecticut Bar Association Civics Education Committee, which I joined many years ago with former Secretary of State Denise Merrill. I also am a founding member of the Connecticut Bar Foundation Catherine E. Rohrbach Circle, and I volunteer for the Connecticut Judicial Branch Civics Academy and Read Across America programs. It's been an honor and a privilege to serve as a judge of the Superior Court, and I would be honored and privileged to continue serving, and I would be honored and privileged and frankly quite grateful to this committee to receive your support in my endeavor to continue serving. So with that, I would like to thank you for your time and for your attention and for your consideration, and I'd be happy to answer any questions.
Thank you. Comment or question from members of the committee? Comment or question, Representative O'Day?
Thank you very much, Mr. Chair. Good to see you, Your Honor.
You as well.
Full disclosure, I think actually, it was probably a number of years before you got to the bench. We tried a case together.
Yes, we
in
did.
Middletown.
Yes.
And I will tell members of the committee and public may not know, but your temperament, intellect, experience is phenomenal. You are a credit to the bar. You settled a very difficult case that we had in chambers at the end of the day after what, eight hours of mediation. So just a couple of standard questions I'm asking everybody.
Yes.
First, are you willing to serve anywhere assigned, even family in Stamford?
Yes.
All right. A little bit of a pause there for the record, but I understand traffic is difficult. And are you willing to work at least 9 to 5? I know having experienced you are willing to do that, but just for the record, are you willing to work at least 9 to 5?
Yes, sir, I am.
You've never served in family, correct? You did criminal?
I covered the GA for 18 months, and no, I have never served in family with the minor exception that Rockville is a block assignment, and I covered a few things in family, but very few. And I frankly must say, I admire the people that practice in the judiciary in family and juvenile. I frankly don't know how people do it. I admire them.
Well, you may have the opportunity at some point.
Maybe.
The one thing I haven't asked, and I meant to of some prior, and I just ran out to get some lunch. I'm sorry.
That's okay.
I see that there were 6 complaints, but they were all dismissed.
Yes, sir.
Was there any common theme in those, or? And obviously they were all dismissed, but anything that you learned about from them, or how would you explain? Now, 6 is not. There's a number of people that have more than that, judges. But was there anything? It's been 8 years, so 6 is not on the higher end by any means. But was there anything about those complaints that had you alter or change anything you do as a judge? It's a kind of a loaded question, I guess. But
listen even more carefully, try even harder to treat everyone with respect. 2 of those were prisoner cases. I have not had any complaints filed with the Judicial Review Council in the last couple of years, so hopefully I've learned something.
Well, as somebody who knows you, I know that you've got the perfect temperament and experience and education intellect. So thank you for your service to the state of Connecticut, and I appreciate the governor renominating you.
Thank you very much, Representative O'Day. I greatly appreciate that. Thank you.
Thank you, Mr. Chair.
Thank you, Representative, and you'll be happy to know in your absence, I asked your question for you. Representative Brown, and I apologize for a moment earlier. I know who you are.
No worries, Mr. Chairman. I don't take anything personal. Thank you, Judge Gordon, for being here today. You mentioned in your questionnaire, I believe it was question 9, that when you talked about the parts of the job you enjoyed most, you mentioned representing or being there for self-litigants. I think they call that pro se. I'm not an attorney, but when we think about your courtroom for
Yes.
example, how do you balance judicial efficiency to make sure that all clients get their opportunity in court, especially when you are pro se, but also make sure that you're moving in a timely manner and getting through the docket? How do you specifically balance that in your courtroom?
That's a great question. I think if I were to err on one side of that, it would probably be spending more time listening to make sure that everyone feels and believes that they've had their day in court and that they have been listened to. But you're right, the business does need to keep going, but frankly, I do want to make sure, especially with self-represented parties, that they know that they've got my full attention.
I appreciate that answer. Thank
Yeah.
you, Mr. Chairman.
Thank you. Further comment or question? I'll just follow up with my follow-up to Representative O'Day about the system of accountability you have in place as it relates to that question.
Yeah, I've been thinking about that, and it's an interesting question. I think for me, what I do is I constantly remind myself and frankly articulate it out loud, especially to the lawyers, that I took a vow when I came onto the bench to never forget what it's like to be a active civil trial lawyer. I did that for 30 years before coming onto the bench. I know what that's like. And as far as accountability, I guess I take that one step further and constantly remind myself in the particular situation how I would want to be treated if I were the lawyer or I were the litigant. And I can tell you, etched indelibly in my memory are the times that I remember when a judge treated me, my client, and the other people fairly and made it clear that the case was going to be decided solely on the facts and the law. And I remember those people, and I try to bring that spirit into the courtroom and hold myself to that standard.
Thank you.
Thank you.
Comment or question? So comment or question from members, comment or question from members, seeing none. Thank you very much for being here with us.
Thank you, Chair Winfield. Thank you very much.
The Honorable Ernest Green Jr. of Norwich. To learn how to turn the microphone on. Do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
You may provide your statement.
Good afternoon, Senator Winfield, Representative Stafstrom, Senator Kissel, Representative Fishbein, Vice Chair Flexer, and all the esteemed members of the Judiciary Committee. My name is Ernest Green Jr., and I'm happy and honored to be before you today. I would like to thank Governor Lamont for nominating me for a second term as a Superior Court judge. After my appointment in 2017, I was first assigned to GA10 in the New London Judicial District, and then assigned about a year later to the Wyndham Judicial District Family Court in Putnam, where I sat for the next 4 years. After Family Court, I was assigned to GA10 again for the term that began in September of 2022. I was asked in April of 2023 to serve as a temporary administrative judge in Wyndham prior to being designated as the administrative judge for that district as of September 2023. Wyndham is a block assignment district where all are eligible to cover civil, criminal, family, or juvenile matters. I'm the Part A criminal judge, but I also cover the GA and other matters as necessary. Outside of court, I am a James Cooper Fellow of the Connecticut Bar Foundation and sit on several committees: the Education Committee, the History of Women in the Legal Profession Committee, the Attorneys of Color Committee, and the High School Essay Contest Committee, for which I've also been a judge. I'm on the Rules Committee of the Superior Court, the Judges Education Committee, the Executive Committee, and I was appointed to serve on the Psychiatric Security Review Board Work Group. I'm a member of the Wyndham County Bar Association, and I'm the co-chair of the Health and Wellness Committee of the Connecticut Judges Association. I've been a mock trial judge. I have volunteered for Read Across America, and in my spare time, I also teach spinning classes, and I have a yoga teacher certification. With your approval, I would be grateful for the opportunity to serve as a second term as a Superior Court judge, and I would be happy to answer any questions that you have.
Thank you. Representative O'Day. I was waiting for you.
Thank you, Mr. Chair. Hello, Your Honor.
Good morning. Good afternoon, sorry.
Congratulations. Yeah, congratulations on your nomination. And going through, I didn't see any written testimony opposing you. I did just I want to ask the same question I did of Judge Gordon on the complaint list. It looks like there were 5 complaints all dismissed.
Yes.
Over your 8 years, and obviously that's not a spike or anything. I don't want anybody to think that's unusual. In fact, doing criminal work like you have, that's certainly not uncommon. Was there any common theme to those complaints or anything that you've changed during your time as a judge because of any of the complaints?
Well, I guess the first answer is that there wasn't a common theme to the 5 complaints were different. The 2 that came from criminal, actually, the first was because I didn't allow an individual to tape with his iPhone, and he was upset by that. The second was an individual thought that I could not put a bond on him, though he had been arrested for domestic violence and had a history of failing to appear. And the third was a sovereign citizen who believed that I violated his rights under the 14th Amendment, not by doing anything in particular. I had 2 complaints from family court, and neither of them were about demeanor. The one litigant was unhappy with how I divided the assets, and I think that's what he brought to the review commission. And the other individual was a particularly difficult litigant and had filed complaints against, I think, everybody in the courthouse, including myself. But I did, I took that as an opportunity to learn something about myself, to think about what they had said. I read those complaints, took them seriously, and to the extent that I thought that there was something that I had done, I was certainly willing to change those things.
That's about as good an answer as you can give. So thank you for that.
Yeah,
and then the question that generally I ask of all is robitis. You know, you've been sitting on the bench now for a number of years. And none of the complaints involved your temperament, correct?
That's correct.
And just having the brief conversation we've had, I can tell that you don't generally suffer from robitis. So is it fair to say that you're humble enough to notice if that was getting out of control?
Yes, I think I've always, as an adult, have intended to be on good terms with all persons. I think that my reputation as a judge is that I have a calming influence on folks. I try to kind of dampen anxiety. I'm aware of how anxious people are when they're in front of me. I'm always cognizant of that. I think that I'm a very good listener, very receptive, very open, while still being efficient. So I don't anticipate developing robitis as I go through it.
And I have actually gone up to Wyndham. It's a long drive from Stanford. So are you willing to serve anywhere assigned, even if it's family in Stanford?
Yes. In fact, Putnam is often known as the sort of like the opposite of Stanford in terms of geographical undesirability for judges. But I was happy there when I was there. It's not a long commute for me. I was always very happy in Putnam. Glad to be a part of the Wyndham Judicial District.
And you're willing to work at least 9 to 5?
Of course.
Okay.
Absolutely.
Well, again, congratulations on your nomination, and thank you for your responses. And thank you, Mr.
Thank you,
Chair.
Representative O'Day.
Thank you, Representative O'Day. Senator Flexer.
Senator Flexer.
And thank you, Mr. Chair. Good afternoon.
Good afternoon. Nice to see you again.
Nice to see you too. I just have a few questions as the presiding judge in the Wyndham Judicial District. Are there any judges who live in Wyndham County?
There is one judge that lives in Wyndham County. We have one resident judge, that's Judge Newsom, who is the presiding criminal judge and administrative judge in New London.
Okay, so you sort of have opposite.
Yes.
Got it. Well, I just wanted to say that I have taken several opportunities to be in your courtroom, sitting in the back row, sometimes at the request of crime victims, particularly domestic violence victims. And I wanted to say publicly how much I was impressed by the way you run your courtroom. And I think all of us who serve on this committee, whether we're attorneys or not, anyone in the legislature, frankly, should take an opportunity to sit in the back row and watch what happens in court. And the days that I've been there, unfortunately, are you were seeing some of the most, to my mind, heinous, awful, violent cases, and trying to make determinations in those cases where horrible acts of violence had been committed and where there was real trauma inflicted on not just the victim, but the entirety of their families. And watching the way that you dealt with those cases was really impressive. And so I just wanted to state that publicly, given that you were here today for your reappointment, and to say how lucky I think we are. Most of my Senate district is in the Wyndham Judicial District, and we're very lucky to have you serving as the presiding judge in our area, where there are a lot of really complicated matters and difficult crimes that take place in our part of the state. And I'm impressed by the way you approach your role as a judge.
Thank you, Senator Fletcher.
Thank you, Senator Fletcher. Comment or question from other members of the committee? Comment or question? I think you kind of know what's coming, which is my question. It's about system of accountability, but I'm going to preface the question with a statement. So I've been asking this question for a couple of years, and what I'm looking for is something external to the individual sitting in front of me. We have from time to time had persons who we have put forward who've been able to answer the question about robitis and who, quite frankly, have done really well until a point at which something happened that, for whatever reason, they did not respond the way they thought they were going to respond. For whatever reason, their self-checking didn't work, right? I think it's important for all of those who are sitting on the bench with the immense power that you have, with the people who come into your court perceiving you to have a lot of control over some area of their life, to have something external to, I just check myself, in play. And so that's what I'm getting at. So I did not preface it this time. I usually do, but I've done it long enough that everybody should know that that's what I'm getting at. But I just want to, for the rest of the hearing, make sure that folks understand what I'm looking for. You may answer.
Well, I have when I'm in court in Danielson, we have an arraignment link that is basically, we're broadcasting through the building. And there are individuals who are watching at all times. If something comes up that's particularly contentious, I'm always aware of who I am relative to the persons that I'm dealing with. My goal is to not react to people, but to respond to individuals. And I know that people are upset, people are anxious. I was in family court for 4 years, and people would come after me, just in terms of, they would be angry with the marshals, they would be angry with family relations, they would be angry with the court. And it's my job is to sort of figure out where they're coming from and then respond to it. So if there's something that they're looking for, that I can give some sort of answer that isn't just me reacting to them. I'm committed to that. If I said something that was even on the edge of that, I would check that with the court staff, for instance. I think I have great relationships with the clerks that I work with. The other judges are perhaps watching. The judge's secretary is always watching. So I'm always open to feedback about how things go or how things are going. When I was in GA10, the chambers is pretty much right in GA10. And there are people in and out of the office all the time. So I was able to get a sense of not only how I was feeling about how things were going, but how people were reacting to me, the victims, the defendants, the state's attorneys, the public defenders, all of those people. And I take my responsibility to all of those individuals very seriously. If I was having a good day or a bad day, no one should be able to tell that on the basis of how I was interacting with people from the bench. And maybe that's not everybody's position, but that's what I'm committed to. So I've been a public defender. I've had judges in front of me who were very strict and very difficult to deal with sometimes. I will leave all of them nameless, but I never wanted to be that guy, and I'm not. And if I ever thought I was, then I would ask for some sort of assistance with that. So I think that robitis is something that I have not developed. And if I think I was moving in that direction, I would think that was not who I wanted to be. And then I would go and check it with somebody else. And I think that judicial has great resources that are available for individuals who need some assistance.
Thank you. Comment or question from other members of the committee? Seeing none, thank you very much for joining us this afternoon. The Honorable Karin L. Clatt of Meriden. When you're ready, raise your right hand. Do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, nothing but the truth, so help you God, or under penalty of perjury? You may provide your statement.
Excuse me. Good afternoon. Senator Winfield, Representative Snatcham, Senator Kinsel, Representative Fishbein, and members of the Judiciary Committee. I want to thank you for the opportunity to appear before you today. I also want to thank Governor Lamont for his consideration in nominating me for a third term as a Superior Court judge. Over the past term, I have served in Meriden Superior Court as part of a block assignment handling family and criminal and civil matters. I was then assigned to New Haven and Harvard Superior Courts handling family matters. For the past 6 years, I've been assigned to criminal matters, mostly as a trial judge in both Tallinn and Waterbury Superior Court. It is an honor to be nominated as a Superior Court judge. Serving as a Superior Court judge is a challenging and yet worthwhile experience. I would be honored and grateful for the opportunity to continue to serve the state of Connecticut for an additional term. Thank you again, and I would be happy to answer any questions.
Thank you. Comment or question from members of the committee? Comment or question, Representative O'Day.
Thank you. Thank you, Mr. Chair. Hello, Your Honor. Good afternoon. I just want to say a couple of things here. I want to thank Attorney Ed Gavin has, for the CCDLA, provided comments, and a number of people, including Attorney Gavin, had spoke out on your behalf of what a fair and excellent jurist you are, which is consistent with how you were as a prosecutor. I always like to ask questions. When I was on judicial selection, I would reach out to people that who are on the opposite side of someone to find out their temperament and demeanor. And the fact that Ed Gavin and a number of criminal defense lawyers spoke very highly of you when you were a prosecutor and as a judge, I think speaks volumes. So congratulations on that.
Thank you. I think that
and I saw that you had I think only 3 complaints that were all dismissed. Was there any common thread among those complaints, if you remember?
no, there's no what I would call common thread. One was a criminal matter. It was a complaint regarding the sentence that was imposed. One was a family matter, sorry. And I think it was in response to a series of contempt motions that were rendered by the court. The third one was a habeas action. Again, I think it was just in response to a ruling by the court regarding an appointment of counsel. You know, you take all of them seriously in each circumstance, but there's no common theme in them.
And I meant to ask this of Judge Green. Having sat on family, is there any suggested changes or recommendations you would make to us as a legislative body on how we might be able to fix it?
Wiser minds than mine. To be quite honest, I haven't sat in family in quite some time, and there have been a number of changes that have been made in how family cases are processed since I've been there. You know, as everybody has said, it's an emotional docket, it's a difficult docket, and, you know, you approach each day with calm and a determination to just follow what the law is. I don't know that I would have any specific recommendations. I certainly follow Judge Bozzuto has been fabulous. She was fabulous as a family court judge leader, and she works well and teaches us well in how to handle these types of dockets.
And are you willing to serve anywhere in the state in any capacity, even as a family judge in Stamford?
Certainly, I would do that.
All right. And you're willing to work at least 9 to 5?
I always work more than 9 to 5. That I was used to.
And then lastly, the temperament issue. I haven't seen any negative comments about you and temperament. And I'd ask, I'm sure when you came through the first time, I had asked the temperament issue. Have you received any complaints about your temperament, or are you aware of any complaints about your temperament?
No, every day I'm cognizant of the fact that we're the face of the courtroom. Everybody's looking at you. So you become cognizant of that and you strive to be in charge, in control, but respectful of everyone. So I've not heard, or certainly there's been no direct complaints regarding my demeanor. I do try to treat everybody with fairness. Everybody that comes before me has the right to talk, and I have the responsibility to listen to them.
Well, thank you very much for your responses, and congratulations on your renomination. Thank you, Mr. Chair.
Thank you, Representative O'Day. I'm going to question from other members of the committee, comment or question. I would pose the same question I've been posing everyone to you, your system of accountability as it relates to that question.
Well, I certainly have had the opportunity to listen to other responses, and I don't know that I can be more articulate than my fellow judges, but I think every day, as I said, the responsibility of the court is to listen to the people, to listen to both sides. As a trial judge, that's, I'm in a unique situation. I don't have, oftentimes don't have an audience watching my every move, but I have that responsibility to listen to it for right now, the state and the defense, to listen to all their arguments, to follow through on the caseload that they submit to me, and to make a decision based on all of that. I want everybody to know that comes before me that they have a right to be there, that they have the right to be treated with respect. And, even the witnesses that come in, you have to tell them, just breathe, just breathe. It's our justice at its best, right? In the trial.
Thank you very much. I don't see any further questions, so thank you for joining us today.
Thank you.
The Honorable Kimberly A. Knox of West Hartford. When you're ready, raise your right hand. Do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, nothing but the truth, so help you God, or under penalty of perjury?
I do.
You may provide us with your statement.
Thank you and good afternoon, Senator Winfield, Representative Strastrom, Senator Kissel, Representative Fishbein, and all the distinguished members of the Judiciary Committee. I am happy to be before you here today for your consideration of my renomination. I would like to take a moment to thank Governor Lamont for nominating me for my second term as a Superior Court judge. During my first term, I was initially assigned to the criminal docket in GA 21 in Norwich for approximately 1 year. I was then assigned to the civil docket in New London for a little over 3 years. In September 2021, I was assigned to the civil docket in New Britain, where I currently am the presiding judge of civil and also the administrative judge. I have had the privilege of serving on various judicial committees. I am the chair of both the Civil Jury Instruction Committee and the Judicial Ethics Committee, and I have served as a member of other judicial committees. Outside the courthouse, I was a member of the Oliver Ellsworth Inns of Court, and I am presently an adjunct faculty member at the UConn Law School. I consider it an honor and a privilege to serve the people of the state of Connecticut as a Superior Court judge. I would be most grateful for the opportunity to continue to do so in another term, and I am happy to answer any questions that you may have.
Thank you. Comment, question from members of the committee. Comment or question from members of the committee. Representative O'Day. See, I'll wait for you.
Thank you, Mr. Chair. Good afternoon, Your Honor.
Good afternoon.
Congratulations on your renomination. You've heard me asking the same general question. I see you had one complaint dismissed. Generally, what was that about?
That was the individual was unhappy with a procedural decision I made on a motion to continue a matter and filed the complaint.
And was that a represented party or unrepresented party?
Had been represented up until that day. It was in the middle of a jury trial, and the person had come in and had requested that their counsel withdraw We were in the middle of evidence and the individual wanted to continue the trial.
And how, I will say normally, was the other side opposing that
The
motion?
other
for
side
continuance?
did oppose it.
I will say normally if two sides agree to a continuance of some matter, is that something generally you are amenable to?
Obviously, yes. There's always good cause, especially when both sides are agreeing.
And I will say to anybody listening out there, and especially the judges, I did have a situation where a court trial was scheduled without input for the parties, and I moved for continuance. The other side agreed with it, and the judge denied it. So I'm particularly sensitive to that, to the issue. So it's good to hear that generally when people consent, both sides consent, that you would grant it. And having explained in the middle of a trial, I can understand why you wouldn't grant that continuance. Have you, it looks like you have not served in family court yet.
I have not.
Are you willing to serve anywhere in the state, even in family court in Stamford, if so assigned?
Absolutely.
And are you willing to work at least 9 to 5, Monday through Friday?
Definitely.
All right. I don't have any further questions. Thank you very much, Mr. Chair.
Thank you, Representative O'Day. Comment, question from members of the committee, comment, question from members of the committee, and my question. The system of accountability associated with the question of robitis or judicial temperament.
Senator Winfield, I have to share the comments of my prior colleagues who have responded to you. To me, the role of a Superior Court judge is a very humbling role. Litigants come before us with disputes, and our job is to serve them. Our job is to be knowledgeable about the law, be respectful to the positions and the claims and the arguments they make, and to listen to them, whether they're represented by legal counsel or representing themselves. So I feel like I have in place many different ways to check the accountability with regard to both demeanor and with regard to providing a timely and efficient and prompt administration of justice. So the parties have their cases heard in a timely manner. So I think there's two components to accountability. One is the demeanor of the judge, and I hope I've responded to that. And the second is to the administration of justice, which needs to be managed, and we need to respond to the needs of the parties in doing so.
Thank you. Comment, question from members of the committee, comment or question from members of the committee. Seeing none, thank you very much for joining us.
Thank you very much.
Enjoy the rest of your day. Next, we have the Honorable, I think I lost my place once again. The Honorable Sherie Murphy. Oh, no. Yeah, Margaret Murphy first. That's right. Of West Hartford. Thank you. Do you swear or affirm, as the case may be, that the information you provide to the committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury? You may provide your statement.
So good afternoon, Chairman, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and the other esteemed members of the Judiciary Committee. I thank Governor Lamont for nominating me to serve another term as a Superior Court judge, and I appreciate the opportunity to appear before you today. I was appointed to the bench in May 2017. Since then, I have served as a judge in Manchester, Hartford, New Haven, and Rockville. My assignments have been in the criminal, family, habeas, and juvenile courts. I am currently serving as the presiding judge for juvenile matters in Rockville, where I handle delinquency and child protection cases. I consider it the honor of my legal career to serve the people of Connecticut as a Superior Court judge. I would be grateful to this committee and the General Assembly if I am appointed to serve another term. You have my questionnaire, and I am happy to answer any questions you may have.
Thank you. Sorry for the mix-up.
No.
Representative O'Day.
Thank you, Mr. Chair. Good afternoon, Your Honor.
Good afternoon, Representative O'Day.
Good to see you. And full disclosure, I did work with your husband, but I don't see as a conflict such that it's been decades since we worked together. So a couple questions on the 6 complaints that you've had. 5 were dismissed and 1 is pending. Were there any common themes with those complaints that you were aware of?
I think that the 5 that were dismissed were people who were just not satisfied with my ruling. They didn't appeal, but they filed a complaint instead. So I think that was the theme. The most recent one was what I would describe as kind of a sovereign citizen in juvenile court. And, you know, just, and I think the issue there, and I ended up recusing myself from that case, the most recent one, and sending it on to Middletown Child Protection Session. But I think the issue was just didn't want to be in court, disagreed that court had jurisdiction over them, and wanted to argue that point every court date.
What is the CHRO complaint?
Oh, that was someone who it was a habeas case. They had a disability, they claimed, and they wanted counsel. But they kind of didn't go about it the right way. They didn't file a complaint with the Judicial Review Council. Instead, they filed it with the, CHRO, which was eventually dismissed.
And there's a letter from an individual who has given us information on a number of judges, but I don't know, have you seen any of the letters there's at least this one letter in opposition to your reappointment?
Yes, I'm familiar with that litigant.
All right. And what would you, not to focus on it, but in response to the complaint, what would you tell this committee?
The litigant, the courts have had to put limits on him and his ex-wife filing motions in court because they're so litigious and I guess I would describe it as frivolous. I had a contempt motion filed on behalf of the ex-wife because he wasn't paying what he was supposed to be paying. I did find him in contempt. It was affirmed on appeal. And so he wasn't happy with that. He disagreed with that.
And having had some experience with family matters, is there any changes that you would recommend going forward? Obviously, you can tell that's a theme here. I do think we need help in Stamford, at least family from what I've been told. And I'm wondering if you see any opportunities of either fixing or changing the system.
I think since when I came on as a judge, it was just changing from the old guardian ad litem system to the new system with the family relations officers. I think the family relations officers do a fantastic job of working with the litigants before they get into court. It doesn't, 90% of people, that's my figure, get through family without too many problems. But there are a significant number that take up a lot of the court's time. But I think the courts, the branch is on the right track of trying to help people before they get into court, try to get them to reach a resolution of their issues. Whenever I would give the advisement in Hartford Family Court, I would tell the litigants, and many of them, as you know, are not represented by counsel. I would say, this is your opportunity to fix this for your family. I don't know your kids' soccer schedules. I don't know their school schedules. If you can't reach an agreement, I will make a decision, but it would be much better if the two of you could reach that decision together. Doesn't always happen. The only thing that I would suggest, Representative O'Day, is find a pot of money and give people representation like we do in juvenile court. I think that would help people tremendously. I don't know if that's feasible.
I'll speak with my friends on the other side of the aisle on that issue. Just for the record, obviously a little tongue in cheek with that. And having known you and I've going through, I know this isn't an issue, but how can you assure us that robitis will not be a problem going forward for Judge Murphy?
Well, when I get these complaints, I do take them seriously, and I do review them to consider, was there anything I could have done to prevent this complaint? When I get a decision from the appellate court, even if I'm affirmed, I review that decision to see, was I on the right track? Did they have any other suggestions? So there are steps that I take, to make sure that I'm on the, my demeanor's appropriate. I talk to other judges, and just say, what do you think? So, and then, there are cases that keep you up at night, that, you're like, am I handling this right? Is this what's right for, especially for the children? Is this right? So, I do think I have that internal compass, try to do the right thing by the litigants, try to, as everyone has said, listen and listen more than you speak. That's how I handle it.
I very much appreciate that self-reflective response. And speaking of Stanford Family Court, are you willing to serve anywhere in the state as assigned, including Stanford Family, if so assigned?
Yes,
Right. And are you willing to work at least 9 to 5, Monday through Friday?
yes.
All right. Thank you very much for your responses and your time here, and congratulations on your renomination. Thank you, Mr. Chair.
Thank you.
Thank you, Representative O'Day, Representative Osborne.
Thank you, Mr. Chair, and good afternoon, Judge Murphy. Thank you for being here.
Good afternoon.
It has been several years since I have seen you live and in person. I think I knew you and met you in your first assignment, I believe, in Hartford Family back in 2017, 2018.
So my first assignment was in the Manchester GA 12.
Ah, okay. So
And then
second
my
assignment.
second assignment was in
Second
Hartford
assignment
Family.
in the Hartford Family 2017, 2018. So obviously you've had many years of your career on the bench since then. And it was certainly one of your first assignments, but I do want to return to a question that Representative O'Day asked, and that was, and it's a delicate question area, but I have to say, there are a number of complaints on your questionnaire. And although they do all seem to have been dismissed, and you've already, represented that there was no common theme among them, I have to ask, is there anything, it doesn't seem like you spent an especially long time in family court, which does seem to engender a lot of complaints. And is there anything that you can reflect on that you have learned since 2017, 2018, since the beginning of your career on the bench? Is there anything that you can reflect on that you've learned that you might do differently with litigants than perhaps you did at the beginning of your career? Or is there anything that you think you may have, is there any approach that you take that you feel may engender some of why people end up filing complaints?
Well, what I try to do now more than ever is listen more than talk. And that's what I try to do.
And do you think is that a difference in the way that you began your career on the bench? Do you think that's made a difference with how litigants perceive you?
I'm not sure how litigants perceive me, so I'm not sure I can answer that question.
Well, there seem to have been a lot of complaints on this particular questionnaire compared to what we see with the questionnaires that come before us. So oftentimes you can deliver bad news to somebody in several different manners. And I'm very minded of a case I had recently, and I was reminded of this, that, clients remember the outcome, but they remember how you feel, how you make them feel, I should say. And I remember recently I had a case where I did a whiz-bang incredible job on this case. I got a phenomenal result, but on reflection, I was probably a little short in my demeanor with this particular client who was really struggling with getting to a settlement. And I probably delivered tougher love than I should have in trying to get to that result. And I had a really good, honest conversation with my client afterward, who said, you didn't need to be quite that direct with me. And I thought about it because I had gotten such a good result for this particular client. And yet what she was focusing on is how I made her feel, right? So there are lots of different ways that I could have delivered that same advice, perhaps with just a different approach. And I'm wondering if you've had that opportunity for self-reflection, or if when you say I listen more, or I listen, have you had any opportunities like that to reflect, or to do you think that's impacted any of the reasons that you've had complaints?
So as I said, when I get a complaint, I do review it. I do know, I know all the cases that these complaints came out of. And, you know, so I do reflect on them. So I don't know if that answers your question, but.
Well, thank you very much. I appreciate your congratulations on your renomination. No further questions.
Representative Stavstrom.
Thank you, Mr. Chair. And thank you, Judge. Judge, I just I want to start by offering my, I don't know if condolence is the right word, but my sympathies. I know you were recently the subject of a threat, and you know, unfortunately, it seems those are becoming more and more common against any number of or any manner of folks in the public eye these days, and in service to our state and to our nation. So I want to extend my sympathies on that, and let you know that, you know, this committee takes that seriously. We've been looking at ways that we can be helpful to the branch and trying to deal with that. And so yeah, my sympathy. I want to dig down a little bit on the response you just gave to Representative Osborne, though. I guess I'm a little concerned by the comment that you're not sure how litigants perceive you.
I'm sorry, didn't somebody?
I'm a little concerned by when you say you're not sure how litigants perceive you. What do you mean by that?
Well, Representative Osborne was talking about her experience with a client. And so I didn't quite understand, you know, she was asking me a general question about how people perceive me. I would say that, you know, generally I get along very well with the court staff and the marshals and, you know, the people that I work with. I get along very well with my colleagues. I've been assigned to a lot of different areas of the law. I have a process for learning that. I take advantage of the branch's education. I talk to my colleagues. I listen in on, you know, my colleagues who are in that area to understand, like, you know, how they handle it. So I think my perception is that I'm well liked and that I am respected. And so, how do people perceive me? I think mostly on the bench, people are grateful that, you know, I'm listening to them and that we're getting through a difficult time in their life. You know, I've done family, I've done habeas, I've done criminal, now I'm doing juvenile. I think for the most part, people don't want to be in court, but for the most part, I think people appreciate my efforts to understand their problems. Are there some people who want to take control over the process, want to object, and you know, they don't want to be there and they make that known. And so, but we have to move forward. And so sometimes, you know, do they perceive that, you know, and they file a complaint because I granted the TRO and they're upset about that? Yes, that would think that was the first complaint. You know, that happens. But I will say that my perception of the reaction of people to me, whether employees of the branch or whether you know, litigants who appear before me is, they appreciate my help.
All right, I'll accept that. I guess I'm sure Senator Winfield's going to ask you his question, but I guess to me, I think it's you know, whether it's a judge or state rep or whatever, those of us who serve the public, I think we sort of have an obligation to do a check-in on how the folks we're serving sort of view us, and knowing sort of how litigants perceive you in the courtroom, I think is pretty important. So I appreciate you letting me drill down on that. Senator Winfield.
Thank you, Mr. Chair. I think all of us have had relationships with people who actually know us. And therefore, when we operate certain ways, we get a certain level of grace because they understand us in a more fulsome way than they may understand other people. When you're in the court, you don't really know the people who are in the courtroom. You don't know the judge. You only know what you experience. So to me, it seems extremely important that people in a position to preside over that courtroom understand what's happening, not just with the staff, as much as they think they do, but with the people who come into that courtroom and have all that they have on the line, on the line. It's the very reason why I think the question about Robitis isn't good enough, and we need to ask the question about a system of accountability. I will point out to anyone who's answered this question or will ever answer this question while I'm sitting here, to tell me about your internal system is not good enough. It makes me question whether you understand the question before you. It makes me question whether you understand how people who don't have a lot of power sitting in front of you perceive you. It makes me question my vote on every person who answers that question and tells me I look at it. It does. The answer to the question is external to the person sitting there answering the question. So anyone who answers the question and only tells me, oh, I take into account this and I take into account that, I believe you, but it's not good enough. Because on that day, when you're not able to do that, you need an external system. That's the point. So I'm not even going to ask you the question. I'm just putting this forward for everyone to hear. And I've said this in every hearing we've had for the last few years. The answer is external. It's not, I thought about it. It's not, I have kids at home. I have to take out the trash. I hear that all the time. And those are, I won't even say those are cute answers. They're not good enough. People feel as though their life, their property, their liberty is on the line when they're in front of you. And we all have to have an external system of accountability. Thank you. Questions, comments from members of the committee? Seeing none, thank you very much for joining us today.
Thank you.
Sherie Murphy, now of North Branford. When you're ready, raise your right hand. Do you swear or affirm, as the case may be, that the information you provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury? And you may provide your statement.
Thank you. Good afternoon, Senator Winfield, Representative Stafstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. I am honored to have this opportunity to appear before you, and I do thank Governor Lamont for nominating me to serve a second term as a Superior Court judge. Since my appointment to the bench, I have served in New Haven, New London, and most recently in Milford, where I currently preside over criminal trials. Prior assignments have included, in addition to Part A criminal matters, GA, Part B criminal matters, and civil matters. I am an appointed member of the Minimum Continuing Legal Education Committee. Additionally, during this term, I have enjoyed appointments as judicial mentor, panelist for Project ECHO, which is the extension for community healthcare outcomes, committee member for New England Regional Judicial Opioid Initiative, and as an instructor for the Connecticut Judges Institute. Outside of the courthouse, I have volunteered as a mock trial judge for UConn Law School, participated in Read Across America, presented as a guest speaker at the CTLA Women's Caucus Fall Dinner, and served as a panelist at Quinnipiac University's Law School's Women in Law program. Additionally, I would like to note that I am an adjunct instructor at the University of New Haven. I have been affiliated with that university for over the past 20 years as an instructor, member of the Legal Studies Advisory Committee, or both. It has been an honor and a privilege to serve. It seems to me incredible that almost 8 years has passed since my appointment to the bench. I would be grateful for the opportunity to serve a second term, and I thank you for your time here today and your consideration.
Thank you.
Thank you.
Comment or question from members of the committee? Representative O'Day, followed by Representative Fishbein.
I certainly don't mean to step on my good ranking member's toes if he wants to go before me, but good afternoon, Your Honor.
Good afternoon.
So I'll go in reverse order. So typically, I try and ask every judge if they're willing to serve anywhere assigned, even family in Stanford, if that's where you're assigned.
I'm willing. Yeah.
Okay. And working at least 9 to 5?
Willing to do that as well.
There was one complaint made that, frankly, there's someone that I guess is in your neighborhood that had a complaint that they never see your husband doing the yard work. You're always stuck doing the yard work. I don't know if that's true.
It's definitely true.
So you had two complaints that were dismissed. Was there any common thread in those complaints, if you know?
Representative, I do know, and no, there were not any common threads. One was Attorney Jostle, who filed basically an appeal through the wrong process on a dispositive motion that I had decided. And the other was, I believe, a self-represented person who appeared at the GA. I've not been able to locate him on our docket. I believe perhaps it could have been back then Judge Kevin Murphy. However, his complaint was that the judge failed to wear a name placard and hid beneath the desk. So no common thread there.
And seeing as you've been in, have you been criminal and civil? You haven't had any family law experience?
I have not.
All right, having looked at, I don't see any negative letters. I looked, are you aware of any negative letters to your renomination?
I am unaware of any negative letters or comments to my renomination.
And have you, during your years as a judge, have you had anyone, to your knowledge, complain about your temperament or any temperament-like issues?
Not to my knowledge.
And this gets a little bit to where the good chair was going with the judges, but my question that I got, frankly, from Justice McDonald was that robitis is sometimes some judges get afflicted with it. How can you assure us in the future that you wouldn't be afflicted with robitis?
So I understand that to be a common thread and a common concern. And I also understand why we do serve the people. I do not forget the path that I took to become a judge. I was an active litigator for over 24 years. I expected to be treated fairly. I expected that my clients were treated fairly when we entered a courtroom. It's for the purpose of amicable resolution of disputes. Sometimes I had great experiences over 24 years and sometimes not so great experiences. So I keep in check that I want to be the judge who gives the great experience and not the not so great experience. So that's how I keep it in check. I do have external factors, and I'm assuming that Chair Winfield will ask, so I'll reserve those comments for that time.
I don't have any further questions. Thank you, Your Honor. And again, congratulations on your renomination. Thank you, Mr. Chair.
Thank you, Representative O'Day. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Your Honor.
Good afternoon.
Looking at your, so you, the majority of the term has been in New London. Is that fair to say?
That is fair to say.
And is there a reason why you haven't sat family, it appears, at all?
I don't know what that reason would be. I'm not in charge of assignments. However, I did enjoy a fairly lengthy term in civil, and since being moved to criminal, I have sat criminal. So.
Well, I noticed that when we asked what areas of law do you enjoy the most as a judge and why, you know, you said those areas, and I'm just trying to, you know, if you haven't sat family or juvenile or stuff like that, I know Attorney O'Day or Representative O'Day asked you about perhaps serving in family in Stamford, but you know, we have family all over the state. So am I to understand that if assigned to family, that would be something that you would be interested in and willing to do?
Of course I would be.
I appreciate that, because, you know, we do have issues with individuals not wanting that assignment. So, you know, we have a lot of judges before us here today, and it appears that most of them have had some family experience during their term. So I just want to highlight that. So thank you and congratulations on your renomination.
Thank you. I appreciate that.
Thank you, Representative. Comment or question from other members of the committee? the question, yes, I will ask you the question. I would just say, if you wanted to answer it as part of that question, I don't need to ask the question. I have no ownership over it. So, but please proceed.
So I was thinking as I was sitting there, because a lot of the responses that were provided were very articulate, and I do adopt those responses on behalf of my colleague for the majority of my answer. But to add to that response in answering your concerns, I believe there are some external factors that I employ, and those include the following. First of all, I'm extremely receptive to feedback. So I have a good relationship with my clerks. I also, sitting criminal, for instance, have a relationship with victims advocates. I also take the time to listen to the attorneys, any of the complaints that they have, if they do, regarding efficiency or effectiveness of the bench. If I feel myself getting to a point where I need to check on demeanor or something of that nature while I'm on the bench, because I spend many hours on the bench as a presiding judge managing criminal trials, I do a few things. One is I'm always mindful that judges have the opportunity to take a recess. I'm also mindful of the fact that attorneys are there to advocate, and that you have to be receptive to their emotions and not try to leave your emotions behind. So if I feel like things are getting too emotional, or there is a situation which is going to somehow affect my ability to remain calm, or just have that type of attitude that I would want a judge to have if I were a litigant in front of me, I do recess. I would take the opportunity to recess. Additionally, trying cases and being on the bench and dealing with a variety of factors, which includes instructions to the jury, the voir dire process, self-represented litigants, as well as experienced litigators, listening to victims advocates, hearing victims, watching victims' testimony. You have the opportunity as a judge now to go back and listen to how you handled certain situations that were presented by using the FTR system. And a very smart colleague of mine once told me that FTR could be your best friend or your worst enemy. So I am always mindful that the proceedings are being recorded, and that is an external factor. That is sort of a double check on how I conduct my proceedings. And if I ever sit back and think perhaps I should have handled something differently, I always take the time to review it. And lastly, I'd like to say that I don't know if it's fortunately or unfortunately, but for purposes of external factors, fortunately, many of the matters over which I preside do receive some sort of publicity, and there are write-ups. And I do make it a point to accept copies of those publications from clerks or whoever provides them to me. I do read any commentary, and I do know specifically things that are written within the commentary that do pertain to how I handled the proceedings. So those are some of the external factors that I believe that we can use. And lastly, I want to say this. I just know that, and I don't have any familiarity with family, so I'll put that out there, or juvenile, but in civil trials as well as GA matters and criminal matters, a lot of times you are aware that certain difficult situations will present. And I keep written canvases or a written outline, which is just a double check on how I'm going to handle the situation, so that if emotions rise, I can check myself and sort of balance my emotions by taking a look at my outline. For instance, a contempt outline, how to handle contempt. So after 8 years, we may think that we all know how to handle an unruly situation in the courtroom, but when the time comes and emotions run hot, it's nice, I think, to have that written outline in front of you, which gives you guidance as to how to calmly handle the situation.
Thank you. Just one more check, comment, question from members of the committee, comment, question. If not, thank you very much for joining us.
Thank you.
Okay, next up will be the Honorable Tammy Gwynn O'Dowd of Bloomfield. Judge, before you get seated, if you just raise your right hand for me. Do you swear or affirm as the case may be the information provided this committee be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
Yes, it is.
Great. Have a seat whenever you're ready.
Good afternoon, co-chairs Senator Winfield, Representative Safstrom, Ranking Member Senator Kissel, Representative Fishbein, Vice Chairs, and distinguished members of the Judiciary Committee. I would first like to thank you for taking the time to be here today. I would also like to thank Governor Lamont for nominating me for reappointment to a second term as a Superior Court judge. For the past 8 years, it has been both an honor and a privilege to serve the people of Connecticut. Each day when I enter the courtroom, I am conscious of the awesome responsibility and challenges of being a Superior Court judge. To listen carefully to each person, to treat everyone with respect and dignity, and to decide cases fairly within the laws of this state. Since my appointment in 2017, I have spent my entire time in the Hartford Judicial District. My first assignment was in GA 14, covering the criminal and motor vehicle and arraignment dockets. From there, for the next 4 years, I was assigned to Hartford Family Court. Since September of 2022, I've been sitting in the Hartford Juvenile Court and as presiding judge since September of 2023. Finally, in October of 2023, I was honored to be named as Chief Administrative Judge for Juvenile Matters. I've also served on several judicial branch committees, including the Education Committee, Rules Committee, Judicial Media Committee, and Client Security Fund Committee. Outside of the courtroom, I've been active in the community by serving as a Presidential Fellow Committee member with the Connecticut Bar Association, volunteering to read to students as part of Read Across America, participating as a guest speaker for a juvenile law class at the University of Connecticut School of Law, and preparing meals in my community for Lasagna Love and Mercy Shelter. I would be most grateful to this committee and the General Assembly for the opportunity to continue to serve the state of Connecticut in this capacity for another term. Thank you for your time and consideration today, and I would be happy to answer any questions.
Thank you, Rep. O'Day.
Thank you, Mr. Chair. Good afternoon, Your Honor.
Good afternoon.
Congratulations on your renomination.
Thank you.
I see here that you've had 3 complaints, all dismissed, as I've been asking. Were there any common themes in those complaints? Or are they all unique?
Each of those are unique. The only commonality between the 3 cases that they were all during the time period when I was sitting in family court, and they were all self-represented litigants. 2 of the cases were just a dissatisfaction with the outcome with regards to the judgment for their dissolution. Neither of those cases, any of the parties appealed my decision. And then the other complaint was, I believe it was a question with regards to abuse of discretion and not allowing the children's therapist to testify. And what I recall from that case is that the mother in that case had objected to the children testifying. So in that case, I did at that point did not allow the children to testify at that hearing, but reserved it for another day and appointed a guardian ad litem to investigate the matter.
Having sat on family, you heard me probably ask earlier on, any recommendations that you would have for the committee in fixing the system or changing the system based on your experience, if you know, or have any ideas?
When I was first assigned to family court, it was before pathways. So some of the comments that the committee members have asked about pathways and whether it works or not, I found that with pathways, I thought it was more efficient with regards to handling the cases. In Hartford, I did not experience cases, waiting 6 months for a trial. And at every RPD, the parties came before a judge, and that was the practice and happened almost 100% of the time in Hartford. So I can't speak to other courts. What I can say is, for the individuals that are coming before the court, especially if they need to have supervised visitation or any sort of referrals for programming, I think that's lacking in the family court in order to service the parties, in order to get them into a better position, whether it's mental health or substance abuse, or needing to have supervised visitation, to have those programs available for them.
I see that you're an MSW as well.
Yes.
My wife is an MSW. It's helped her in our marriage, helped her fix me anyway. I'm obviously just kidding for the record. Is there, I see that you're in Bloomfield.
Yes.
Are you willing to serve anywhere in the state, in any capacity, even in family court again?
I would.
I know it's a long drive to Stanford, but if you were assigned to Stanford, would you be willing to serve?
Yes.
And are you willing to work at least 9 to 5?
Yes.
And the robitis question, that's typically it's one of the hardest things that we can find out about a person and whether or not they'd be afflicted with robitis once they're appointed. I have been looking at the comments. Are you aware of any negative testimony for your reappointment? Because I didn't see any.
I'm not aware of any.
All right. And how would you answer the question? So you haven't, as far as I can tell, I've never appeared before you, Your Honor. So it doesn't appear as though that you have any robitis issues. So, but how can you assure this committee that they won't come about in the future?
Well, I could speak to, for example, the complaints that were brought before me. I took those very seriously. And so when those were brought to my attention, the first thing I did was I asked the monitors to produce a transcript of those hearings for me, as well as listen to the FTR. And my mentor at that time, I had asked for assistance from my mentor just to make sure I was doing everything right and treating everyone fairly. And so I had my mentor listen to the transcript as well as reading those transcripts and sitting down and talking to make sure as a new judge that, anything that I could do to avoid a situation with regards to if it was my temperament or robitis, that I would address it right away.
Well, thank you for that. And thank you for your responses to this. Good luck again. Congrats on your renomination. Thank you, Mr. Chair.
Thank you, Representative.
Representative Osborne.
Thank you, Mr. Chairman. How are you this afternoon, Your Honor?
I'm well.
It's nice to see you again.
The same.
Congratulations on your renomination. It's been a couple of years since I've appeared before you. But I was just curious. You listed some of your most important cases that you thought were most significant. And you listed as number 10, Camille versus Camille. The matter involved the enforcement of orders from a dissolution judgment related to foreign property. So can you just tell us a little bit about that case and why you thought it was a significant enough case to mention here?
Sure. So obviously it was significant in the sense that it's not, run-of-the-mill property that's here in the state of Connecticut, much less the United States. And so parties were really trying to, and this was, so the original judgment was not me. So these were post-judgment motions with regards to transferring the property based on a judgment from another court. So in that case, we did have a lot of status conferences in order to avoid having to go to litigation. And what the parties ended up doing was that they hired a lawyer from India that they agreed to in order to assist them in getting that property and all those titles transferred to them. So I thought it was significant in the sense that it was obviously a case where you wouldn't see every day, and myself having not had much family, I didn't have any family experience before. It was challenging, but also it was very cooperative effort that you don't necessarily always see in family court. And the result was that they were able to get this attorney to assist them.
Great, thank you for clarifying that. And it is nice when you get these more intellectually stimulating cases in family.
Yes.
And I just wanted to comment for the benefit of my colleagues here on the bench. Whenever I appeared before you, your decisions didn't always go my way, but you were always respectful, you were always fair, and it was always a pleasure to have a case before you, and congratulations again on your renomination.
Thank you.
Further questions or comments from the committee? Further questions or comments? If not, Judge, congratulations on your renomination. Thanks for being with us today. Next up will be the Honorable Sheila A. Ozalis of Newtown. Judge Ozalis, if you could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided this committee will be the truth, the whole truth, and nothing but the truth, to help you God or under penalty of perjury?
I do.
Great. Have a seat whenever you're ready.
Thank you. Good afternoon, Chairman Safstrom, Ranking Member Kissel, Ranking Member Fishbein, if he comes back into the hearing, and Chairman Winfield, and members of the Judiciary Committee. I'd like to thank Governor Lamont for nominating me for reappointment as a Superior Court Judge. I was appointed to the bench in 2009, February 2009. Since that time, I've served in Danbury, Waterbury, New Haven, and Stamford. Courts working in a block assignment in Danbury and Stamford, and civil assignments in Waterbury and New Haven. Currently, I'm assigned to the Stamford Judicial District as the Assistant Administrative Judge, the presiding judge of the complex litigation docket in Stamford, and the presiding judge of the Stamford Civil Docket. I regularly engage in civil litigation conferences, motions, trials, and hearings, and oversee and manage the civil and complex litigation dockets and judges. I'm humbled and truly consider it to have been a privilege to serve the people of the state of Connecticut as the Superior Court Judge for the last 16 years. The work has been diverse and challenging, and I've taken this responsibility very seriously. I'd be most grateful to the committee and the General Assembly for your approval of my nomination. Thank you, and I'd be happy to answer any questions that you have.
Thank you, Judge Ozalis. Questions from the committee? Representative Bode?
Thank you, Mr. Chair. Good afternoon, Your Honor.
Good afternoon.
Congratulations on your reappointment. And full disclosure, I have had the pleasure of appearing before you in Stamford. And might as well get the first two questions out of the way. Are you willing to serve anywhere in the state if you were assigned, even to family?
Yes, I am.
And you willing to work at least 9 to 5, Monday through Friday?
Yes, I am.
And I see you had one complaint since your last nomination. Can you just describe briefly for us what that complaint involved?
The complaint was in effect an appeal of trial decisions I made. It was a motor vehicle accident case, and there were several decisions I made during the course of the trial. One in denying special defenses to be filed the first day of jury selection. The second, when the parties had agreed to the admission of certain exhibits and had agreed that one party would be responsible for the redaction of certain information. And the redactions that were made were not favorable to the other party, and the other party didn't realize it until they got the exhibit in front of them. It was before trial started, and I directed that the redactions be in accordance to the agreements of the party and not favorable to the party who did the redactions. That person took umbrage at that, thought that the other side had the opportunity to catch it, and they caught it too late. I disagree. The third was when this person submitted a charge for me to give to the jury after evidence had closed. Neither myself nor opposing counsel had the opportunity to review the charge, and that charge were quotations to a Supreme Court case that didn't exist. In chambers, as I reviewed the charge, I asked the attorney to retrieve the case law book from behind him so that I could look at it. It confirmed to me that that case law did not exist in that case, even though it was quoted in his proposed charge. And I gave him the opportunity to look through the case. Perhaps I missed it. He was not able to find it. We have a discussion with opposing counsel there that this was not appropriate. And we had to be very careful in what he submitted to the court and make sure that what he submitted was accurate. Went back out on the record to do the charge conference, and he insisted on the charge. So on the record, I felt it was my obligation to address the issue that this was inappropriate.
Well, I've never heard that one before. Wow. So have you ever served in family?
I did, and when I was in a block assignment in Danbury, literally when you serve in Danbury, you're on call to jump into any discipline. And I did the overflow docket on family for short calendar days on my first year while I was on the bench. And then when I was assistant administrative judge in Danbury, I would get called to jump into that discipline or other disciplines. In fact, one day when I was in Danbury, I literally had a day where I started in civil, then moved to the GA because we needed coverage there. Then after I had a recess in the GA, moved to the family court to handle some motions there, and then had to get in the car and drive to the juvenile court building to handle a matter there.
And you've probably been listening to the questions about how you would fix the family system. I know it's a loaded question, but are there any ideas that you have or suggestions based on your experience in family?
Well, my suggestion, and there's no funding for, my suggestion would be that self-represented individuals be given the opportunity to have counsel or the assistance of counsel. It's a wild territory to navigate on your own, and it's emotional and it's difficult, and there's a lot at stake.
Well, having appeared before you, I am pretty confident that robotics is not going to be an issue, but for those that have never appeared before you, can you just explain how you can assure us that robotics will not be an issue in the coming 8 years?
I am committed to be a public servant. When I was nominated by Governor Rell in 2009, I made that commitment to her. And I try to live up to that commitment every day. However, when I go on the bench, there's a couple things that I do externally and internally to make sure that I'm living up to that commitment. Number one, I check with my clerk staff to make sure what the environment is in the courtroom. Are we going into a heated environment? Is everyone calm? Is there assistance that's needed? Whatever, what's going to be necessary for me to do in order to effectuate the hearing or whatever's going on in that proceeding. Second thing is on collection cases. When I go out to pre-try and try to resolve those cases, I don't go on the bench. I sit down in the well of the courtroom with opposing counsel, with usually the creditor's counsel and the self-represented party. And I explain to them what's going on and explain to them that we're trying to reach a resolution of the case if we can, and listen to them. I'm not doing that from the seat of the bench. I'm doing that on the floor so that we can look eye to eye to each other in order to do that. And I can listen and try to better understand how they got into this situation, what it's going to take to get out of that situation, and try to resolve the case. I've also, for robitis, I'm not beyond getting water for litigants. It's very difficult to get to Stanford, and you can get there if you don't have a car by public transportation. It's not an easy feat. And I've had certain individuals who have come during the hottest days of the season, and I am not behind fetching water and bringing it down to them so that they can cool off and have the opportunity to have that liquid refreshment. So that's how I try to do those kinds of things.
And, again, I had said earlier, I thanked Attorney Gavin, not realizing he was sitting here. The CCDLA compile input. And you actually got a letter from an attorney I know very well, Mark Phillips, who speaks very highly of you in the written responses. And I can tell my colleagues, Attorney Phillips was on judicial review, and he does not give out compliments willy-nilly. So congratulations on that. Congratulations on your renomination, and thank you for your service to the state of Connecticut, Your Honor. Thank you, Mr. Chair.
Thank you.
Thank you. Further questions? If not, Judge, just a couple quick ones for you. So you're pulling at least double duty down there. And it as somebody who, I don't think I have any cases currently individually with you, but as somebody who certainly has cases in that courthouse, how do you manage? How do you manage the job of presiding judge on the civil docket and also a separate complex litigation docket? For those who don't know, a complex lit docket can come from anywhere in the states. I mean, you could have a case that was in New London that all of a sudden ends up before you in Stanford, and you're sitting there saying, well, I already have my existing, PJ docket. How are you juggling both?
I have the best team. I have a phenomenal caseflow clerk who fills me in on what's going on during the day and what we need to manage, and we have times during the day in which we coordinate. I have a phenomenal caseflow clerk for complex litigation, who gives me the schedule of what's happening for the day. And I try to, I have a schedule I set out for myself in the morning on what I need to address and look at emergencies. I usually work every lunch, trying to get through any emergencies or things that need my attention. And, but it's the team around me that enables me. And the clerks in Stanford are amazing. And that's what enables me to do both those jobs.
Well, we got to get you some help, because I do worry we're going to burn you out down there doing both dockets, by yourself down there. I think that, you know, certainly I'm looking at, I know we have a couple of our other complex lit judges coming up behind you, and, you know, how you're doing your job plus Judge Welch's job back there. I think we gotta get you some help down there. And this is the point, right? Is that I didn't mean,
I will say this, I offered to do both jobs.
I hear
and
you.
so-
I don't mean to sort of, I know we've sort of picked on Stanford a little bit today. And I don't mean to, but I think it is a hard place to recruit judges to, because unless you're down in that part of the state, traveling to it is difficult. And I think we need to look as a committee about how we either staff that courthouse better, or frankly, I've always wondered why we have a complex lit docket in Stanford as opposed to potentially moving into Bridgeport, which I think would be a better location for it, frankly. But feel free to comment on. No, because I just think it's easier for litigants to get to as opposed to trying to get to Stanford. But Judge, do you want to comment on that?
I do. As I sat here listening to the comments about Stanford, I love Stanford. It is a beautiful courthouse. It is filled with hardworking judges, hardworking staff. And you get you have an exceptional bar down there. And I think anyone would be lucky to work down in Stanford and have that experience. Yes, it is hard and difficult to get to via the highways. But if you do get assigned there, I think it is a phenomenal experience. This is my 5th year there. I hope to continue down there. It's, as I said, for all of those reasons, it's a wonderful place to work.
Well, I hear you. I agree with you. You know, generally have good experiences when I'm down there. I guess my only gripe is the over-aggressive marshals down there. It's the only courthouse where they'll actually search through your bag and steal a granola bar from a lawyer who may be planning to be down there for 8 hours. And right, Rep. O'Day, any other courthouse, if you subtly sneak that granola bar in the bottom of your litigation bag, and right, I see all my colleagues nodding. So we might want to talk to the marshals down there and just say, you know what, the lawyer comes in, they're going to be here all day, they're not going to have lunch. If they sneak out in the hallway and have a granola bar, maybe we shouldn't be stealing it out of the bottom of their briefcase.
All right,
If you could pass that one along for me, I'd appreciate it.
I certainly will.
All right, thank you, and appreciate being with us. Oh, Representative O'Day he's got 5-hour energy drink. You know, like I said, I get it. You're walking in with a full pizza. Okay, fine. You're not walking through the metal detector with a full-on pizza, but you got a granola bar in the bottom of the litigation bag. Let's come on. Let's cut it. Thank you for being with us.
Thank you.
All right, Judge Pearson.
Thank you very much.
Thank you, Judge Ozalis. Appreciate it. Judge Pearson, if you could raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Thank you, sir. Have a seat, and whenever you're ready.
Thank you. Good afternoon, Chairman Winfield and Chairman Staffstrom, Senator Kissel, Representative Fishbein, and all the distinguished members of the Judiciary Committee. It is an honor to appear before you today. Before turning to my brief remarks, I also want to thank Governor Lamont for nominating me to serve a second term as a judge of the Superior Court. My first term began in May of 2017, and I will say to the members of the committee, it seems as if that was yesterday. I am currently assigned to the complex litigation docket in Waterbury, handling some of the most challenging civil cases in our state court system. Prior to being assigned to complex litigation, I was presiding judge of the Civil Division for the Waterbury Judicial District. Before that, I served for 2 years as a civil judge in Ansonia, Milford. I was assigned as a civil line judge in the New Haven Judicial District for 1 year prior to being transferred to Ansonia, Milford. In my first year on the bench, I served as the GA judge in Middletown, during which time I also handled civil matters and conducted my first civil jury trial as a judge. I'm currently a member of the Rules Committee of the Superior Court, having been reelected by my colleagues for a third one-year term. I'm also a member of the Law Library Advisory Committee. Finally, since 2019, I've been asked to teach several classes to incoming judges during pre-bench orientation, including classes on diversity awareness, sexual harassment and civil procedure, as well as mediation and pretrial settlement. I've also served as faculty at the Connecticut Judges Institute, teaching seminars on such topics as civil jury trial practice and civil protection orders. With that brief introduction, I look forward to answering any questions that you may have about my candidacy for reappointment.
Thank you, Mr. Chair. Knowing that I was going first, I hope I won't take any offense. I'll try and speed it up. Your Honor, good to see you up there.
Nice to see you as well.
Congratulations on your renomination.
Thank you, sir.
Briefly, I know the answers to this because I've appeared before you, but are you willing to serve anywhere in the state, even if it's family in Stamford?
I am, sir.
And to be clear for the record, I don't mean to disparage Stamford. I practice there and I love it. It's just that seems to be the family court is where it appears to be the most problems. And you've never served in Stamford, as I understand.
I have not.
And you're willing to work at least 9 to 5?
I am.
And having known you for a number of years, I know that's not a problem either. And finally, the standard questions. Again, I know this because I know you, but for the other members of the committee and potentially the public who are watching this, how can you assure us that robitis will not be a problem for you over the next 8 years?
Well, in my view, every person who appears before me is entitled to the same dignity as a human being. And that view has never changed throughout my life, and I anticipate that it will not change going forward. And part of according somebody the dignity to which they are entitled as a person is showing them the respect that each and every individual is entitled to. And so that is my answer to the question.
And thank you for that. And as I've been asking everybody, you've had one complaint that was dismissed. Can you just briefly go over that one complaint?
Sure. The complaint that I had was filed by a sovereign citizen who took the position that the state of Connecticut did not have the constitutional authority to tax his income. I dismissed his complaint, and he did not file an appeal of that dismissal to the appellate court, but he did file a complaint.
And I was trying to see, I looked through most of the public testimony. I didn't see anything from anyone against your nomination, and there was no letters from the bar, from the CCDLA. Are you aware of anyone that's opposing your renomination?
I am not aware of anyone.
I am not either. And I will tell you, the Honorable Jason Welch spoke very highly of you and your mentorship of him. And, you know, obviously he's familiar with this side, but wasn't as familiar with that side of the bench, so as it were. But I've heard nothing but great things about you. I've experienced nothing but great things. I'm sure, I know you enjoy the complex lit docket. Is that fair to say?
It's more than fair to say. It's a joy to do it every day.
Well, I'm very thankful to the governor for renominating you. Thank you so much for your service to the state of Connecticut, and hopefully we'll be seeing you at a higher level if the governor so sees fit. Thank you very much, Your Honor.
Well,
Thank you, Mr. Chair.
Thank you, Representative O'Day, for those extremely generous remarks. Thank you, sir. You're welcome.
Representative Fishman.
Thank you. Good afternoon, Judge Pearson.
Good afternoon.
My former business neighbor. He
Yeah.
worked-
Yes, sir.
Worked right down the street from me.
That's right.
Congratulations on your renominations. One of the areas that you've heard touched on here today was service in the family court.
Yes, sir.
And I note that, just, you don't have to stir me, so just, I know, I got it. It's a little, it's uncomfortable though. You're up here. You've served a term, but it doesn't appear that you've served in family court at all.
I have not.
And is there a reason for that?
I have no idea why, Representative Fishbein. It is the chief court administrator who makes the decisions on assignments, both with respect to geographical location and with respect to what division a particular judge is going to serve in. And I've never been assigned to the family court. That is the chief court administrator's prerogative and responsibility. That's what they decide.
I know that judges are asked on a somewhat frequency where they would be interested in serving. Is that fair to say?
It is fair to say.
And have you ever indicated on your response that you'd be willing to sit in family?
Well, you get three options, Representative Fishbein, so you cannot possibly cover all of them. Certainly my first choice for a long time has been to sit in the complex litigation docket, which I've had the great fortune of being assigned to. I have also asked to be assigned to the criminal docket, which I've never been assigned to the criminal docket other than that first year when I served in the GA in Middletown. So those are the choices that I've submitted.
So you've only submitted two choices out of
No,
the three?
Complex litigation, civil and criminal are the ones that I've asked for.
Okay.
But if I was asked to serve as a family court judge, and to just reiterate the response I gave to Representative O'Day, I would be delighted to do that. And not only delighted, but happy to do it wherever they may send me.
Yeah, for some reason, Representative O'Day's question only has to do with family in Stamford, though. So, I sort of pointed it out before. I thought he was going to expand that a little bit, but I mean, maybe he's giving me a runway to work with. In question 13, we ask, and I haven't been here the entire day because I've been out there doing meetings and working on other stuff. We ask in our questionnaire about cases that judges have handled and why they're significant to them.
Yes.
And most people have not followed those instructions, but so it's not just you. I just wanted to ask about the Carano case.
Yes, sir.
Why was that case, that had to do with Zantac?
I'm sorry, I didn't.
Had to do with Zantac?
Yes, sir.
The prescription drug. Why was that case significant to you?
It's significant because there are, for several reasons, it's significant. It is a products liability case of national importance. It has, they're related to that case are matters in which there are more than 1,000 plaintiffs. And many of them are residents of the state of Connecticut, and it involves products liability, which touches on the rights of consumers to purchase and use safe pharmaceutical products. So it's important on several levels. One, its size; two, its national importance and potential national significance; and three, it has to do with whether a certain product may actually lead to causing a disease that has negatively impacted people's lives and may in fact have taken those lives away. So that's why.
Oh, I appreciate that. Thank you. Thank you very much.
Thank you, sir.
Thank you, Mr. Chairman.
Further questions or comments from the committee? Senator Winfield?
Yep, just very quickly a follow-up. I think you know what's coming.
I do know Senator Winfield, and I'm more than happy to answer that question. The way I understand the question, Senator, is when you talk about accountability, what you're asking about is when I do something that has consequence, how do I hold myself responsible for that consequence? In other words, what do I do after I have acted in a certain way, whether it's by issuing a decision or presiding over a certain trial. What do I do after that action has taken place to check myself to make sure that what I have done is in keeping with the high standards that I hold for myself? And what do I do that is outside my own head, my own self-reference, to say, oh, I'm doing a good job, or maybe I could have done that better, or what have you. So I'll give you several examples of what I do. First of all, with my written decisions, because I do write a lot and I have written a lot in the various and several civil assignments that I've been given. I always ask my colleagues to read my decisions, and to the extent they're willing to go through them. I want feedback from my colleagues about what I have written. Is what I have said clear? Is my presentation of the analysis persuasive? Do they think there's anything that I could do better the next time when I'm writing a decision? Because I understand fully that what I write provides guidance to future litigants, potentially, to other lawyers, to other actors. So I want to make sure that I get feedback from my colleagues about what sort of product I am producing and what the quality of that product is, and whether that product can be improved somehow. Then in addition to that, in terms of trials, in terms of courtroom atmosphere, in terms of how I interact with others in the courtroom, I solicit from lawyers. I want to know, how did I do? And I ask them, you had a trial with me a few months back. How did that go? Was there something you didn't like about the proceeding? I solicit comments from the attorneys who appear before me. I want to hear from them about what their experience was like with me. And I also want to hear from my court officer or my clerk about how they think the proceeding went, what the problems were, and how we might be able to address those problems in the future. And I encourage people to tell me honestly what they thought of my performance. Now, I'm fully aware that not everybody is always going to be fully honest with me about what my performance is in a particular matter. But my hope is that over time, people will be. And that by engaging in those things and in those post-action communications, post-memorandum of decision, post-trial, I will get the feedback that I need to hold myself accountable for what I have done, and hopefully to improve upon what I do on a daily basis. That's my answer to you, sir.
Thank you. I would just say this to anyone who is thinking about this question, listening to this question, and I appreciate your feedback on that. There is a difference between asking or even encouraging folks to give you feedback and making it known just what place feedback has in your mind. What I mean by that is I've not always been here, clearly, and I've worked in other places where I was the boss and the only person above me was in another country. And what people came to understand was not only did I want feedback, but that it was important enough to me that the only time I ever got upset was when I didn't get actual honest feedback. They're two different things. And I guess what I'm asking folks, because I don't want to be unfair to people, what I'm asking folks is, have you set up a system where people can actually pull your coattails, right? That's what I'm asking folks. And I want people to think about it deeply because of what it is to be in a courtroom. So I appreciate your answer. I'm not saying you're wrong or anything. I just want to be clear for folks because it would be unfair for me to, well, I don't know. I've been asking this question for years, so maybe it's not, but it may be unfair for me to ask that question without clarifying. But again, thank you for your answer. Really appreciate it.
And Senator Winfield, if I could just add one other thing, I make it clear to the attorneys who appear before me and to the staff that works with me that I want them to be honest with me about how they feel. I encourage them to be open. And I think the people who know me will tell you that that's the case.
Appreciate it. Thank you.
Further questions or comments? Further questions or comments? If not, I've got about a laundry list of them to go through here. I've been waiting for this for a long time.
All right,
But,
Representative Staff.
my first question is, why don't you work as hard as Judge Ozalis? She seems to be able to manage the complex lit docket plus the presiding judge docket.
I have an answer to that if you want to hear it.
Yes, please.
Representative Staffman, the answer is that although Judge Ozalis wears many hats and wears them extremely well, if you compare the number of cases on her docket to mine, I have many more than she does. That's on the complex litigation docket.
All right, fair enough, fair enough. Judge, I commend you, congratulate you on your reappointment. I want to sort of use you to make a comment I probably should have made with several folks. I think a lot of the folks on our list today really do a lot of work and service to the branch outside of just the courtroom. And I know, how important that is and how critical it is. I recently had occasion to listen to the Rules Committee meeting. It was actually one of the first times I think I've ever listened to a meeting of the Rules Committee. And I know you and a few other folks here today serve on that. Certainly I found your comments to be spot on a clarification to a rule that I'd like to see the branch make. But I appreciate your service to the state and congratulate you on your renomination here.
Thank you very much, sir.
Next up will be Judge Spader. Judge, if you could raise your right hand for me. Do you swear or affirm as the case may be, the information provided this committee to be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. Have a seat and whenever you're ready.
Good afternoon, Chairmans Winfield and Safstrom, Ranking Members Kissel, Fishbein, and members of the Judiciary Committee. Thank you for allowing me the opportunity to appear before you today. And I would also like to take this opportunity to thank Governor Lamont for nominating me for a second term to the Superior Court. It's truly been an honor and privilege to serve the people of Connecticut for these past 8 years. I was first appointed to the bench in May of 2017, and I began my judicial career at the arraignment docket in New Haven. Moving shortly thereafter for an extended period of time as the presiding judge on the housing and property dockets in New Haven, Waterbury, Bridgeport, and Norwalk, Stamford. I'm now serving as a family judge in the New Haven Judicial District. I serve on the Education Committee, the Bench Bar Foreclosure Committee, and the Access to Justice Commission, where I chair the subcommittee on law libraries and law schools. Working on continuing legal education for judges, I created an annual program that I call the Housing and Foreclosure Roundtable. It's for judges on the housing and foreclosure dockets that analyzes new appellate decisions in each of those disciplines and the changes you make to housing and property laws each year, as housing tends to be at the forefront of your annual work lately. Since my third year as a judge, I've taught classes at the pre-bench program for new appointees on not only property issues, but on technology and procedural concerns. It's an awesome responsibility to make decisions that impact the daily lives of our citizens and one that I do not take lightly. I appreciate your consideration of approving my nomination to continue serving for another term, and I'd be happy to answer any questions you would have for me.
Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Judge.
Good afternoon.
Nice to see you again. Judge, I have to see that you surprised me a couple months ago. I had a pretrial with you. And, walking into the pretrial, many times you go to a pretrial and the judge may have looked at the proposed orders, may have looked at, generally what's looking at the case. But in that particular case, you did some research. You looked up the bankruptcy. You knew about the bankruptcy, me walking in the room, and it helped that process because that neutral had more information and was able to have a very engaged process. It was unique, I have to tell you. We don't see that, or I don't see that very often. So I gotta ask you, since you've been in family for what, 3 months now, after a lengthy time in housing and foreclosure, which I know can be tough, especially during the pandemic, because, you know, we shut off evictions to a certain extent, but we didn't shut off foreclosures, right? So you had property owners that aren't having the income, but they're getting foreclosed on. But that was the process that you were left with, during the pandemic. But now that you're in family, 3 months in family, I gotta ask you, what's it like?
It's just as challenging. Housing and foreclosure is extremely challenging on their own because the decisions you make have an immediate impact. 5-day appeal periods in housing, immediate foreclosure sales in foreclosure. Family has a little more length to it because you're dealing with a motion for modification and people are going to keep coming back. There's children, there's long-term cases. You see the same people quite frequently, whereas in housing, it's very immediate. And doing housing for as long as I did, well, that probably leads to the next thing. That brings up a number of complaints because it's hundreds and hundreds and thousands of trials I've done over the years. But I really enjoyed so far on the family docket. That I'm still dealing with a lot of self-reps and you're able to communicate with them, talk about their cases when you're on the bench, try to provide solutions, try to help them through. You can make a difference. That's why I enjoy doing this. And that's why I research those cases like I do, sometimes you have a lot of self-reps on your dockets and they don't know what is important or what to present. And when I became a judge, there's an older colleague who's no longer a judge who saw my preparation that I was doing, all this reading before the cases and reading all the pleadings. And he said, you'll stop doing that in a few months. And I'm proud to say that I still haven't stopped doing that because I think it's important to the litigants. I hated as an attorney when I showed up and a judge wasn't prepared. And I never want to be that judge that's not prepared when someone shows up. And it's important to have the information on the case to be able to adjudicate it and help the parties get the solution they need in their case.
I appreciate that. Can you pull the microphone a little bit closer to you? I don't know if we're picking up. I also wanted to ask you, we talked about housing, foreclosure, it is a difficult docket. You have a lot of, there's been a lot of complaints that have been filed during the term. All of them been dismissed. Would you like to address that in some, is there anything you want to say about those?
Well, none of them related to any temperament matters. 14 of the 16 complaints went along with appeals filed along with them. And I think a lot of them did, 8 of them were out of Stanford too. So, yes, I don't mind being in Stanford. But the part of the process in housing and foreclosure is a lot very personal and very quick, and people are facing housing insecurity and very important issues that you have to deal with as a judge and try to communicate with people. None of them related to anything that had to do with temperament. They all kind of were like, hey, I don't like the process that it is so quick, or that, the appeal period ran this quick. And none of the issues made it that far in the complaint process. They were dismissed before I had to respond to any of them because they didn't really have a legal basis. But it doesn't mean that I didn't read them, was concerned with them, tried to make sure I understood the concerns of the parties and could apply that in the future.
And of those, were some of them filed by the same person?
I think 3 were filed by one person, 2 were filed by another person. There were repeated issues, and they've filed complaints against other judges as well, a number of those people.
Okay, I appreciate that, and congratulations on your renomination. Thank you.
Thank
Mr.
you.
Chairman.
And I look forward to having that pretrial again because I got more information that'll help both of you guys. So
Okay.
I know it's coming in again, but I found some information.
Repo day.
Thank you, Mr. Chair. Good afternoon, Your Honor.
Good afternoon.
And thank you for that response to the good ranking member. Just to delve in that a little deeper, and believe me, the area where the most complaints are made are when somebody's in family, and so that's why I've been asking this question, because I think it's unfair that the judges that have volunteered to work in family have have had some of them a hard time on reappointment. And looking at your, the number of complaints, there's 16, the next closest is 6. So were there any common themes in those complaints that in self-reflection and reading them, you thought about what you could do differently or better? I will admit, I've been going through trying to figure out the complaints. I have not delved into each of them myself. So is there anything that you can, any way you can enlighten us on any common themes or issues that you think you can work on, or are they all just one-offs?
Well, that 3 by 1 person, which was the same issue, so maybe that counts as one. But, you know, probably you talk about family, you probably haven't had a lot of housing judges that did 6 years in housing, because it's usually a 2-year term and then someone's running away from that, just like they want to run away from family. Because it is a difficult, stressful docket. And those complaints do come out of there because it is a docket where I also have a lot of appeals, because an appeal is really the only way to stop an eviction also. So it is as challenging a docket as family, which is why, you know, a couple of years ago, the chief court administrator was like, hey, you're made for family. Your family's coming your way because you're dealing with the same kind of self-reps and the same kind of business in housing, and I've been doing it for a number of years. The common theme is that housing insecurity issue. You know, we don't have solutions for a lot of the people in our society who are going through that. And the judge is the bringer of the bad news a lot of times. And so if anything, it's how I deliver bad news. And it's also important when you're on a docket like that to not just be able to deliver the bad news, but to also know the solutions. You know, there's an extra statute for a housing judge that you're also supposed to be knowledgeable about safe housing in your district. That's the only extra statute for a judicial duty, is those who are the housing judges have that extra duty. And I felt that meant my extra duty was to know different services that were available to people in my districts. So I would make sure that as I deliver judgments, hey, here's some other options available. Here's where you might want to call for some resources. Here's where there might be some help available to you. I didn't know those things at the beginning, you know, and a lot of people who are just going into a housing docket wouldn't know them now. And that's why, you know, with the chief court administrator support, I've added, you know, annual programs to help other judges who are just taking over housing, so I can kind of get them up to speed quicker about programs that are available.
And, you know, I've been asking, and since you did do family in Stanford,
No,
maybe-
housing in Stanford.
But sorry?
Housing in Stanford.
Housing in Stanford, sorry. You may be able to make some recommendations on how we can help new judges or help in the family arena and housing arena. Do you have anything that you could give us as by way of recommendation going forward on what we might be able to do to help judges who are sitting in housing or in family?
Well, I think how, you know, as I indicated, I kind of created this housing roundtable to try to help the new judges. From my perspective, when I just became a family judge in New Haven, you know, the first thing I did was reach out to Judge Armada, and I sat with him for 3 dinners in August and went to one of his courtrooms to learn from him and learn from the colleagues. And you got to learn who the colleagues are that you can trust, that you can learn from. And I like to be that judge for the foreclosure and housing judges, even though I'm not on that assignment now. I still take many calls throughout the week to try to help people through tough decisions. But it's learning from your colleagues and knowing who you can trust and who you can learn from, who are good teachers.
And, you know, the questions I've been asking, are you willing to serve anywhere in the state, even Stanford family?
You know, I had my little Stanford schedule. I had a parking space they gave me at the Milford Courthouse, which is right next to the train station. So I had the 5:30 train out of Milford down to Stanford. I know the routine and willing to serve in it.
Thank you. And work at least 9 to 5, Monday through Friday?
Yes.
And the robitis question that we kind of danced around a little bit, but going forward, and I've been reading, you know, I don't think you have any robitis issues. How can you assure us that there won't be any robitis issues with you going forward?
You know,
the group here that's up for reappointment, 12 of us or 13 of us were appointed together in 2017. I don't know if it was just a strange year, but our robes are really heavy. And I say that not lightly, but it is a reminder when I put it on that the decisions I'm making are heavy. And I've said that to when I teach the pre-bench classes and I talk to the new judges about the assignment they're about to take on. You know, I kind of tell them, even there was a habit for a while that went away, thank God, where judges were doing remote hearings like in their chambers without a robe on and things like that. No, you need to feel the weight of this robe every day for every decision you make. And it is an awesome responsibility we're given that I know that I will not take lightly. Part of that is because I won't ever change that robe because it's such a heavy robe and I need to feel the weight of the decisions I make.
All right, thank you very much for your responses. Congratulations on your renomination and good luck going forward. Thank you for service to the state. Thank you, Mr. Chair.
Thank you.
Thank you. Judge Spader, as you said, you know, I know you really enjoy housing. I had the opportunity to appear before you a number of times when you were in Bridgeport, particularly during the COVID years. And I noted on your information, I mean, you know, you really were one of the first judges to take on sort of some of the pretty novel kind of COVID defenses to non-payment of rent, particularly in the commercial space, you know, the restaurant spaces. I know you had the case that eventually went up to the Supreme Court. Do you want to just remark on that a little bit? Sort of, I know you were relatively, this was in your first term, you were relatively new to housing. The pandemic hits, you know, you're in Bridgeport, which is one of the busiest housing dockets, certainly. And, you know, the type of cases that came in and how you dealt with that.
I just kind of started getting some chills because I remember it was a very difficult time. It was a difficult time because the decisions were even more heightened because there wasn't available housing stock out there. So evictions were extremely difficult on people. And I do know because we were operating pretty quickly as a branch with remote processes that a lot of decisions I was making early in the pandemic, and you know, were early decisions being made nationally because the other courts had not opened up. So you mentioned the restaurant case. You know, I know that, you know, I was called from a New York judge like, hey, I've got to deal with the gap on Times Square and you have dealt with similar issues here on this Norwalk restaurant. And it was heartbreaking at that time. Like one of the restaurant case that I think you're referring to, I was partially reversed because I didn't award enough damages. I found all the legal defenses and I got to analyze them. I think I analyzed them through impossibility during the time of the prohibition, issues like that. And even then, I'm like, this poor restaurant owner is closed through no fault of his own, and how the zoning works here in Norwalk, there's not enough room for outdoor dining. And this poor guy can't operate, and he signed the guarantee. So I kind of said, enough, I'm cutting off the damages at this point. And, you know, the reversal that came from the Supreme Court was, okay, all the legal analysis is correct, but as a matter of law, you have to even award more damages than you did. And even that was heartbreaking that I had to go back and do that. Okay, we're back for another hearing. And, you know, I tried to, I guess, show too much of a heart in that case. It was a difficult time, especially on the housing. Some of the decisions I made, you know, still show up today. I think Dawkins is one of them, where I was the first judge in the nation to say, hey, the CARES Act does not expire as it relates to non-payment provisions, which meant that even though there was sunset provisions throughout the CARE Act, the one little section in there about a moratorium on non-payment cases, they didn't put a sunset in that section. So that meant to me that to proceed with a non-payment case during the pandemic, even after the CARES Act had expired, I was going to require an extra 30-day notice to quit. And I know other Supreme Courts have followed that. And I know I was the first judge to do that nationally, but we were dealing with the difficult crises at the time. And the legislature stepped up incredibly with the Unite CT and all the programs through CHAFA to help people out. Ultimately now, right to counsel, and how much that has benefited people in the housing court. But it was a difficult time, and I'm glad I was there to make some of those decisions at that time, respectfully, because I think I did it in a way that helped both landlords and tenants as best as possible at the time.
So that's how, like I said, I wanted to ask that because I know during that time, I ended up having a bunch of cases before you. And I've always, even from not my cases, but observing you, as somebody said, sitting in the back of the courtroom is really important for people on this committee to do. And so times I've been able to sit in the back of the courtroom and observe you as conscientious and caring. The one case I have to ask you about, because I think you mentioned, housing cases aren't normally the ones that are on the front page of the newspaper. Normally it's, the big criminal case, or maybe it's a multi-million-dollar civil case, but one case did generate front page media attention when you're in Bridgeport, and that's the Pansy Wright case. And that's a case that involved a foreclosure action over what turned out to be a fairly small credit card deficiency. And we ended up, I will say, we as a legislature ended up taking action after that case. We as a committee realized that there was sort of a gap in the foreclosure mediation program, and that case wasn't technically eligible for foreclosure mediation program. And so we took action to fix that gap. But I know questions certainly have come up about that case and your handling of it. So I did want to make sure I gave you an opportunity to address that for us.
Well, the legislative change was probably a long time in coming, and not that you can mediate a credit card debt or a tax lien debt or a condo debt, because they are the debts, but giving people the chance to talk to a foreclosure mediator who can maybe talk about payment plans. The article indicated, and even through the pleadings, a payment plan was reached, and then the first payment had to stop payment on it. Those are the kind of things that if they were in with a staff person at our courthouse, say, no, this isn't, a scam that you're facing. Talking to court staff that understands the process is beneficial to people. I mean, there was a self-represented appearance, but no appearances at the hearings. And I did apply the law as it existed at the time. But we all learn from these things and how we treat people, how legislative changes may come into play. No one, whether it's the foreclosure judge, the housing judge, or even an individual, wants to see someone foreclosed, lose their housing, go through a restraining order, go through domestic violence, the things we deal with on all of our dockets every day. You make the decision you make based on the law, applying the facts as best you can at that time. But I think expanding mediation programs as you did does at least give more people an opportunity when they're in the courthouse to get those answers from a neutral party in the courthouse to assist them.
I guess just one follow-up question on that, and maybe the one unresolved question I kind of have, not to be overly blunt or direct, but how do you decide whether to grant strict foreclosure or foreclosure by sale? Because I mean, it seems that at least an argument could be made in this instance. Yes, she still would have lost her house in a foreclosure by sale, but she would have retained some equity potentially. How do you make that determination, bench?
Even when a defendant is not appearing, the plaintiff has the obligation to put forth their case and their documents to the judge. I looked at it again last night.
docket entry 114 in that case is the foreclosure worksheet that showed at that point in time, there was only $2,000 in equity because statutorily, Title 49, a judgment lien comes after those WPCA liens that were due, and there's a mortgage that was due. And the plaintiff gives you an appraisal. And this was before the pandemic, so before property values really went up. At the time of the judgment entering, there was $2,000 in equity. A foreclosure sale usually costs around $5,000. And in general, there's no bright line, but if it's less than 10,000, by the time extra debts come due during the time of a foreclosure sale, you tend to order a strict. Strict is the default type of form of judgment in our statutes. Sale only occurs if there is equity or if the U.S. is a party under 24 U.S.C. I think it's 2386, but don't quote me on that. So the default position should be a strict foreclosure. And this did fit the manner for a strict foreclosure. Now, the article does indicate like, well, the property value did go up and they sold it for a lot more money later. The pandemic hit, property values did go up. I've got an appraisal that the plaintiff presented to me that did not seem inaccurate on its face. Bridgeport at that time had higher assessment values based on the reval and the taxation. So it was not unusual for appraisals to come in below what the town assessed the property at, just the way Bridgeport's reval was at that time. And yes, property values did go up during the pandemic. At that time, there was also a pending appeal on an earlier case 3 months earlier in December, where I granted a sale instead of a strict, and they were appealing me for using the discretion to go with a sale. And ultimately, the appellate court did say that I did not use the right discretion in that case because the plaintiff had moved for a strict and there was no notice that anyone was asking for a sale. So I shouldn't have just on my own said, hey, there's equity. I want there should be a sale on this. So that was also pending at the time of this case. Time goes by and values did go up in Bridgeport, and they did throughout the state of Connecticut. But at the time that decision was made, it is based on the information that was in the court file.
Appreciate that. And certainly as somebody from Bridgeport, I'm no stranger to the fact that for better or worse, Bridgeport has had some of, on a percentage basis, has had some of the highest growth in value of real estate of any community in the state over the last 5 years. So questions or comments, further questions or comments? If not, Judge Spader, congratulations on your renomination and thanks for being with us today. Thanks for answering our questions.
Thank you.
Judge Stewart. You could raise your right hand for me. Do you swear or affirm, as the case may be, the information provided this committee to be the truth, the whole truth, and nothing but the truth, so help you God or under penalty of perjury?
I do.
Great. You can have a seat whenever you're ready.
So, good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel. I would greet Representative Fishbein, but he doesn't appear to be here still, and Senator Flexer, and all of the distinguished members of the Judiciary Committee. I am Elizabeth Stewart. I want to first of all thank Governor Lamont for nominating me for a second term. I also want to thank the members of this committee for giving me the opportunity to appear before you today and for considering my nomination. Since I was first appointed in 2017, I have tried to meet this committee's expectations for a Superior Court judge. I began my service in the Bridgeport GA, where I managed the domestic violence docket and where I handled several criminal trials. After that, I moved to the main courthouse in Bridgeport, where I did a very short stint in family, followed by a year in civil, followed by 2 more years in family, and then 1 more year in civil. Since that time, I have handled exclusively civil matters. I spent 2 years in New Haven, and since this fall, I have been in Hartford serving on the complex litigation docket. Throughout that time, I have heard and decided numerous family and civil court trials, and I presided over approximately 20 civil jury trials that have gone to verdict. I also have written and published many decisions on motions. The Chief Justice appointed me this past year to serve on the Access to Justice Commission, and as part of my responsibilities, I am the chair of the Pro Bono Subcommittee. Our mission is to try and make it easier for clients to obtain pro bono and low bono representation, and to try and increase the number of attorneys that provide those services. The Chief Justice also appointed me to serve on the Minimum Continuing Legal Education Commission, and I serve on the Rules Committee of the Superior Court. Community service is important to me. I have spoken to elementary school children about the law and what judges do. I have graded high school essays, and throughout my legal career, I've served on a number of community boards. During this term, I was on the board of the United Way of Greater New Haven, and through that organization, I've done everything from being the chair of the Strategic Planning Committee to loading groceries into the backs of people's cars during the pandemic. It has been an honor and a privilege for me to serve as a trial judge. I get to learn new things, I get to hear interesting cases, and I get to help people. I would be deeply grateful for the opportunity to continue to serve the people of Connecticut in the second term. I thank you for considering my nomination, and I would be pleased to answer any questions that you have.
Rep. O'Day.
Thank you, Mr. Chair. Good afternoon, Your Honor. Congratulations on your renomination.
Thank you, and good
Just-
afternoon to you.
I'll get the standard ones out of the way first. Willing to serve anywhere in the state, including, if asked, family in Stamford.
Yes, sir. In fact, during the pandemic, when Stamford was closed down, I had the honor and privilege of handling many of the Stamford family matters while I was a Bridgeport family judge. But yes, I would be willing to do that.
So, as you probably heard, I'd asked some questions of those that have served in family, if they have any ideas on how we can improve it. It's a loaded question, I know, and we're going to be obviously talking about that a lot this session. But as you sit here and have contemplated it, listening, any low-hanging fruit that you can think of for us to try and make things better?
I have a few comments for you. First of all, I mean, as you probably know, there's very little statutory law with respect to family compared to, for example, civil or criminal. I don't think that really needs to be embellished. There was some discussion back and forth, particularly when Judge Bozzuto was up here regarding the Pathways program. That actually is in the practice book now, but it's the January 1st, 2025 practice book, which none of us, including us judges, have in our hands yet. My view would be to let those changes start to work. I observed towards the end of my tenure in family when we were transitioning to that, even without the practice book rules, many of the things that Judge Bozzuto pointed out. I mean, the mere fact that if you have an agreed upon divorce and you can hand it to the judge on the papers and have the judge approve it, is made a huge difference. Doing all those things just to get the people who are getting along and have a plan out of the way so that we could spend more unobstructed time on everyone else was of great benefit. And I do think, I do also agree that when I first came to family, having spent my career in civil, and I was like, gosh, this is short calendar from the 80s. We were hearing arguments on motions for extension of time, and there was all this stuff wasting time. I think this whole notion of in advance setting a hearing time for people is far more civilized. So I think there's a way to go, but my counsel would be to wait a year or so and see if once we've transitioned over to this new system, whether things will work better, because I think that they will.
And I see that you, since your last appointment, you've had one complaint dismissed. Can you just give us some information on that?
Yes, I think I was 2 or 3 months into my GA assignment, and there was a person who failed to appear, and I was asked to, and I did sign a warrant for that person to be rearrested. They were rearrested, and they were not happy about that.
Based on that one, and I commend you on only having one, particularly in all your family experience. So
Thank you.
That does speak volumes. Anything about that complaint that had you reflect and change your mind or have any impact on your, I don't want to say demeanor or your practice going forward?
I can't say that that one individual complaint had an impact. I will say this, I've had many, many reviews, particularly for my time sitting in family, because there are so many more proceedings in family that would give cause for those reviews to be filled out. I have taken those very seriously and have reflected on them, particularly to the extent there were any themes in those.
And I haven't, and I will say, as much as I tried, I don't know, I didn't see any written oppositions to your reappointment. Are you aware of any?
I am not.
And the Robitis question, having not appeared before you, and not seeing any written complaints, other than the one we just talked about, but from a Robitis standpoint, how can you assure us that that won't be a problem in the future?
I am, as I said, I do continuously pay attention to the reviews that I get, and I do try to read the room when I'm on the bench, and get that sort of instant feedback, if you will. And I've, frankly, since I was a 16-year-old restaurant employee, had a service mentality, and I try to maintain that.
Well, thank you very much for your responses. Congratulations on your reappointment, and thank you for your service to the state of Connecticut. Thank you, Mr. Chair.
Further questions or comments from the committee? Further questions or comments? There's not actually, Judge Stewart, just one question. I know you serve on the MCLE committee, and there's been some in the legislature and gone back and forth on whether it should be statutory or rule change or whatever, but there's some folks in this building who would like to see some, if not all, of your CLE credit be satisfied by doing pro bono work. Do you have a thought on that?
Well, I guess the concern I have mixed thoughts on the fly here. One is, I would want to make sure people are still having continual legal education. So I'd be a little concerned by saying, as noble as I think the pro bono work, obviously I'm the chair of that committee, I would be concerned about sacrificing that continuing legal education. So that's one thought that I have. I do really want to increase people's participation in doing pro bono and low bono work. I think it's extremely important. I am sure that the bar would not be enamored of us making it mandatory. I would prefer that people do it and come away with that feeling, as I personally, when I was in the bar, that feeling of like, wow, I really did something to help someone today. That was good, rather than mandate it. So those are my immediate reactions, but I would certainly be in favor of just about anything that would increase people's participation, lawyers' participation, in doing pro bono work.
Well, I'm hoping that the commission's going to take that up this year and look at that seriously, because I think, at least where I sit, I think, you can make an argument on whether whether we should or shouldn't be mandating CLE, but we'll leave that for another day. But if we are going to, it seems to me that particularly doing pro bono work in an area of practice that's not your own, if you're a civil litigator and you're taking on a criminal case, or if you're, a civil litigator or criminal lawyer and you're taking on a housing case or something, I mean, you're learning something about the practice of law, probably more so than sitting there watching a video on, PLI or whatever. So I guess I'll preface this by saying I feel pretty strongly that we should allow pro bono to count towards your CLE requirement. So I'd ask you guys to take a look at that, and if it's not 12 hours, maybe it's 6 hours, but I think we should be looking at that.
All right.
I'm seeing some thumbs up on my colleagues, so we may have a bill. Senator Winfield.
Thank you, Mr. Chair. Have you been here today the whole time?
I have indeed.
I'm confused about your answer to Representative O'Day, that given the context that has been established in this hearing. I respect that you think about what's going on, you pay attention in the court, and that you have times that you worked in a restaurant and all of that. But I think what we've been working on establishing here is that it's more than that. And so the answer that you provided is a little baffling to me. I will be honest. And I tried to not do this because I think all of you are qualified. I think likely all of you will have no problem after this in the vote. But that answer is a little astonishing to me, given what has played out here today. So I'm going to run that back and ask you to hopefully give us an answer that's responsive to the fuller question about Robitis and then its connection to the question that I'm asking about system of accountability that's more than my gut, what I'm perceiving, that takes into account the experiences of people in the court and the need for people with the power that you have. And I will say this, I say this to my colleagues all the time, we have to have the same kind of systems of accountability, right? Because we all have a lot of power to affect people's lives. Can you respond to that question and also touch on the system of accountability you have in place?
All right. I'm sorry, I was anticipating you separately asking that question, but in any event, I have several responses. I certainly agree with a number of the comments that my colleagues have made. I'm not going to repeat those. I have not developed, although I might start copying it now that I'm on a docket with a lot of lawyers in front of me, the system that Judge Pearson described, which sounds excellent. I will fully confess I have not done that. I do try to read the room, and that was very important, I thought, when I was sitting on family, when frankly, most of the people in front of me were self-represented. I've done some of the things when it was not a formal proceeding, but it was a settlement discussion that Judge Ozalis represented. In other words, I come out without a robe on. I sit down at the same level of those people, the litigants are, and look at them straight in the eyes and try to really not only hear them, but make them understand I am hearing you. Because unfortunately, if they don't work out a resolution, there's going to come a time when I'm going to have to make a decision, and at least one of those people is going to leave thinking that it wasn't fair, or I worry about it not being fair. So those are some of the things that I've done. I've also found that time can be my friend. And when this courtroom is getting heated, whether there's lawyers in there or not, I think that it's important to call a recess and step back myself. I mean, if I even start to feel like I'm getting into it with the people in front of me, I know that I need to call that recess. And even if I'm not, but they are getting into it, I know I need to call that recess. I also find that time is very important when I spend a lot of time writing decisions, but instead of just hitting submit and sending the thing out, I need that extra time to either go and talk to somebody, not about exactly what I'm going to decide, but am I on the right path? Is this going to be fair? Are people going to come away feeling that they got something out of this that was to their benefit and that solved the problem or helped to solve the problem? That time to reflect is very important to me. So I don't know that fully addresses your question. Will say that I do some of the things other people have mentioned here, like I do listen to myself and the other people, obviously, that were with me on the recordings that we have from time to time. I find that to be very useful.
I just want to let you know that I don't pose this question as some sort of gotcha question, right?
No, I understand that.
And I want to point out something you said that I think is important. And it's not all the stuff that probably most folks would think was the important part of this. It was the part where you said what you hadn't done and now you would consider it, right? To me, that's part of the reason that this question gets posed. Sometimes folks are doing really good work. They're doing all the things we would want them to do, but there's something they just didn't see. And sometimes folks don't get it when someone asks them a question or pulls them aside. The fact that you recognize that that's a good idea, given the context of this hearing, and it's something that I might want to implement, that's good enough for me, right? So I want the folks who are hearing this question not to say, I have to have a perfect answer. I don't care about a perfect answer. I want to know that you're thinking about the people who are in that courtroom, that you're thinking about, is there a way for me to do the job better? And that answer about what's internal doesn't hit it. So I actually want to thank you for talking about what you haven't done and what you, I think, suggested you plan to do, because I think that's as important as any answer anyone else has given me today. Thank you.
Well, thank you. As I said before, I learn something every day, which is one of the best things about this job, and I appreciate that.
Further questions or comments from the committee? If not, Judge Short, congratulations. Thanks for being with us.
Thank
you. Judge Carl Taylor. You could raise your right hand for me. Do you swear or affirm, as the case may be, that the information provided this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I so swear.
Great. Have a seat, and whenever you're ready, we'll hear your opening statement.
Good afternoon, Chairman Winfield, Chairman Sandstrom, Vice Chairs Flexer, Gadkar Wilcox, and Facino, as well as the ranking members, Kissel and Fishbein, and the other distinguished members of this committee. I am honored to be here before you today. I'd like to thank Governor Lamont for nominating me for another term as a judge of the Superior Court. Since my last appearance before this committee in 2017, my assignments have been primarily on the criminal bench and the juvenile bench. At the time of my last reappointment in 2017, I was assigned to the Talon Judicial District, where I handled criminal, housing, and juvenile matters, and was actually succeeded in the criminal matters by Judge Gordon, who was here today. I next spent 2 years in juvenile court in Hartford. I then went to juvenile court in New Britain, where I was the presiding judge of the juvenile court for 3 years during COVID. I am presently a trial judge on the criminal side in New Britain. I also handle administrative appeals under Judge Budzik, and I've also actually tried a civil jury case with 3 pro se litigants to verdict. It has certainly been a privilege and a challenge to sit as Superior Court judge and to preside over cases that are extremely important to the lives of the residents of this state. I would also add that I have served as a mentor for a new Superior Court judge. I have served on the grand jury panel. I've been a presenter at the Connecticut Judges Institute, and I've been a member of the Rules Committee. I'm also a member of the Connecticut Lacrosse Hall of Fame. I've received an award from the Connecticut Lacrosse Coaches Association for being Man of the Year. And last spring, I received the New Britain Bar Association Public Service Award. I've been a coach in West Hartford Youth Lacrosse for over 42 years. I would be most grateful for the approval of this committee and of the General Assembly for me to serve another term. And to that end, I will welcome any questions that you may have. Thank you.
Report.
Thank you, Mr. Chair. Good afternoon, Your Honor.
Afternoon.
First, thank you for your years of service with the state of Connecticut and congratulations on your renomination.
Thank you.
I will save my questions about college lacrosse at a later date, and your awards, when it's just the two of us, but, congratulations on that.
Thank you.
So to get the basic questions out of the way, are you willing to serve, anywhere in the state of Connecticut in any capacity as, including family law in Connecticut or in the family, law, family bench down in Stamford?
Yes, I am.
And work at least 9 to 5, Monday through Friday?
I work 9 to 5, but for me to get the job completed, I usually end up working nights and weekends.
So, and thank you for that. And I see, you had one complaint dismissed, and I read about it in the questionnaire, but is there, in your own words, anything about that complaint that, altered your demeanor or anything, in how you handled yourself on the bench?
Well, I don't think that particular issue was a demeanor issue as much as it was a dissatisfaction with the ruling that I made. The lady in question, I think, wanted custody of her teenage daughter back. And it did not appear in the best interest of the teenage daughter to go back with her. The teenage daughter was doing well with the father's side of the family, and and actually she had indicated that she felt that her best interests were staying where she was.
I don't have any further questions. Well, temperament issue, Robitis, there hasn't been any complaints that I could see. Are you aware of anybody, opposing your renomination?
I am not.
I didn't see any. And I realize that, this is going to be your last time before us. But for the next few years anyway, how would you answer the Robitis question? I've never appeared before you. I can imagine that it's not an issue for you, but how can you assure members of this committee that Robitis will not be an issue for you in the next few years?
Well, I've been around the system a long time, both as a judge and as a member of the state's attorney's office. And I think one of the primary issues in that situation is you must remember you're dealing with people. Whether you're charged with axe murder or spitting on the sidewalk while chewing tobacco, you're dealing with people. People make mistakes, and you have to always keep that in mind and treat them in the manner which you would want to be treated if, God forbid, you were in that situation, or in the manner that you'd want a family member treated.
Well, thank you for those responses. Congrats again on your renomination and good luck going forward. Thank you, Mr. Chair.
Thank you.
Questions? Judge Taylor, just a couple I have. First, on the Robitis question, have you had a chance to look at your most recent scores on the judicial performance evaluation?
I think the last time that I looked at them was probably about 6 months ago, maybe.
Okay, and what were the years from those?
They were, to the best of my recollection, they were the most recent ones.
Okay. Because the most recent ones I have is 2015 to 2019. Do you know if there's any more recent ones than that have come out?
Not that I recall.
Okay. Because in your 2015 to 2019 performance evaluations, you scored on par with your peers in legal ability and management skills, but frankly, your comportment score was a D plus. When most judges are at about the average is a B plus. And any reason why your comportment score would be sort of an outlier among your peers, at least back at that period of time?
In all honesty, I don't know. The only thing I can say is I was dealing with a lot of the same people because I had fairly lengthy juvenile assignments.
Right, but this is based on, so this is, I mean, admittedly, it's not the biggest sample size, but it's 26 respondents. And these are folks who generally have had cases tried through or have settled after evidence started. I mean, these are fairly involved cases. And like I said, I mean, we get these for all judges, and we've got the average. So the average, if we take all the judges across the system, the average comportment score is just under 90%. Yours is under 70%, or was under 70%. I guess I need an explanation of why you believe that is.
And as I said, I don't know why the score was like that. I treated people with respect. I think, some of them didn't like my decisions, but I always treated people with respect and made the best decision I could under the circumstances.
Right. So those same people graded you as about an 85 on legal ability and on management skills. So they gave you relatively high marks on legal ability management skills, but then those same respondents, there was a noticeable fall off to your comportment. Have you done anything since 2019 to sort of address any perception that you may have, there may be some concerns about your comportment on the bench?
Well, one of the things I did, I ended up leaving juvenile and going to criminal. Working on, one of my thoughts was perhaps I'd been in juvenile too long and someone else should have an opportunity coming in with a fresh look at it.
Anything else?
As I said, to the best of my recollection, I've treated people well. I don't yell at people, don't scream at them. You may not like my decision, but it's going to be the best decision that I can make. And I would think that my cases that have been up on appeal, I've had some are worse, but I think majority of them have been upheld.
We ask folks in their questionnaires to list 10 cases that they consider to be sort of their most significant over the last term. And you gave us four of your 10 cases were cases in which you were overturned on appeal. Is there a reason why you listed those as the most significant? Was that the totality of the cases in which you've been overturned on appeal? Is that why you listed them, or?
It's a totality that, to the best of my recollection during this term, I've been reversed on appeal. And I thought it was important that you folks know that.
I certainly appreciate the candor, and I agree with you. I appreciate that. Let me ask you about a couple of them. So you listed the State versus Lopez case. I'm trying to understand the summary here, but it sounds like the defendant there was charged with a violation of a condition of probation, and that charge of violation of probation was that he had a pellet gun in his house. Is that right?
Yes.
Okay. And you revoked probation based on the presence of the pellet gun and sentenced him to 8 years of incarceration. Is that right?
Yes.
And that was overturned on appeal for
It was.
insufficiency?
Yes.
I'll admit, I don't practice criminal law. I mean, is 8 years for violation of probation? Where does that fall sort of in the pendulum? Is that a lengthy sentence for violation of probation? Or, I mean, it seems like seems pretty lengthy to me.
It was a lengthy sentence, but the gentleman owed, it was less than what the gentleman owed. He owed a lot more than that. He had a record that was none too good. I think he had a conviction for being involved in drive-by shooting, and he also had a prior conviction for being a sex offender.
All right. All right. Then in the Inri Armani case, the appellate court held that you exceeded your authority to order DCF to cease reunification issues, and that your rejection of the permanency plan was not a final judgment that was immediately appealable. So this was an instance where the court said you exceeded your authority. What was the situation there?
Situation there was, it was a child with some very serious health and respiratory concerns, and the father kept smoking around the child on visits. It was a situation where the child's health, I believe that the child's health was endangered, and I would, pardon me, I wanted DCF to do something about getting the father to stop smoking, clean up the house so that the child wouldn't be exposed to cigarette smoke, and go from there.
Was DCF a party at the time, or?
DCF was involved.
Okay, all right. All right, Senator Winfield?
Thank you. I want to go back to the scores. And when you're answering, it would help me because I'm having a difficult time hearing you. If you could approach the microphone.
Sorry.
So you said to Representative Stastrom in response to his questions that you had reviewed your scores. So were you aware that your scores were what he suggested they were?
I was aware that some of them for a period of time and concerning that issue were on the low side.
So is that the point at which you, when did you review those scores?
I would assume it was somewhere around the pandemic.
Is that the
maybe a
reason?
little later.
Sorry, I didn't mean to step on you. Is that the reason you chose to leave, or you asked to leave, or however that happened?
Well, I came to realize, quite frankly, I'd given it all to juvenile. I didn't have any more to give.
I'm not sure what that means.
What it means is I thought I had worked as hard as I could, and I was just, quite frankly, worked down
Okay.
in terms of dealing with juvenile, and I needed something else to do.
And how, if you can imagine or talk a little bit about that, how do you think that relates to the scores though? And let me clarify, because I want to make sure that you have a fair opportunity. You can work in a place where you've worked yourself to the bone, whatever the case may be, but when you leave that place, what is reflected by your time there is glowing, right? So how does the fact that you had given everything you have to give result in what we see here?
In terms of
the scores being what they are.
And as I said, in all honesty, the specifics of the scores, why people reach that assumption, I can't tell you. As I said, I treated people to the best of my ability. Didn't yell at them, didn't treat them badly. I made decisions that a lot of people didn't agree with. And to that end, I finally got to the point where I had thought I had done all I could do in juvenile, and it was time for me to move on.
And did the presence of those scores in your mind suggest that more than maybe you haven't given your all, that it meant anything else, that it might have meant there's something that you're not seeing, there's some assistance you might need, anything other than you worked to the best of your ability?
No, because as I said before, Senator, I really didn't understand why people would complain about my comportment, because I didn't treat them poorly. I treated them with respect, and that was it. To the best of my knowledge, no one said anything to me about it. And in retrospect, I can't think of anything specifically which would get people to be upset.
And as I look at the scores, this is not an insignificant deviation. It's actually significant, right? So I guess this is why I keep harping on this notion that accountability has to exist outside of oneself. Because as you suggest to us, I can't see this, I don't see this, whatever iteration on that theme. But clearly these scores don't just come from just anybody, right? So clearly folks who have a sense of, did you want to?
No, you finish. I don't want to interrupt.
Folks who have a sense, they, as was suggested by Representative Stasham, on the other measures, they represented you right in line. But folks who have a sense of how these things work and who don't just judge willy-nilly have a difference of opinion. And you did not see it. And at the point where it was made clear to you the system of accountability you seem to have in place, and I'm going to be fair to you and allow you to speak a little bit on your system of accountability, but the system of accountability that you have in place, which is, again, largely your perspective, your gut on these things, said to you it's time to move on. And I don't want to put words in your mouth, but that there was nothing there to correct. So if you could talk to me about your system of accountability that might be different than what I'm hearing and perceiving here, and whether or not what I'm suggesting to you I've heard is correct, that would be helpful.
Well, as I said, one of the things I did was I realized that it was time to move from that assignment. I moved back to criminal, where I think that that assignment was one where I was able to do more in terms of the nature of the business. And also it was an assignment where more, I was able to, we had more people there, you could talk to them. And I had suggestions from other people as to things I should be doing. I had suggestions for them as to things they should be doing. Doing juvenile is sort of it's more of a solitary existence.
Though there are ways in which one could seek to not be solitary, correct?
Well, because of the confidentiality in juvenile, it sort of makes it a little more difficult.
I guess what I'm asking you, and I get that, but I guess what I'm asking you, if one were able to perceive that there were some issues without violating confidentiality, there are ways in which one could seek help, mentoring, assistance, whatever.
I'm sure there are.
Did you do that?
At that time, no, I left the assignment.
Thank you.
Representative Fishman.
Well, thank you, Mr. Chairman. Good afternoon, Judge.
Yeah,
The confidentiality in juvenile that you just brought up, I guess it's a double-edged sword, because a judge who's not in a sealed courtroom, many times, courtroom is packed. So the decorum of the judge is not only being reviewed by the litigants, but the whole gallery. And I think that may, to a certain extent, keep that particular judge in check. You mentioned that nobody had brought to your attention, other than the scores, particular issues. What would you have expected a litigant in juvenile court to do that was unhappy with your comportment?
Well, I suppose it would depend on the person. There are enough people in juvenile court who'd known me for long enough who would be able to come in and say, you need to do this or you need to do that. You need to tone down this. There's a fair number of the people I knew.
But the litigants don't have that opportunity, right? So if it's the litigants, it's the lawyers that are doing these reviews. So we're talking about these scores, and those aren't done by court staff. They're done by individuals that are before you. And you had said that nobody had brought it to your attention. So I was just trying to conceptualize the person who's before you. There's a lot of appointed lawyers in juvenile court. There's kids get into trouble, they have an attorney appointed for them, perhaps as a GAL and stuff like that. And those are the people that are doing these reviews. So representing a child who's in juvenile court who's unhappy with your comportment, which results in the score, how would you anticipate them bringing that to your attention in the courtroom or after that matter?
Through their lawyer.
Okay, so then the litigant, let's say the 16-year-old kid who's arrested for stealing a car, says to their lawyer, I think that judge was a jerk. I don't, that's the process that we're dealing with. what would you have expected the lawyer then to do? To bring it to
Well-
your attention?
Well, the lawyer could always come back and Chambers or see me another time and say, listen, I think you're a little hard on him, or what you said wasn't appropriate to him, or something of that nature.
Okay, I understand your perspective, and thank you, Mr. Chairman.
Thank you. I guess, Judge, I mean, do you know how hard that is for a lawyer? Particularly someone who's going to appear before you time and time again, may have another case before you, that it's going to come back in chambers afterwards and say, hey, you really treated my client like a jerk out there. I mean, that's what you expect a lawyer to do?
I think some lawyers are well capable of doing it, especially those who have been around a long time, been around a while, not a long time. And I think there are enough lawyers who have known me long enough where if they perceived the problem, they would come back and talk to me.
All right. I mean, I guess I'll just represent on these scores. Like I said, admittedly, it's from a few years ago, but the profile of the respondents, it's 26 respondents, 60, all 26 of those are lawyers who submitted the evaluation. Of those, 16 of those 26 lawyers have been practicing for 10 years or more. So, I mean, we're talking about relatively experienced litigants who are in your court who have given you a D+ on comportment. All right. Further questions or comments from the committee? If not, appreciate being with us. Judge Welch.
Thank you.
Judge, if you could raise your right hand. I do swear or affirm, as the case may be, that the information provided this committee would be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury.
I do.
Great. Have a seat, and whenever you're ready, we'll take your opening statement.
Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Tom Welch, and I'm profoundly humbled and grateful for the opportunity to appear before you today. Thank you. I would also like to thank Governor Lamont for renominating me as a Superior Court judge. The past 8 years have been extremely challenging and rewarding. In 2017, I was assigned to the Danbury Judicial District, which is a block assignment where I was primarily covered the GA hearing criminal matters. I was also able to hear civil court trials, civil jury trials, and housing, zoning, and foreclosure cases. In 2018, I was assigned to the Bridgeport Judicial District Civil Division, where I have remained to the present time. In addition, in May of 2019, I was appointed as the Assistant Administrative Judge. In August of 2020, I was then appointed as the Administrative Judge, a position I continue to hold. Since September of 2023 to the present, I have also been serving as the presiding judge for the Civil Division. Additionally, I've served as a member of the Executive Committee for the Ansonia Milford Judicial District, the Judges Education Committee, the Civil Jury Instruction Committee, the faculty for the Connecticut Judges Institute, and as e-judge for the Bridgeport Judicial District. Finally, I have also served as a faculty member for pre-bench orientation program for new judges. The past 8 years have been an honor and a privilege to sit as a Superior Court judge and preside over cases that are so important to the residents of the state of Connecticut. I continue to learn every day and would be most grateful for the opportunity to serve another term. Thank you. I'd be happy to answer any questions that you may have.
Representative, oh, Callahan. Let's switch it up here a little bit. All right.
Thank you, Mr. Chairman. To be brief, good to see you, Judge Welch. The curse of having a W for a last name, huh? But it was a pleasure serving with you when you were in Danbury Court. I did witness Judge Welch, how he interacted with staff, how he interacted with the public, and it's exemplary, to say the least. Judge Welch is exactly the type of judge that I want to see on the bench in Connecticut, the way he treats defense, the state, and anyone who comes into the courtroom, and not more importantly, but I guess equally important, the staff. So you're just a good-hearted person with a brilliant legal mind, and I'm happy to see you in front of us here today. And I'm very happy that you're hopefully going to move through smoothly.
Thank you.
Rep. O'Day.
Thank you, Mr. Chair. Good afternoon, Your Honor.
Good afternoon.
It is I echo the comments of my colleague to my left here. You are I've had the pleasure and honor of being before you in Bridgeport, not as often as I'd like. I do love the Bridgeport Superior Court, but you are a credit to the state of Connecticut, and thank you very much for your service. A few questions that I've been asking everybody. First, are you willing to serve anywhere in the state of Connecticut, including Stamford? Perhaps we can poach you from Bridgeport. So would you be willing to serve in Stamford?
Yes.
And are you willing to work at least 9 to 5, Monday
Yes.
through Friday?
Yes.
And I went through the documents provided by the CCDLA, which unfortunately it looks like you got a positive review from not only Attorney Gavin, but also my friend and colleague Mark Phillips. So he made a liar out of me. I didn't know that he also wrote a letter of recommendation for you. I didn't see any letters in opposition, which are you aware of anybody opposing your renomination?
I am not.
So I will leave it at that. I will say thank you again for your service to the state of Connecticut, and you are a model jurist, and I greatly appreciate the governor putting you up for renomination. Thank you, Mr. Chair.
Thank you.
Thank you. And Representative Doe, for the record, although he might be willing to serve in Stamford, the Bridgeport Bar is certainly not ready to let him go to Stamford, just so it's clear. Madam Chief Court Administrator in the back, let's be clear on that. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Judge Welch. In your, this was your first term, correct?
Yes.
And during that term, have you sat in family at all?
I have not.
Is there a reason for that?
I will correct that. As the administrative judge in the district, I have taken on a few occasions the family support magistrate docket, just as filling in when it wasn't covered. So, but currently I've been assigned as the administrative judge in Bridgeport and in the civil division, and currently sitting as the presiding judge of the civil division.
Okay. And how long have you been in that role, that particular role?
The administrative judge position since 2020, and as the presiding judge of civil since September of 2023.
Have you ever put down on your questionnaire that you'd be willing to sit family?
I have not.
Okay. And I noticed in the area, we asked in the questionnaire, what areas of law do you enjoy the most as a judge? And you basically said it was a lot of different things that can come my way civil, right? I didn't think that zoning appeals and probate appeals made it to your court. I thought that most of them go to New Britain.
So in Bridgeport, let me take a step back. In Danbury, I handle zoning appeals. Not all zoning appeals go to the land use docket. That's an option. You can make an application to go to the land use docket, unless it's an affordable housing appeal, then it goes to the land use docket. And in Bridgeport, I've done a number of zoning appeals in Bridgeport as well. And the administrative appeals, meaning tax appeals, we send to New Britain. But probate appeals, as you can see from my list of 10 most important cases, there was a probate appeal in there. In probate appeals, we handle it in Bridgeport.
Okay, thank you for that. And I know, I think Attorney Representative O'Day asked you about serving in family in Stamford. Would you be willing to serve in family in any district should you be reconfirmed?
I would not only be happy to serve family in any district, but any assignment that is given to me.
Okay, thank you. Thank you, Mr. Chairman.
Thank you.
Further questions or comments? If not, Judge Welch, great to see you. Congratulations on your renomination. And I know a number of folks do this around the state, and a number of nominees, but as we're on our last one, I want to particularly point out and thank those nominees and those judges who are active in their local bar associations. You know, you are the presiding judge in Bridgeport. You're the face of that courthouse in so many ways. The last two Bridgeport Bar Association events I was at, you made a point of being there, not just being there, but of shaking the hand of pretty much every lawyer who was at those events. The way you work the room, the way you're involved in the local bar, I think is a model for what we should be getting from all of our judges around the state, particularly from our presiding judges. So thank you for that.
Thank you very much. Thank you.
All right, that will conclude our list of nominees. We do have members of the public who are signed up to testify, some in person and some remote. The first one I have is Ivelisse Correa.
That's me.
Go ahead. And ma'am, just as this is our public hearing, I will remind folks we limit folks to 3 minutes so that we can get through everybody. So please try to keep your remarks brief. If folks have submitted written testimony, we do not need you to read your written testimony to us. We have that available. And feel free just to summarize and address anything that's not in your written testimony. So with that, please proceed.
Yes. So I'm here for 3 candidates. First, it looks like you're going to reappoint Raheem Mullins. Best of luck to him. So I do support him. Second, Matthew Budzik. Life has brought me into many courtrooms with him, and I've been able to observe he is a very fair judge, and I do hope that he is reappointed. And then finally, the judge I'm here for, Barry Armada. I am here to oppose the reappointment of Barry Armada. I'm not sure why he was appointed in the first place. And while he may be great in other parts of the judicial branch, I have never been before him because I do not live in New Britain. I have watched him victimize countless Black women, some of who have come to me for help. He doesn't care if these women have been abused. It seems like he has a vendetta against Black single mothers. Children have been put into abusive situations by him. He has returned children to active crack addicts. Someone came to me, and this was recently, so they were actually in touch with reporter Tom Hopkins from CT Investigator, and he was actually looking into a case with Judge Armada because the mother was threatened with a gun by the father, and she was told by Judge Armada that despite being threatened with a gun, that she would be held in contempt if she did not turn over her children, only for the father to sit there and violate the court orders, threaten the mother when she attempted to pick up the children. And thankfully, when she filed an ex parte, I had to walk her through it. She was able to get some relief, seeing as police had to get involved. I would hope that Judge Armada is sentenced to retirement and not reappointed. He puts Black mothers at risk, especially single mothers. I understand there may be some sort of fatherhood initiative going on. I also have seen him, if the father is an active father, but, like maybe lives with the mother, there's been a little discrimination on that end. And I'm wondering if the Judiciary Committee was aware of a lawsuit from 2021 where he was named as a defendant in a lawsuit with 2 African-American professionals for forging court documents in order to initiate and maintain a legal prosecution against them. So this would be an immunologist and a certified public accountant. They were detained by Troop D in Danielson, Connecticut in 2019. They previously had no criminal history. So I would hope that he is not reappointed and
Thank-
sent into retirement. Thank you very
Thank-
much for allowing me to speak today.
Thank you. We appreciate it. Questions from the committee? Seeing none, we appreciate you being with us today. Next up will be Attorney Ed Gavin. Attorney Gavin, you don't have to take an oath. You look like you wanted to stick your right hand in the air. So unless you want me to put you on a docket someplace in doing family court in Stamford, you can just have a seat. So I thought you might take a pass on that. Go ahead, take a seat, and turn your microphone on.
Chairman Winfield, Chairman Staffstrom, Vice Chairs Flexer, Wilcox, Vizino, and Ranking Members Fishbein and Kissel. My name's Edward Gavin. I'm a past president of the Connecticut Criminal Defense Lawyers Association, and I appreciate the opportunity on behalf of CCDLA to appear before you this afternoon. We have submitted for your consideration from our 350 members of the CCDLA commentaries regarding the reappointment of the slate of judges. This is my 17th year testifying here at the Judiciary Committee. We welcome the opportunity to go ahead and provide you with comments from the trenches in regard to our observations of the judges in the courtrooms. There's obviously judges that are up for reappointment that are perhaps in the family forum that we don't practice in, so we don't have comments regarding them. I would like to just call your attention to three of the individuals that were up for reappointment. I can't say enough good things about Judge Bozzuto. She has been outstanding in dealing with our needs in the criminal forum. If I pick up the phone, she answers the phone, she calls me back. She's willing to talk to us about anything, whether it's opening a courthouse late in the morning or parking or how people are being treated in the courtroom. She's just absolutely wonderful in that regard, responsive, and I thank her for that. On the criminal side of the house, you saw the submissions regarding Judge Clatt. Judge Clatt is one of the top trial judges in the criminal forum. She was a great prosecutor in Waterbury. We were sad to see her leave the state's attorney's office, but she's excelled as a judge in the criminal forum and should be reappointed without any reservation. The last one I'd like to just briefly mention is our last candidate, Judge Thomas Welch, the presiding judge in Bridgeport, where I practice. Judge Welch is just absolutely wonderful. He could run a judicial district anywhere in the state, and I'm sure he would. Some of the questions from the committee have been, do you have any problem working 9 to 5? That's a half day for Judge Welch, and he'd be happy to go cut the grass before court started if you asked him to do so. He's really just a spectacular individual. He's a great judge. He's fair, he's reasonable, and he also should be reappointed. So I appreciate the opportunity. I know it's late in the day, and I'd be happy to answer any questions that anyone on the committee has. I thank you.
Thank you, Attorney Gavin. Are there Representative O'Day?
Sorry, Mr. Chair, just real briefly. Attorney Gavin, thank you for your testimony. Just to be clear for members of the public and the committee, your organization has recommended not to reappoint judges, correct?
Oh, absolutely.
Over a dozen over the last number of years, correct?
Sure. What we do is we ask the membership to go ahead and submit the commentaries. We send them in verbatim. We don't edit anything. There are judges that have come up for reappointment, and perhaps you were there. I certainly know that there are members of this committee, including Senator Kissel, back in the day when we were here past midnight, wondering whether or not judges would be reappointed based on their conduct. So it's not just here for us to go ahead and give accolades to the judges. If I have a problem with a judge or somebody comes to me or my membership, I call Judge Bozzuto right away. We're in constant contact with judicial selection. We're not cheerleaders here.
Well, thank you. And thank you very much for your 17 years of service to the state of Connecticut. Appreciate it. Good seeing you
Thank
there.
you.
Good luck
Good
with the
seeing
rehab
you.
on the knee.
Thank
you, Mr. Chair.
Thank you, Representative. Representative Blumenthal.
Thank you, Mr. Chair, and thanks, Mr. Gavin, for being with us here today, as well as all the commentaries that you and your members have provided. I've always found them helpful. And I was just wondering, in terms of how other areas of the bar may be able to contribute similarly, what we can learn from your practices. And so how have you handled the fear, perhaps, among your membership that there may be a possibility of retaliation if they say something negative about a judge who's up for appointment or reappointment?
I'm going to show my age here. I'm not afraid of any of the judges that sit on the bench. And if I have a problem with somebody, I have no problem voicing that opinion. And I have no problem saying to them that they're acting inappropriately. And sometimes it's better off if you're a new lawyer, you're a new public defender, you're just getting your feet wet. Sometimes it's better that the gray-haired members would go ahead and voice that concern. It's always surprised me, honestly. Why isn't a family bar here? The job you guys have is so difficult, and why the other, the Connecticut Bar Association and the other family law sections, why they're not here helping you decide on reappointment issues is a mystery to me. We started doing it because we had a problem with a high-profile case and a judge being reappointed, and John Schoenhorn and I came in here and we spent hours, and when I believe the lieutenant governor cast the final vote, I think that's right, Senator Kissel, in regard to the reappointment of a specific judge. But so it's fine for us, and the vast majority of the judges are wonderful. They really are. But if there's a problem, we have no problem bringing it to your attention.
And these commentaries, if they're ever in the negative, do you ever submit anonymized commentaries? Have you found that to be helpful? Is there any other method we should be recommending?
What I tell the members is they have the right to go ahead and sign an anonymous submission. But if I was on the committee, I wouldn't take an anonymous submission and I wouldn't give it the weight that somebody that signs their name at the bottom of the document. So I give them that opportunity. I don't think there's one anonymous submission in this package. I think it's 38 pages of and not every judge we have comments on because we don't know some of the judges. But we do give them that opportunity and we encourage them to go ahead and sign their name and stand up for their opinion.
Okay, I appreciate that. I could certainly, it sounds like you've had a different level of results, and I don't know if that has something to do with, the criminal defense bar or your leadership, or I won't try to speculate, but I could imagine how lawyers might be hesitant to sign their name to a negative appraisal of a judge. At the same time, I think, we often get litigants in here, which is understandable. There are often litigants who are unhappy with a judge. It's understandable, in every case, somebody wins, somebody loses, and someone is going to be unhappy. But I think, getting more lawyers to submit more frank commentaries to us would be helpful. The lawyers have, as you know, more of a longitudinal repeat view and more of an understanding of what's within the norm and can have some additional context. And so I'm very interested in trying to increase that sort of participation. So I'm especially appreciative of your leadership and the criminal defense bar's leadership on that point. So thank you.
And any bar association that wants to know how we do it, be happy to cooperate with them and show them how we do it and how it's worked for us in the past.
I appreciate that. Thank you, Mr. Chair.
Thank you, Representative. Other comments or questions? And for anyone who might be interested, I'm sure Attorney Gavin would make himself available outside of this forum. Thank you for joining us. Your help is always very much appreciated.
Thank you so much, Chairman.
Next we'll hear from Maureen Martowska.
Good afternoon, members of the Judiciary Committee. Since 2005, I have been before this committee many times as an advocate with the Connecticut Coalition for Family Court Reform. I am a retired Massachusetts attorney. I helped draft the first written and eventually adopted Connecticut Code of Conduct for GALs. Barry Armada was the primary GAL that inspired the need for this code. My son's case was pending in the Hartford Family Court with 18 different judges from 2005 through 2021, and it languished in the Hartford Family Court system for the entirety of my granddaughter's childhood. I am here because Barry Armada was the poster child for GAL abuses in the Hartford Family Court. In 2017, he narrowly squeaked by with a narrow 78-71 vote. I ask that you look at the 3 links that I've provided if you really truly want to do due diligence on the reason for the no confidence votes, almost half of the people voting for him. While I admittedly have not had the opportunity to observe Mr. Armada as a judge, I have had a 15-year prolonged ability to observe him in court as a GAL. His character defines him as a person, and I would describe that as manipulative. His actions, not words, defined him. For example, he stripped significant recommendations from a psych evaluator's recommendations, eliminating all holidays for the father without advising the court. He also abused requests for status conferences, falsely claiming that he needed to get before the court on an urgent basis, and that was simply to address getting his GAL fees addressed more expeditiously. Wrongly placed monies in IOLTA accounts and failed to properly timely return the monies, repeatedly demanding to sit in on depositions so that he would get paid for it rather than be able to just get a less costly alternative by getting the transcripts. His unwillingness to review and correct his own billing mistakes, stating that if he had to do it, he's going to get paid for it. Testifying in a hearing that a name change for a child would be to carry the father's name would be a badge of conflict. The judge totally disagreed with him. Repetitive non-responsiveness to counsel of record, such that delays for the therapeutic providers felt the case was experiencing substantial delays due to the GAL's non-responsiveness and not in the best interest of the child. Billing at private rates despite court-ordered state rates as a GAL. Keeping a child in supervised visitation absent abuse and neglect for approximately a year simply to make the mother feel more comfortable. And also not allowing Medicaid providers to provide pediatric therapeutic services that he recommended when private pay options were rejected by the mother. Barry Armada stated that the panel of Medicaid providers were inferior. That was his reason.
Your time has elapsed. If you could wrap it up, that would be.
Yes. The one thing I would say is I have a great deal of experience working with pro se litigants. Many in this state have come to me. And if you want some insight, I hope somebody will ask me regarding system accountability regarding the judges.
Okay.
Thank you.
Let's see. Are there comments or questions from members of the committee? Comments or questions? There are none, Ms. Martowska, so I would thank you for joining us today.
Okay.
We will have Darren Pruslow. Darren Pruslow. Is Darren Pruslow with us? If not, we will have Matthew Martowska. Is Matthew Martowska with us? If Matthew Martowska is not with us, we'll have Ian Gottlieb.
Good afternoon.
Good afternoon. You may proceed. You have 3 minutes.
Thank you. I'm here to speak on behalf of Judge Walter Spader and speak in favor of his reappointment. I've been appearing in front of Judge Spader since he's been on the bench, starting in Bridgeport Housing Court sometime around 2019, I believe it was. And I've been repeatedly in front of him since. In the past several years, he has actually done what a lot of judges haven't done in a particular area of housing, which is take an interest in it. We get judges that are new all the time, and by the time they get up to speed, they're gone, and we get new judges. And Judge Spader has been very instrumental in kind of consolidating a lot of what's been going on and getting a little bit of uniformity as to what we've been doing in housing. I can't necessarily speak to foreclosure since I'm not generally in that court, but I would like to, I did watch Judge Spader's testimony at the hearing, and everything he said I pretty much agree with. I've had losses in front of him. I've had wins in front of him. His temperament is spectacular. His running of a courtroom is fantastic, and he's fair with all the parties. And I think that that's something that is needed in housing court, especially given the fact that you have a lot of people that are facing those uncertainties of losing their homes. And it is difficult, and he handles it extremely well, and it makes it a lot easier for all the parties to understand what's going on. So I would like to share that. I would be happy to see him reappointed again and continue to be a judge for us in the state of Connecticut. Thank you.
Thank you. Are there comments or questions from members of the committee? Comments or questions from members of the committee? I do not see any. Mr. Gottlieb, thank you very much for joining us. Have a great afternoon.
Thank you. You too.
Michael Martowska. Mr. Martowska, you have your 3 minutes.
Hi, I'm Michael Matowska, and I'm here to speak against the reappointment of Judge Barry Armada. It is rare for a judge to not get reappointed for another term. The Honorable Barry Armada is someone I would always consider as less than honorable and unworthy of holding such an esteemed position. I pray that he fails to be reappointed. This can only happen if those who will make this decision do their due diligence and learn who Barry Armada truly is by not limiting themselves to listening only to what they are told today. Many people spoke against Barry Armada when he came before the Judiciary Committee the first time. This committee should listen to the testimony given that day. For your convenience, my wife, Maureen Matowska, has provided a link to that hearing and the hearing of the full legislature in the written testimony she submitted. There were enough issues raised then by my wife and many others that when it eventually came time for the full legislature to vote, the debate ran much longer than usual and major concerns were raised. Armada barely got through by a vote of 78 to 71. Thus, it would only have taken a switch in the vote of 4 legislators to have kept Barry Armada from being a judge today. That in itself says a lot about why it's imperative that you not rubber stamp his reappointment. In order to properly serve your constituents, you should dig further into his history before finalizing your decisions. The simple fact that 71 legislators voted against Armada should raise a red flag for you. Most appointees reaching this full legislative vote stage were unanimous or near unanimous votes. Barry Armada didn't, and rightfully so. This committee and the legislature in full now have a chance to revisit Armada's appointment. Please give this matter the attention it deserves. In so doing, I ask that you not just focus on his term as a judge over the last several years. In order to properly serve your constituents, you need to consider his character and history in its entirety. Some of the citizens of Connecticut, hurt by Armada in the past, spoke up during his first go-around with this committee. Having failed to prevent his judicial appointment then, will surely keep most from speaking up now. They know, as I do, that anything we say at this point is extremely unlikely to change the outcome. They feel Barry Armada will get reappointed regardless of any testimony against such that is provided. Adding insult to injury, they also know Armada will be able to qualify for a judge's pension during a second term as a judge. However, what's more important is that the citizens of Connecticut deserve to have the best candidates appointed as judges, not people like Armada who are good at playing the system to build a name for themselves. I prepared this testimony before hearing what Barry Armada would say today. However, the thought of him testifying reminded me of the saying of some lawyers that you can't prove a lie. Barry Armada is a smooth talker, and whether he is outright lying or simply spinning a point, he will sound truthful. I've seen that firsthand in my son's situation where he served as a GAL, how Armada would distort or obscure the truth when speaking to a judge. He would even lie to my son about what he would say in court in order to pressure him into doing his bidding. My point is that you should take any testimony from him with a grain of salt. He is quite the salesman. There will be no knowledgeable lawyer cross-examining him that has a necessary detailed background in hand to do a proper cross-examination. My wife's testimony provides more detail on our family's experience with Barry Armada. It will explain why we were against his appointment as a judge then and why we still feel that way. I feel like Don Quixote fighting windmills, that what I do today will have no impact. However, I wouldn't be able to look myself in the mirror if I didn't at least do.
Mr. Martowska, your time has elapsed. If you could summarize, that would be helpful. Mr. Martowska, you're on mute.
I do realize that Barry Armada was appointed in the criminal court initially. And I thought that was.
Mr. Martowska, I asked you to summarize, not just continue. Can you wrap it up?
Yeah, I'm just, all I can do is beg you guys to really, like I say, I feel he doesn't belong there in the role of a judge at all, despite the good things I heard about him by different people today. You know, when I first work, I'm summarizing, when I first saw that he was transferred to family court,
hold on.
I didn't think he belonged there. I begged that he not be reappointed.
Martowska, I'm going to ask you to listen for a second. I know that people have some really important things to say. I am not going to treat people differently because then we'll have a different issue. So I have to stop you. Let me check with the committee to see if there are questions. Are there questions or comments from members of the committee? Representative Fishbone.
Good afternoon, sir. I read your written testimony and I couldn't find any specifics in there. I did look in the judicial website and it appears that there was a case way back in 2005 before, because Judge Armada was first appointed in 2017. Is that the case that you're talking about, your family's involvement with Judge Armada?
I'm sorry, were you speaking with me? I think you spoke to somebody else.
The question is to you, Mr. Martowska.
I'm sorry, could you repeat the question? I didn't catch it all.
Sure, I'm trying to, I read your written testimony and I appreciate that, but I couldn't really find any specific allegations or something in particular that you're claiming that Judge Armada did. I did look in the judicial website and it appears that there was a case back in 2005 that perhaps involved your family, that maybe Judge Armada was a GAL in that case. That was long before he got appointed to be a judge. Is that the case that you're talking about?
Yes, that's one of my 8 beloved grandchildren, and I feel as a result of the role that Armada, who was my son's JL at the time, played a significant role in keeping her alienated to this day. As a simple example, even in the very beginning of his role as a JAL, one of the things we tried to do was, it wasn't the wife, I mean, the mother that filed in court, it was my son. He wanted to start paying child support. He wanted to have the court guarantee him his access. And ultimately, he was awarded joint custody. At the same time, knowing what should be done, he prepared a draft parenting plan. Barry Armada would not give input on it, would not push it, would not do anything. He would not ask the mother to do anything. After spending thousands of dollars in court just to get a parenting plan from the judge after days in court, it was effectively word for word what my son had proposed in the first place. Why didn't he work with, as a lack of a better description, as a mediator or working the best interest of the child to get things done?
Mr. Martowska, I'm going to ask you to allow Representative Fishbone to ask a follow-up. He's attempted twice to pose another follow-up.
Yeah, thank you, Mr. Chairman, because sir, I guess the answer to the question was yes. So I'm just trying to ascertain, when was Barry Armada, or now Judge Armada, last involved with your family? What year?
He was a JAL, and to the point that he was nominated as a judge, which I believe was 2017. But even then, we were still involved with him, trying to get the money back that was supposed to be in an IOTA account that he wasn't giving back to us. He had his firm clean it up before the appointment took effect.
Okay, thank you, thank you. Thank you for that information, and thank you, Mr. Chairman.
Thank you, Representative Fishbein. Are there comments or questions from other members of the committee? Seeing none, Mr. Martellus, thank you very much for joining us today to provide your testimony. Next, we have Peter Sismonic.
Yes. Good afternoon, members of the committee. My name is Peter Shimonik, and I'm from Glastonbury, Connecticut. And as Senator Winfield once mentioned very affectionately, I'm a frequent flyer in these testimonies, in these committee meetings. I'm here this afternoon to testify against the appointment of Judge Clatt and Judge Murphy. And from a rhetorical perspective, the question I have is, how should this committee respond when it's presented with evidence and testimony that a judge ignores and violates fundamental rights, due process, and the rule of law, and that judge violates state and federal laws and suppresses evidence to cover up fraud, perjury, and plain error? And what do we do when we have a judge that erases the existence of children, these children, for child support calculation purposes, and then obstructs justice by preventing correction of this plain and obvious error? What do we do when we have a judge who intercepts and throws motions that are faxed to the court into the trash, rather than offering fair and impartial hearing, because those motions dare to cite fundamental rights in state and federal law? What do we do when we have a judge that blocks all access to the public courts, not only to a pro se litigant, but to my attorneys, and then sanctions me thousands of dollars for the crime of daring to fax motions to the court, which is a First Amendment right? What do we do when we have a judge that denies critical pretrial motions when those motions are not even before her because they haven't even been filed by the court clerk's office yet, because these motions cite fundamental rights in the state and federal law? Should these judges, who act like tyrants and as if rights and laws do not apply to them, be rewarded by being reappointed by this committee for another 8 years and $1 million plus each? What I just described is what Judge Karin Clark and Judge Margaret Murphy engaged in my case, which cost me and my family of disabilities over $100,000. With the Office of Attorney General William Tong, a constitutional office, looking the other way at these flagrant violations of rights and law. To the Democrats on this committee, if any of you are dismayed, disgusted, or horrified that we now have a sitting president who violates the rule of law and attacks the Constitution, yet you look at the other way when family court judges do this exact same thing in our state, you have no possibility to hold any moral high ground to complain. And in the final seconds that I have, well, I'd like to have a little bit of fun. I'd like all of you to be the judges in this case. This is the child support order, child support calculations worksheet from 2017 entered by the court. You'll notice in the section where it says qualifying children, who are these children, the number is 0. The number should have been 1. In 2019, when Judge Clatt had the same issue before her, that number was 2. She prevented and obstructed all possibility of correcting this error. And that's why it cost my family over $100,000. Since 2017 till last year, this state has been collecting the wrong amount for child support from me, garnishing my wages for the wrong amount, without offering me or my attorneys any possibility to access the public court system to correct this error. Thank you.
Thank you, and thank you for coming back again. Are there comments or questions from members of the committee? Are there comments or questions? There are none. I want to thank you for joining us again and have a good afternoon.
Thank you, Senator Winfield.
At this point, we have reached the end of the list of folks signed up to testify. We have reached the end of the list of the folks signed up to testify. I recognize that there is someone in the room who would like to speak. We don't do that because people often do that and it takes, but whenever we finish, I will listen to you and what you have to say. All right, so with that, I believe we are at the end of this hearing. So we are going to call this hearing to an end and
Sir, the public hearing has been declared closed. The public hearing is now closed. We are going to convene our committee meeting for January 22nd, 2005, so we don't run afoul of anything. Yes, January 22nd, 2025, whatever year we're in. We are now going to recess the committee meeting. The Republicans are going to caucus in 2B and the Democrats are going to caucus in 2A. We stand in recess for caucus. All right, good afternoon, good evening. Welcome back. We'd like to reconvene the Judiciary Committee meeting. Remarks from my chair or co-chairs or ranking members, anybody? Okay, let's dive right in. Section 3 of our agenda, nominations for review. I will entertain a motion to favorably report on the governor's nomination of the Honorable Raheem L. Mullins of Farmington to be the
Second.
Chief Justice of the Supreme Court and a Judge of the Superior Court. I have a motion from Senator Winfield. I have a second from Senator Kissel. Is there discussion on this nomination? Is there discussion? I'll just note, obviously, we did have a lengthy public hearing and discussion on this 3 months ago. This is for a permanent 8-year term. Hearing nothing, Madam Administrator, please call the roll.
Roll call vote on the nomination before us, the Honorable Raheem Mullins of Farmington to be the Chief Justice of the Supreme Court and a Judge of the Superior Court. Winfield. Staffstrom.
Yes.
Flexer. Gadkar Wilcox. Fazino.
Yes.
Thank you. Fazino.
Yes.
Kissel.
Yes.
Fishbein.
Yes.
Blumenthal.
Yeah.
Brown. Cabrera.
Yes.
Callahan.
Yes.
Chicarella. DiCaprio.
Yes.
Delaney.
Yes.
Dillon.
Dylan, yes.
Doucette. Dubitsky.
Doucette, yes.
Thank you. Dubitsky. Elliott. Gaston.
Yes.
Godfrey.
Yeah.
Howard. Jacobson.
Yes.
Johnson.
Yes.
Khan. Lamarck Muir.
Yes.
Lesser. Mar.
Mars, yes.
Miller. O'Day.
Yes.
Osborne. Pavlik D'Amato.
Pavlik D'Amato votes yes.
Quinn.
Yes.
Rahman. Roberts.
Yes.
Retigliano.
Yes.
Sampson.
Sampson is no.
Sims. Veach.
Yes.
Walker.
Yes.
Wilson.
Wilson votes yes.
Thank you.
All right, we will hold the votes open.
Dubitsky votes yes. Thank you.
We will hold the votes.
Madam Clerk, I'm sorry, Mr. Chair, this is Senator Miller.
Yes,
Senator
Senator.
Miller, Senator Miller votes yes.
Thank you.
All right, I was just gonna say, we're gonna hold the votes open until 6 o'clock, so if folks miss their names in the roll call, you'll have a chance to vote at the end, at the conclusion, all right? All right, next, we'll move on to our list of Superior Court nominees. I will entertain a motion to favorably report on the governor's nomination of the Honorable Barry F. Armada of Suffield to be a judge of the Superior Court.
Second.
Motion from Senator Kissel, second from Representative Fishbein. I will note for the record that Representative Pavlik D'Amato needs to recuse herself. Is there discussion? Is there discussion? Hearing none. Madam Administrator, please call the roll.
Roll call vote on the Honorable Barry F. Armada of Suffield to be a Superior Court Judge. Winfield.
Any affirmative?
Staffstrom.
Yes.
Flexer. Gadkar Wilcox.
Yes.
Fazino.
Yes.
Kissel.
Yes.
Fishbein.
Yes.
Blumenthal.
Yes.
Brown. Cabrera.
Yes.
Callahan.
Yes.
Chicarella. DiCaprio.
Yes.
Delaney.
Delaney, yes.
Dillon.
Dylan, yes.
Doucette. Dubitsky.
Yes.
Elliott. Gaston.
Yes.
Godfrey. Howard. Jacobson. Johnson.
Yes.
Khan. Lamarck Muir.
Yes.
Lesser. Mar.
Mar, yes.
Miller, yes.
O'Day. Osborne. Quinn.
Yes.
Rahman. Roberts.
Yes.
Retigliano. Sampson.
Sampson's yes.
Sims. Veach,
did yes.
thank you. Veach,
Yes.
Walker,
Yes.
Wilson.
Wilson is a yes.
Moving on, I will entertain a motion to favorably report on the governor's nomination of the Honorable Elizabeth A. Bozzuto of Watertown to be a judge at the Superior Court. Motion from Senator Kissel, second from Senator Winfield. Discussion on this nomination. Seeing none, Madam Administrator, please call the roll.
Roll call vote on the Honorable Elizabeth A. Bozzuto of Watertown, Winfield,
Winfield, any affirmative?
Staffstrom,
Yes.
Plexer, Gadkar Wilcox,
Yes.
Fazino,
Yes.
Kissel,
Yes.
Fishbein,
Yes.
Blumenthal,
Yes.
Brown, Cabrera,
Yes.
Callahan,
Yes.
Chicarella, DiCaprio,
Yes.
Delaney,
Delaney, yes.
Dillon,
Dillon, yes.
Doucette,
Doucette, yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Godfrey, Howard, Jacobson, Johnson,
Yes.
Khan, Lamarck Muir,
Yes.
Lesser, Marr,
Yes.
Miller,
Yes.
O'Day, Osborne,
Yes.
Havelock Tomato,
Havelock Tomato votes yes.
Quinn, Rahman, Roberts,
Yes.
Vertigliano, Sampson,
Sampson is yes.
Sims,
Sims in the affirmative.
Veach,
Veach votes yes.
Walker,
Walker votes yes.
Wilson.
Wilson votes yes.
Next, I'll entertain a motion to favorably report on the governor's nomination of the Honorable Matthew J. Budzik of West Simsbury to be a judge of the Superior Court.
Second.
Motion from Senator Kissel, second from Senator Winfield. Discussion on this nomination. If not, Representative Fishbein for motion, please.
Mr. Chairman, I make a motion that we can create a consent calendar and that we move the nomination of the Honorable Matthew J. Budzik to said consent calendar.
So
So moved.
objection, hearing none, consent calendar is created and the nomination is placed on it. Next, I'll entertain a motion to favorably report on the governor's nomination of the Honorable John L. Cordani of Wolcott to be a judge of the Superior Court.
So moved.
Second.
Motion from Senator Winfield, second from Representative Fishbein. Is there discussion on this nomination? Is there discussion? Seeing none, Representative Fishbein?
Mr. Chairman, I make a motion that we move the nomination of the Honorable John L. Cordani to the consent calendar.
Is there objection? Hearing none, so ordered. Next, I'll entertain a motion to favorably report on the governor's nomination of the Honorable Matthew D. Gordon of West Hartford to be a judge of the Superior Court.
Second.
Motion from Senator Winfield, second from Representative Fishbein. Discussion, hearing none. Rep. Fishbein?
Mr. Chairman, I make a motion that we move the nomination of the Honorable Matthew D. Gordon to the consent calendar.
Hearing no objection, so ordered. Next, I'll entertain a motion to favorably report on the governor's nomination of the Honorable Ernest Green Jr. of Norwich to be a judge of the Superior Court. Motion from Senator Winfield, second from Senator Kissel. Discussion. Yes, Representative Howard.
Mr. Chairman, on this nominee as well as Judge Sherie Murphy further down on the agenda, I in the interest of time today, I didn't say this to both of them, but I want the record to reflect that my time in my full-time job had opportunity to work with both of them in their time in criminal courts in New London. They are held in high regard by law enforcement, criminal courts, public defenders, all the defense attorneys and prosecutors. Both of them are on my short list of favorite judges, and I just want the record to reflect that. In the interest of time, I'll say it about Judge Murphy at this time. Thank you.
Thank you. Further discussion? If not, Rep. Fishbein?
Mr. Chairman, I make a motion that we move the nomination of the Honorable Matthew D. Gordon to the consent calendar.
Is there objection to placing this nomination on consent? Hearing none, so ordered.
Excuse me.
That was Green.
Yeah, I just want to clarify. I was checking my notes. Let's try that again, Representative Fishbein.
Mr. Chairman, I make a motion we move the nomination of the Honorable Ernest Green Jr. to the consent calendar.
Okay, so we are placing the nomination of Judge Green on the consent calendar. Is there objection to that? Is there objection? Okay, then that is so ordered. So for the record, our consent calendar currently consists of the nominations of Judge Budzik, Cordani, Gordon, and Green. We'll move on our agenda, and I will entertain a motion of favorable report on the governor's nomination of the Honorable Karin Clatt of Meriden to be a judge of the Superior Court. Motion from Senator Winfield, second from Senator Kissel. Is there discussion on this nomination? Is there discussion? Hearing none, Rep. Fishbein?
Mr. Chairman, I make a motion, we move the nomination of the Honorable Karin Clatt to the consent calendar.
Is there objection to placing this nomination on consent? Hearing none, so order. Next, I'll entertain a motion of favorable report on the governor's nomination of the Honorable Kimberly A. Clark of West Hartford to be a judge of the Superior Court. Kimberly A. Knox of West Hartford to be a judge of the Superior Court.
Second.
Motion from Senator Winfield, second from Senator Kissel. My apologies. It's been a lengthy day. And I will note for the record that Representative Fishbein is recusing himself from consideration on this nomination. Is there discussion? Hearing none. Madam Administrator, please call the roll.
Roll call vote on the Honorable Kimberly A. Knox of West Hartford. Winfield,
Any affirmative?
Staffstrom,
Yes.
Flexer, Gadkar Wilcox, Pizzino, Kissel,
Yeah.
Blumenthal, Brown, Cabrera,
Yes.
Callahan,
Yes.
Ciccarella, DiCaprio,
Yes.
Delaney,
Delaney, yes.
Dillon.
Dillon, yes.
Thank you. Doucette,
Said yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Godfrey, Howard,
Yes.
Jacobson, Johnson,
Yes.
Khan, Lamarck Muir,
Yes.
Lesser, Mar,
Yes.
Miller,
Miller, yes.
O'Day, Osborne, Havelock D'Amato,
Havelock D'Amato votes yes.
Quinn,
Yes.
Rahman, Roberts,
Roberts, yes.
Retigliano, Sampson,
Sampson is yes.
Sims,
Sims in the affirmative.
Veach,
Beach is yes.
Walker,
Yes.
Wilson.
Wilson's yes.
Thank you. I'll entertain a motion to favorably report on the governor's nomination of the Honorable Margaret M. Murphy of West Hartford to be a judge of the Superior Court.
Move. Second.
Motion from Senator Winfield, second from Senator Kissel. Discussion. Hearing none. Rep. Fishbein?
Mr. Chairman, I make a motion, we move the nomination of the Honorable Margaret M. Murphy to the consent calendar.
So objection placing this item on consent. Hearing none, so ordered. Next, I'll entertain a motion of favorable report on the governor's nomination of the Honorable Sherie A. Murphy of North Branford to be a judge of the Superior Court.
Move. Second.
Motion from Senator Winfield. I'll get a second from Representative Howard. Is there discussion on this nomination? Is there discussion? Representative Fishbein?
Mr. Chairman, I make a motion, we move the nomination of the Honorable Sherie A. Murphy to the consent calendar.
Is there objection? Hearing none, that is so ordered. Next, I'll entertain a motion of favorable report on the governor's nomination of the Honorable Tammy Wynn O'Dowd of Bloomfield to be a judge of the Superior Court.
So move. Second.
Motion from Senator Winfield, second from Senator Kissel. Is there discussion on this nomination? Representative Fishbein for
Mr.
motion.
Chairman, I make a motion that we move the nomination of the Honorable Tammy T. Wynn O'Dowd to the consent calendar.
Is there objection? Is there objection? Hearing none, that's so ordered. Next, I will entertain a motion to favorable report on the governor's nomination, the Honorable Sheila A. Ozalis of Newtown to be a judge of the Superior Court.
So move. Second.
Motion from Senator Winfield, second from Senator Kissel. I will note for the record that Representative Jacobson is going to recuse himself. Is there discussion? Hearing none, Madam Administrator, please call the roll.
A roll call vote on the Honorable Sheila A. Ozalis of Newtown. Winfield,
Winfield, any affirmative?
Staffstrom,
Yes.
Flexer, Gadkar Wilcox, Pizzino, Kissel,
Yes.
Fishbein,
Yes.
Blumenthal, Brown, Cabrera,
Yes.
Callahan.
Yes.
Chicarella. DiCaprio.
Yes.
Delaney.
Delaney, yes.
Dillon.
Dillon, yes.
Doucette.
Doucette, yes.
Rubitsky.
Yes.
Elliott. Gaston.
Yes.
Thank you. Godfrey. Howard. Jacobson. I'm sorry. Johnson.
Yes.
Khan. Lamarck Muir.
Yes.
Lesser. Mar.
Yes.
Miller.
Miller, yes.
O'Day. Osborne.
Yes.
Pavlock Tomato.
Pavlock Tomato votes yes.
Quinn.
Yes.
Rahman. Roberts.
Roberts, yes.
Bertigliano. Sampson.
Sampson is yes.
Sims.
Sims in the affirmative.
Beach.
Beach is yes.
Walker. Wilson.
Walker, yes.
Thank you. Wilson.
Wilson is yes.
Thank you.
Next, I will entertain a motion to favorably report on the governor's nomination of the Honorable W. Glenn Pearson of Hamden to be a judge of the Superior Court. Motion from Senator Winfield, second from Senator Kissel. Discussion, hearing none. Representative Fishbein.
Mr. Chairman, I make a motion that we move the nomination of the Honorable W. Glenn Pearson to the consent calendar.
Objection to placing this item on consent? If not, so ordered. Next, I'll entertain a motion to favor report on the governor's nomination of the Honorable Walter M. Spader Jr. of North Haven to be a judge of the Superior Court. Motion from Senator Winfield, second from Senator Kissel. I will note for the record that Representative Pavlock Tomato is recusing herself. Is there discussion? Hearing none, Madam Administrator, please call the roll.
A roll call vote on the Honorable Walter M. Spader Jr. of North Haven. Winfield.
Winfield, in the affirmative.
Staffstrom.
Yes.
Flexer. Gadkar Wilcox. Pizzino. Kissel.
Yes.
Fishbein.
Yes.
Blumenthal. Brown. Cabrera.
Yes.
Callahan.
Yes.
Chicarella. DiCaprio.
Yes.
Delaney.
Delaney, yes.
Dillon.
Dillon, yes.
Doucette.
Doucette, yes.
Rubitsky.
Yes.
Elliott. Gaston. Godfrey. Howard.
Yes.
Jacobson. Johnson.
Yes.
Khan. Lamarck Muir.
Yes.
Lesser. Mar.
Yes.
Miller.
Miller, yes.
O'Day. Osborne. Quinn. Rahman. Roberts.
Roberts, yes.
Bertigliano. Sampson.
Sampson's yes.
Sims.
Sims in the affirmative.
Beach.
Beach is a yes.
Walker.
Walker, yes.
Wilson.
Wilson's yes.
Thank you. I'll entertain a motion to favor report on the governor's nomination of the Honorable Elizabeth J. Stewart of Hamden to be a judge at Superior Court. Motion from Senator Winfield, second from Senator Kissel. Discussion on the nomination. If not, Representative Fishbein.
Mr. Chair, I make a motion we move the nomination of the Honorable Elizabeth J. Stewart to the consent calendar.
Is there objection to placing the item on consent? If not, that is so ordered. We're going to jump to the governor's nomination of the Honorable Thomas J. Welch of Shelton to be a judge of the Superior Court. Motion from Senator Kissel, second from Representative O'Day. Is there discussion on this nomination? I should note for the record that Representative Jacobson is recusing himself. So now that he's recused and is walking out of the room, is there discussion on this nomination? Is there discussion? Hearing none, Madam Administrator, please call the roll.
Roll call vote on the Honorable Thomas J. Welch of Shelton. Winfield.
Field, in the affirmative.
Staffstrom.
Yes.
Flexer. Gadkar Wilcox. Pizzino.
Yes.
Kissel.
Yes.
Fishbein.
Yes.
Blumenthal.
Yes.
Brown. Cabrera. Callahan.
Yes.
Chicarella. DiCaprio.
Yes.
Delaney.
Delaney, yes.
Dillon.
Dillon, yes.
Doucette.
Doucette, yes.
Budzik,
Yes.
Elliott, Gaston, Godfrey, Howard,
Yes.
Johnson,
Yes.
Khan, Lamarck Muir,
Yes.
Lesser, Mar,
Yes.
Miller,
Miller, yes.
O'Day, Osborne, Pavlock Tomato,
Pavlock Tomato votes yes.
Quinn, Rahman, Roberts,
Roberts, yes.
Retigliano, Sampson,
Sampson is yes.
Sims,
Sims in the affirmative.
Beach,
Beach is a yes.
Walker, Wilson,
Wilson is a
Sorry. Walker is a yes. Thank you.
Wilson,
Wilson's a yes.
thank you.
All right, we are going to return to item 3, which was the nomination of the Honorable Matthew J. Budzik of West Simsbury. We are going to remove that item from the consent calendar. So we are removing item 3, the nomination of the Honorable Matthew J. Budzik of West Simsbury from the consent calendar. I would like a motion to approve that nomination in a second.
So moved. Second.
Okay, so now we have a motion to approve from Senator Winfield and a second from Senator Kissel. I will note for the record that Representative Dubitsky is going to recuse himself on that nomination. And unless there's further discussion, Madam Administrator, you can call the roll on that nomination.
Roll call vote on the Honorable Matthew J. Budzik of West Simsbury. Winfield,
Winfield, in the affirmative.
Staffstrom,
Yes.
Flexer, Gadkar Wilcox, Pazino, Kissel,
Yes.
Fishbein,
Yes.
Blumenthal, Brown, Cabrera,
Yes.
Callahan, Chicarella,
Yes.
DiCaprio,
Yes.
Delaney,
Delaney, yes.
Dillon,
Dylan, yes.
Doucette,
You said yes.
Elliott, Gaston, Godfrey, Howard,
Yes.
Jacobson, Johnson,
Yes.
Khan, Lamarck Muir,
Yes.
Lesser,
Yes.
Mar,
Yes.
Miller,
Miller, yes.
O'Day, Osborne, Pavlock Tomato,
Pavlock Tomato votes yes.
Quinn, Rahman, Roberts,
Yes. Roberts, yes.
Retigliano, Sampson,
Sampson is yes.
Sims,
Sims in the affirmative.
Leach,
Beach is a yes.
Walker,
Walker, yes.
Wilson.
Wilson is yes.
All right, with that, Madam Administrator, if you could please read the consent calendar.
The consent calendar consists of to be a judge of the Superior Court, the Honorable John L. Cordani of Wolcott, the Honorable Matthew D. Gordon of West Hartford, the Honorable Ernest Green Jr. of Norwich, the Honorable Karin L. Clatt of Meriden, the Honorable Margaret M. Murphy of West Hartford, the Honorable Sherie A. Murphy of North Branford, the Honorable Tammy N. Winnow Dowd of Bloomfield, the Honorable W. Glenn Pearson of Hamden, and the Honorable Elizabeth J. Stewart of Hamden.
All right, with that, Madam Administrator, you may call the roll on the consent calendar.
Winfield, Staffstrom, Flexer, Gadkar Wilcox, Pazino, Kissel,
Yes.
Fishbein,
Yes.
Blumenthal, Brown, Cabrera,
Cabrera's yes.
Callahan,
Yes.
Chicarella, DiCaprio, Delaney,
Delaney, yes.
Dillon,
Dylan, yes.
Doucette,
You said yes.
Dubitsky,
Yes.
Elliott, Gaston, Senator Gaston.
Yes. I don't know if you heard me this time and the last time, but yes.
Thank you so much. Godfrey, Howard,
Yes.
Jacobson, Johnson,
Yes.
Khan, Lamarck Muir,
Yes.
Lesser, Mar,
Yes.
Miller,
Miller, yes.
O'Day. Osborne. Pavlock D'Amato.
D'Amato votes yes.
Thank you. Quinn.
Yes.
Rahman.
Yes.
Roberts.
Roberts, yes.
Retigliano. Sampson.
Sorry, Sampson, yes.
Sims.
Tim's in the affirmative.
Veach.
Beach, yes.
Walker.
Yes.
Wilson.
Wilson is yes.
All right, moving on to section 4 of our agenda. Concepts to raise as bills or resolution. I will remind members that in this committee, we do all of our action by raising concepts. We generally do not take up proposed bills, and we do not do public hearings on sort of half bills or shell bills or whatever you want to call them. We do public hearings on fully drafted bills. So what we have before us is a list of concepts by which we are going to work to draft bills, which will then be turned into material for a public hearing. A vote in favor of these concepts is not a vote in favor of the ultimate subject matter or language of those bills. It is simply to allow us to have our LCO attorneys draft the language so that we can then talk about it at a subsequent public hearing. So with that, I will entertain a motion to raise concepts 1 through 44 as bills or resolutions. So I have a motion from Senator Winfield and a second from Senator Kissel. Is there discussion on the motion? Is there discussion? Hearing none, let me try your minds. All those in favor of raising concepts 1 through 44, please indicate by saying aye.
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 Those opposed say nay. The ayes have it, and those concepts are raised. Moving on to item number 5. Here we have a list of 8 resolutions from the Claims Commissioner. Again, the motion here is to allow us to raise those resolutions for a public hearing to be scheduled. So I will entertain a motion to raise resolutions 1 through 8 on section 5 of our agenda, wrongful incarceration awards to be reviewed. Motion from Senator Winfield, second from Senator Kissel. Is there discussion on this? Is there discussion? Hearing none. Let me try your minds. All those in favor, please signify by saying aye.
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 Nay, the ayes have it. Number 6 on our agenda. Here you will see a list of 39 claims for which review has been requested in connection with a dismissal or denial by the Claims Commissioner. Again, this is just to raise these to allow us to do a public hearing and allow folks to have their opportunity to present their case to us as to why they believe the Claims Commissioner improperly denied or dismissed their claim. Is there a motion to raise items 1 through 39?
So moved. Second.
Motion from Senator Winfield, second from Senator Kissel. Discussion. Senator Kissel first.
Thank you very much, Mr. Chairman. I know time is fleeting right now. I just want to say Commissioner Shea and his team have done an outstanding job. I have seen huge progress since he's taken the helm, and that is just good news for justice being meted out here in the state of Connecticut. I want to commend Commissioner Shea and his team, and I look forward to hearing these matters going forward. Thank you, Mr. Chairman.
Thank you. Representative Fishbein?
Thank you, Mr. Chairman. Similarly, I want to commend Commissioner Shea, just to put the numbers into perspective. We have 39 matters for review this session, and I believe we had 75 last session. And not to, the next item we're going to have is extensions, and just to put that into perspective, we have 3 extensions this year, and last year we had 300 extensions. So Bobby Shea, God bless you, and thank you very much for everything you're doing for not only for us, but for the state of Connecticut in your role as the Commissioner of Claims. So thank you, Mr. Chairman.
Amen, Representative. It must be all that Jesuit education paying off over there. So Further discussion, hearing none. Let me try your minds. Oh, Representative Dubitsky, sorry.
Thank you, Mr. Chairman. I just wanted to indicate that I need to recuse on number 30 and 31.
All right, so 30 and 31. So what we will do is let me withdraw the motion. Senator Winfield, do you withdraw your motion? Okay. All right, so we withdraw the motion in the second. So let's change. The motion is going to be a voice vote, hopefully a voice vote, but the motion will be, can I have a motion to raise for review denials or dismissals on section 6 of our agendas, numbers 1 through 29 and numbers 32 through 39.
So moved.
Motion from Senator Winfield, second from Senator Kissel. We will note the comments have been previously made in the record, and I will ask, and I will note, and actually on that one, I don't need to note anything. So on that, a voice vote. All those in favor, please signify by saying aye.
Aye.
All those opposed, nay. The ayes have it. Now, I will entertain a motion to raise for review claims requested in connection with a dismissal or denial numbers 30 and 31. Is there a motion?
So moved. Second.
Motion from Senator Winfield, second from Senator Kissel. I'll note for the record that Representative Dubitsky is recusing himself from discussion on this. We're voting. Is there discussion? Other than that, hearing none, we will entertain a voice vote. All those in favor, please signify, please indicate by saying aye.
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 All opposed, nay. The ayes have it. Section 7 of our agenda, claims requests for extension of time for adjudication pursuant to Connecticut General Statute 4-159A. We have 3 of those. Is there a motion to raise those?
So moved. Second.
Motion from Senator Winfield, second from Senator Kissel. Discussion other than what's been previously noted. If not, let me try your minds. All those in favor, please signify by saying aye.
Aye.
Opposed, nay. The ayes have it. Those are raised. Next meeting will be Friday, same time, same place. Although I do believe we've noticed this meeting for 10. Although I think we may get started a little bit later on Monday. We will gavel in at 10, but we may, sorry, Friday. So Friday. We will gavel in at 10 on Friday, but we actually don't anticipate testimony taking our first nominee until 10:30. All right. So just so folks are aware, we will gavel in at the scheduled time of 10, but we won't take action until closer to 10:30 or begin action until closer to 10:30. All right. With that, we stand in recess until let's make sure we leave enough time. Let's say we stand in recess until 6:15 for members to get votes in. All right. Have a good night, everybody.
Mr. Clerk, Madam Clerk.
Sorry about that. Can you hear me okay?
I can hear you.
Okay, excellent. All right, so.
Quick question.
Yep.
Sorry to interrupt you. This is Senator George Cabrera. I voted yes on a bunch of items. My camera was off. I forgot to turn it back on. We need to re-vote those votes, or am I good?
No, I think you're okay.
Thank you very much.
Madam Clerk, just real quickly, I think my volume was off on one of the votes. I just want to make sure that you captured that for me.
Real quick, let me go through it. I have you as a yes on the consent calendar. And then I have you as a yes for Mullins. Armada, I have you as a yes. Bozzuto.
I want to make sure I wasn't missing any.
You repeated, thankfully. Consent. Yeah, you're all set.
Thank you so much. Take care.
Thank you. Take care.
Kirsten?
Yes.
Hi. I think I just missed one. Judge Armada, I think, is driving.
Yeah, I missed you for Armada. How would you like to vote?
Two set votes, yes.
Okay, well, hang on, let me just make sure I don't. Yeah, you're got you for everything else. Thank you.
Thank you. Have a good night.
You too.
Have a good night, you guys.
Hi.
Yes.
I don't know if Senator Rahman is, I just wanted to,
That's okay. Go ahead.
I want to make sure I missed a couple of the votes. I just wanted to vote yes on them all the way down.
All right, the consent calendar. How would you like to vote?
Yes.
Yes. Okay. I'm going to mark you.
Yes, thank you.
For Mullins, I've got you. I've got you for Armada. Just want to make sure. So remember, yes for Knox.
Yes, yep, just yes.
Okay, you're all set.
Great. Thank you very much.
Thank you so much.
All right, Senator Rahman here. I think I missed a couple of votes.
Yes, okay, Senator, can I have you for the consent calendar?
Okay, yes.
Oh, I've got you, yes, for that one.
Yeah,
For Mullins, how would you like to vote?
yes,
For Armada, how would you like to vote?
yes,
For Bozzuto, how would you like to vote?
yes,
For Knox, how would you like to vote?
yes,
For Ozalis, how would you like to vote?
yes. As long my chair voted yes, yes, yeah.
Spader as well?
Yes, yes,
Okay, and then we have Welch. Yes,
yes.
okay, Representative Khan?
Hi.
How are you?
Good. How are you?
Good, good. Okay, so for the consent calendar, how would you like to vote?
Yes.
Okay. For Mullins,
Yes. For Armada?
Yes. Bozzuto?
Yes.
Knox?
just didn't know if I missed. Yes.
Ozalis?
Yes.
Ozalis? Spader?
Yes.
Welch?
Yes.
And Budzik?
Yes.
Okay, you're all set. Thank you so much.
Thank you.
Okay. Senator Flexer?
Hello,
How are you?
I'm okay. How are you?
I'm good. Okay, so for the consent calendar.
Yes, Senator Fletcher votes yes.
Okay, for Mullins, Mullins?
Yes.
Okay. For Armada,
Yes.
Bozzuto,
No.
Knox,
Yes.
Ozalis?
Yes.
Spader,
Yes.
Welch,
Yes.
and Budzik.
Yes.
Okay, excellent. And I think that's everything else. Everything else is voice.
Great.
Okay.
Thank you very much. Have a
Thank you
great
so much. Have a
night.
good one. You too.
Bye-bye.
Can you hear me okay?
Yes.
Oh, there you go. Okay, how would you like to vote on the consent calendar?
Yes.
Okay. On Mullins,
Yes.
Armada,
Yes.
Bozzuto,
Yes.
Knox,
Yes.
Ozalis,
Yes.
Spader,
Yes.
Welch,
Yes.
Budzik.
Can I just say yes for all of them, or we got to do one
It's
by
the
one?
last one.
Sorry. Yes.
Appreciate it. Thank you so much.
No problem. Thank you so
Have a
much.
good night. Yeah.
You too. Bye.
Hi, Representative.
Hello, Madam Secretary. How are you?
Good, good. Thank you for jumping back on. For Mullins, how would you like to vote?
I would like to vote in the affirmative.
Okay, great. And I believe that's the only one that I'm missing for you.
I didn't call you Madam Secretary, did I?
Yeah, that's okay. No worries.
I meant to say Madam Clerk.
You're all set. That's perfect. You're all good. Thank you so
All
much.
right, wonderful.
Have a good
Thank
night.
you. Appreciate
Yep.
it. You too. Bye-bye.